This meeting of the Judiciary Committee will come to order. We are marking up today 7 resolutions of inquiry. Do I have to read all the names? Okay. A quorum being present, without objection, the chair is authorized to declare recess at any time. Pursuant to Rule 2 and House Rule 11, Clause 2, the chair may postpone further proceedings today on the question of approving any measure or matter or adopting an amendment for which a recorded vote for the ayes and nays are ordered. I'd like to remind members that we have established an email address and distribution list dedicated to circulating amendments, exhibits, motions, or other written materials that members might want to offer as part of our markup today. If you would like to submit materials, please send them to the email address that has been previously distributed to your offices, and we will circulate the materials to members and staff as quickly as possible. I would also ask all members, both those in person and those appearing remotely, to mute your microphones when you are not speaking. This will help prevent feedback and other technical issues. You may unmute yourself anytime you seek recognition. Pursuant to notice, I now call up H.Res. 1325, a resolution of inquiry requesting the President and directing Attorney General Merrick Garland to transmit, respectively, a copy of the affidavit to the House of Representatives related to the raid on the former President for purposes of markup, and move that the committee report the resolution unfavorably to the House. The clerk will report.
H.Res. 1325 of inquiry requesting the President and directing Attorney General Merrick B. Garland.
Without objection, the resolution is considered as read and open for amendment at any point. I will begin by recognizing myself for an opening statement. Resolutions of inquiry can serve a powerful oversight purpose. They seek documents and materials from executive branch agencies or the President that are otherwise unavailable. In doing so, they can help us exact a careful balance of powers as co-equal branches of government. But neither this resolution nor the 6 others we are considering today furthers that goal. Instead, these resolutions largely ask for documents that are easily accessible through other means, or are already in the public domain, or they are premised on mistruths and conspiracy theories. Under the House rules, however, a resolution of inquiry is privileged on the House floor unless the Committee of Jurisdiction acts on the measure within 14 legislative days. Therefore, in each instance, I will be recommending that my colleagues report the resolutions unfavorably so that we may move on to other pressing business. We could be spending today improving our laws, protecting our constituents, or securing our nation. Instead, our first resolution of inquiry has an objective that has already been achieved. H.Res. 1325 requests the President and directs the Attorney General to transmit to the House of Representatives a copy of the affidavit justifying the warrant to search former President Trump's home in Mar-a-Lago. The affidavit has now been made public. Without objection, I'll now enter it into the record. The point now is moot, and we should dispense with this resolution quickly. But I cannot help from observing that the affidavit and the other information that has since been released surrounding the search reveal overwhelming evidence that Donald Trump inappropriately withheld classified documents after his presidency was over. Unfortunately, many Trump supporters would rather divert attention from these obvious and deeply troubling facts, and instead they attack the dedicated law enforcement professionals who are working to protect our national security interests. But no matter how much time we spend debating this question today, the facts of the case will not change. Donald Trump admits that he took top secret intelligence information. He admits that he was told by the National Archives, the Department of Justice, and the FBI that the information did not belong to him. He admits that his lawyers claimed that they had returned all of these documents, even though they had not. He admits that he claimed these documents were secure in a storage room, even though they were not. Every one of these admissions is an admission that he put our national security at risk, likely threatening the security of our intelligence assets and the lives of our personnel, both here and abroad. There are men and women in our armed forces and our intelligence community who put their lives on the line every day in order to defend our country. Their lives are in greater danger today because Donald Trump treated top-secret national security information like a souvenir at his resort. And now, faced with the threat to national security posed by Donald Trump, many of my Republican colleagues have rushed into action, not to defend our country, but to defend Donald Trump. These are the same people who once saw maintaining a private email server as a criminal act, but who are now crying foul at the idea that Donald Trump may be held accountable for inappropriately keeping classified information in an unsecure location and resisting efforts to return those documents to where they belong. In fact, the same senator once suggested that, quote, any American out there who did what Secretary Clinton did, unquote, would be in jail now, is threatening riots in the streets if Trump is prosecuted. But attempts to undermine the investigation do not end with the use of inconsistent standards. I wish they did. Instead, we have heard dangerous efforts to demonize the law enforcement officials who helped keep us safe. From my colleagues across the aisle, including on this very committee, I've heard calls to destroy the FBI and smash the FBI into a million pieces. Statements like, the FBI is coming for you, and the FBI is the enemy of the American people might be commonplace on right-wing message boards, but they should still surprise us from political leaders in this country. Even more sinister are the words from far-right supporters across the internet, such as, time to bear arms and take down the FBI. We need to go after not just the FBI, but every employee, including their families. They're not Americans. They're not even people. These sentiments should draw widespread condemnation, but all I hear from Republican officials is silence. Let me remind you, FBI investigators are Americans just doing their jobs, and failure to condemn this language puts their lives and the lives of their families at risk. As the investigation over Donald Trump's handling of classified information continues, we are presented with the opportunity to reaffirm our commitment to upholding the rule of law. We can allow our law enforcement agencies to do their jobs unencumbered. We can condemn those who threaten the lives of the men and women of the FBI. We can reaffirm our commitment to keeping our intelligence community and our military personnel safe. And we can hold accountable leaders who flout our laws. But none of that will result from passage of this resolution. Therefore, I oppose this resolution, and I encourage my colleagues to do the same. I now recognize the ranking member of the Judiciary Committee, the gentleman from Ohio, Mr. Jordan, for his opening statement.
Thank you, Mr. Chairman. Thank you, Mr. Chairman. You mentioned in your opening statement we could be spending our time on improving our nation's security. Yes, we could, and we have tried to do that for now almost 2 years. We have a border that is no longer a border. We'd love to talk about it. We'd love to talk about the fact that we went from safe streets to record crime in every major urban area and try to figure out how we can help those situations, but you guys won't do it. I think I speak for every Republican member on the Judiciary Committee, probably every Republican member in Congress. We would love to focus on those issues, but you won't do it. You talked about the FBI, and we shouldn't be disparaging the FBI. I agree. The vast majority of the Americans, I think your quote was Americans doing their job at the FBI. I agree with that. They're good people. In fact, we know of 14 of them who've come to our office as whistleblowers and talked about the political nature that overwhelms the Washington field office and the FBI. That's our concern. The FBI lied to the FISA court. The FBI altered evidence to the FISA court. That's not Republicans on the Judiciary Committee saying that. That's Michael Horowitz, the Inspector General. And they did so they could spy on President Trump's campaign. They even had a woman pose as someone else, use the name Azra Turk to bump into one of the people who worked on the Trump campaign. You know what they call that? Spying. They did it. The Comey memos, he leaked them to get a special. Okay, we can go. I don't want to go through all the history, but it's worth. I think it is worth just pointing to that. That's what happened at the FBI, and now we have this, the issue in front of us. Why this resolution of inquiry is so necessary. Last month, the FBI took the unprecedented step of raiding the home of a former president of the United States. Never happened in American history. And I would point out, not just the former president, but the likely presidential candidate for the Republican Party to run against the very Justice Department the Biden administration had go raid his home. The raid on the president's residence represents a shocking escalation of Biden administration's weaponization of law enforcement resources against its political opponents. The American people deserve transparency and accountability, and that's why this ROI is necessary, not some heavily redacted affidavit. We want to know the truth. The Biden DOJ is hidden behind a formal policy of not commenting on the investigation, all the while engaging in selective leaks of salacious accusations without any context to them. In fact, on August 11th, 2022, last month, Attorney General Garland addressed the search for the first time, had a press conference, and he said, "I have made clear that the Department of Justice will speak through its court filings and its work." Well, if you made it clear, why'd you have to give a press conference? Why'd you go talk about it? On the very same day, though, the Washington Post reported that FBI agents were seeking quote, classified documents relating to nuclear weapons, according to leaks from, quote, people familiar with the investigation. So much for letting the court filings speak for your work. You did a press conference, and then people familiar with your work leaked it to the Washington Post. So if that's going to happen, why not let the American people in on it all? Just show us the affidavit. The New York Times later reported that President Trump had, quote, more than 300 classified documents at Mar-a-Lago, according to leaks from, again, quote, people briefed on the matter. So it's fine for the FBI to go leak it, but the American people can't see what the whole basis is in the affidavit itself. And Mr. Chairman, there's no reason this raid was necessary. Until the raid, we had seen ample evidence of cooperation. In January of 2022, President Trump voluntarily turned over 15 boxes of material. In May, President Trump voluntarily accepted service of a grand jury subpoena that sought documents bearing classification markings. Throughout June of 2022, the Department and President Trump's lawyers engaged in discussions about the matter. On June 2nd, President Trump, through his lawyers, invited FBI to visit Mar-a-Lago to retrieve responsive documents. On June 3rd, the Department and FBI officials visited Mar-a-Lago, and President Trump allowed them to inspect his storage room, even provided responsive documents during the visit. During the visit, President Trump told them, quote, whatever you need, just let me know. On June 8th, the FBI requested that the president further secure the storage room, which he did. Despite all of this, the Attorney General personally approved the decision to seek a warrant for excessive and unprecedented access to President Trump's private home. During the Biden administration, the department has shattered public confidence in the equal application of the law. The department has filed politically motivated lawsuits against Republican-led states, artificially inflated domestic violence extremism statistics. We know that because a whistleblower has told us that they're juicing the numbers. And he's used counterterrorism resources to target parents at school board meetings. And again, we know all that because brave whistleblowers at the FBI agents have come forward and talked to us. The department has also selectively prosecuted and investigated political opponents of the Biden administration. A pattern has also emerged of Attorney General Garland seeking to prosecute cases against political opponents through leaks to friendly media sources rather than the courtroom. These actions not only undermine the stated mission of the department, they violate the most fundamental tenets of our country. That's why it's critically important that we get access to the unredacted affidavit. We must begin the process of bringing accountability to this agency. I would urge support for the resolution. Thank you, Mr. Chairman. Would yield back.
Gentleman yields back. Without objection, all other opening statements will be included in the record. I now recognize myself for purposes of offering an amendment in the nature of a substitute. The clerk will report the amendment.
Amendment in the nature of a substitute to H.Res. 1325.
Without objection, the amendment in the nature of a substitute will be considered as read and shall be considered as base text for purposes of amendment. I will now recognize myself to explain the amendment. This amendment makes only technical changes to the underlying resolution, such as including President Biden's name. Otherwise, the amendment makes no substantive changes. I yield back the balance of my time. Are there any amendments to the amendment in the nature of a substitute? For what purpose does the gentlelady from Texas seek recognition?
Mr. Chairman, to strike the last word.
Gentlelady is recognized.
There's such a collegiality in this committee, Mr. Chairman, that I hesitate to comment on the remarks of my distinguished ranking member. But we are here today in a bucket of falsehoods and absolute absurdity that tries to, if you will, fix the lean-to that's about to fall down. And that is America's commitment to democracy. You can always distort the facts. That's what this resolution attempts to do, making the victim the former President of the United States. Nowhere has there been mentioned the National Archives, the agency responsible for our historical records that are in fact the very core of America's continued existence, the knowledge of her history so that she can proceed in the future. No one has commented on the very friendly manner in which, appropriately, that the National Archives asked for documents, and that the only way those documents were responded to was the intervention of the Chief Legal Officer of the United States of America. Yet, those documents allegedly were presented, as my colleague from Ohio said, in the most eager way, completely inaccurate. And I think the ultimate insult is the fact that sworn officers of the court, the lawyers of the former president, indicated that they had given all documents. Chairman, that is not true. All the documents were not. The imperativeness of the subpoena was as evidenced in that famous picture on the Time magazine, almost gave most of us who deal in issues of national security and classified information, as members have done over the years of their service, a panic attack. Documents scattered across on the floor, potential negative information or maybe classified about heads of state, now evidence suggesting that information about nuclear capacity on our allies or with our allies, and then this tirade. Republicans should defund the bureaucracy. We should fire the IRS. We should fire the FBI agents who are abusing authority. A member of this committee, he knows who he is. Enough is enough. The FBI needs a complete house cleaning. The FBI is off the rails. All members of the Judiciary Committee, Republicans. The FBI has been compromised. It's time to investigate the investigators. The FBI and the DOJ have weaponized their powers against Americans who disagree with them politically. In the course of all of that, FBI agents, servants of the people, needed to have security at their homes, protecting them. They were receiving death threats. My good friends on the Republican side have now become not the attack on Democrats that have been false, but they have now become the champions of defunding law enforcement and being at the top of the crusade of leading it against the FBI and jeopardizing the lives of their families and themselves. So this resolution is a resolution that is chasing its tail. Why? Because it was the former president who instigated the implosion of information. This was a quiet operation that FBI agents and other investigators, you may not like it, do all the time. And they find information or not. You challenge it or not. In this instance, the former president of the United States took to the podium across America, attempted to become a victim in the midst of conspicuously hiding and offering an unpatriotic response in terms of protecting genuinely classified documents and engaging in genuinely dangerous actions have to be inexcusable. And so I will continue to raise the point of the long chain of outlandish statements of attack on the FBI, and to, in conclusion, just simply say, not only were these threats, but here were, not only were they words, but threats, that when we're in power, we need to go after not just the FBI, but every employee, including their families. They are not Americans. They are not even people. I end on that note. This resolution is false, and it is chasing the tail. And Mr. Chairman, we need to vote this down. I yield back.
Mr. Johnson.
For what purposes, Mr. Johnson of Louisiana seek recognition?
Thank you, Mr. Chairman. I strike the last word.
Gentleman is recognized.
I have to respond to what my friend and colleague just said, and I understand the Democrats' talking points here, but this is so far out of line with what the American people believe about this. During the August district work period, I was in a number of states in colleagues' districts, all from the West Coast to the East Coast, and everywhere that I went, as soon as the conversation was turned in a public forum to audience questions, they asked a couple of things right off the top. They're deeply concerned about inflation, of course. They're deeply concerned about illegal immigration and the border that's open and all these other issues. But you know what is fundamental and at the root of so much of that is the people's doubt about our institutions themselves. And it begins with our system of justice. And my friend, you said this is an quote unquote, an unpatriotic response, our request for information about this. This is our most basic and fundamental responsibility. This is the committee of the United States Congress that has the responsibility of oversight over this Department of Justice that, my friends, is completely out of control. And the American people know the facts. It doesn't matter what the talking points from the Democrats are presenting here today. The people know what's going on. Let me give you a quick recitation of some of this. This Department of Justice has filed politically motivated lawsuits against Republican-led states. They have artificially inflated domestic violent extremist statistics. They've used counterterrorism resources to target parents at school board meetings, and we'll be talking a lot about that later today. The department has selectively prosecuted and investigated political opponents of President Biden and his administration. These are facts. These are objective facts, and anybody can see that. We have a pattern that's emerged. This Attorney General, Merrick Garland, seeking to prosecute cases against these political opponents, they're leaking this to friendly media sources. They're not doing this in a courtroom. They're not following regular order. They're not respecting due process. They're not even respecting the Constitution itself. They have weaponized, that is the word, they have weaponized the Department of Justice. And the greatest threat to this is what all those people have told us in all these public forums all around the country. The American people are doubting now that the system of justice is fair. You cannot weaponize America's system of justice. You know, most of us on this committee are attorneys. We all went to law school. The most fundamental tenet of this is, you know, the phrase, the motto that's etched into the marble above the entrance of the United States Supreme Court, equal justice under law. Wow, that is a critically important principle in a constitutional republic. There's a reason, I say all the time in these public forums, there's a reason that Lady Justice is depicted as the symbol of our system with a blindfold. Because there's not supposed to be two standards of justice, not one for the rich and powerful and one for everybody else. That's what we're seeing. You're not supposed to have Lady Justice yielding the sword against political opponents of the party in charge. That's what we have right now. And that's why we're alarmed. The most patriotic response that we can have right now is to seek this information. Now, our side is in the minority. We don't have the gavels right now. And for those who are watching back home who are so frustrated about this, why can't you guys take control of this? Why can't you bring accountability? Hey, accountability is coming. It's coming in the next Congress. We will get the gavels back. In January, early January of next year, you'll have a new Congress. I believe that you'll have Republicans in charge of this committee, and we will perform our responsibilities. And gathering this information right now is a critical step in having the information we need to exercise that responsibility. The department, the FBI, the White House, they have failed to respond to our respectful and formal and lawful request for the information. We're entitled to it. More than that, we must have it so that Congress can continue to work, so that we can provide this essential oversight so our Department of Justice can continue to work for the people. That's why we're here. That's what you're going to hear repeated over and over. I yield to the ranking member.
I thank the gentleman. In 2016, the FBI spied on the Republican presidential campaign based on a document they knew was false at the time. In 2020, they hid evidence that would be damaging to the Democrat presidential campaign, but the lady from Texas says they're not political. Those are the two examples you have to look at. They spied on a campaign based on false evidence. We know it's false because we had the Mueller 19 lawyers, 40 agents, $40 million, all that said, no, nothing there. But they hid evidence because a whistleblower came forward and said Timothy Thibault, who's amazingly now retired from the FBI, was pressuring people to suppress evidence that was damaging to the Democrat campaign. But they're not political. Not political.
I yield back. There'll be more.
Gentleman yields back. For what purpose does the gentleman from Rhode Island seek recognition?
Mr. Chairman, I move to strike the last word.
Gentleman is recognized.
Thank you, Mr. Chairman. This resolution is an effort to get documents central to an ongoing and active criminal investigation by the Department of Justice. When the FBI conducted their search as authorized by a federal judge upon a finding of probable cause to believe that evidence of federal crimes would be found at that location, they executed a search warrant at Mar-a-Lago, and they found more than 10,000 government documents in Donald Trump's home, some of which contained vital, extremely sensitive national security information. Let's recap the facts. Among the documents found, there were documents with confidential, secret, and top secret classifications, documents reported to reveal the nuclear capabilities of foreign nations, dozens of empty document folders marked classified, and dozens of empty folders marked returned to staff secretary, military aid, and who knows what else. Who could possibly think that it could be safe for Donald Trump to keep these documents in his personal home at a resort? Can you imagine the outrage if a Democratic staffer, after being fired, took top secret documents back to their personal home and refused to hand them over? Donald Trump stole these highly classified documents. He failed to store them properly, and then he refused repeatedly to return them as required by law. Under existing federal law, presidential records are not the private property of the former president. These documents belong to the government, not the man who formerly held office. Donald Trump is not above the law just because he's bitter and angry that he lost the election. For years, all we've heard is that Democrats are the anti-police party and that GOP backs the blue and supports law enforcement. But they've shown that nothing could be further from the truth. They only back the blue as long as the blue turns a blind eye to Donald Trump's abuse of power. No matter how much hard evidence we have, Donald Trump breaking the law, they call an FBI investigation a witch hunt or conspiracy. I hate to burst your bubble, ladies and gentlemen. Someone has to break it to you. The FBI is law enforcement. When members want, and I quote, to defund the bureaucracy of the FBI and to decentralize the FBI and claim that the FBI is corrupt and politicized, they're not backing the blue. Instead, they're throwing law enforcement under the bus to try to protect a corrupt former president. Paul Gosar even wants to destroy law enforcement. That's not hyperbole. He tweeted, "We must destroy the FBI." I asked that be put into the record. He says this when the FBI
Without objection.
He says this when the FBI was just doing its job. There is hard evidence that Donald Trump is a clear threat to our democracy. He couldn't even get his story straight about these documents. Donald Trump and his lawyers told the National Archives and the FBI that the classified documents were kept in a secure facility. They were not. Then he tried to say the documents belonged to him. They don't. Then he tried to claim that he had no more classified documents. That was not true. Then he claimed that he had declassified them on his way out of office. Also not true. Then he told us, sort of his favorite, like everything, it's a witch hunt and it's a hoax. And then he went so far as to even claim they were planted. These documents were planted at Mar-a-Lago. Clearly, these documents were not kept safe or secure, with potentially devastating, catastrophic consequences for our country and our democracy. These documents weren't just some benign files. They were sensitive and top secret files that are not even available to some of the highest ranking government officials. These files being leaked or stolen by foreign enemies could literally cause the death of those who do the dangerous work of collecting this intelligence. And for Americans whose safety rests on the security of this information, and for the informants who are possibly provided it, this was a threat to their life and well-being. Storing this kind of information in a private resort was the epitome of recklessness and lawlessness. The government and law enforcement has every right and, in fact, a duty to investigate and to use official congressional hearings to demand an affidavit that we already have related to serious ongoing criminal activities and an ongoing and active investigation is not only inappropriate, it's outrageous. We get accused all the time of playing games, but that's what this resolution is, a game of distraction. It's a waste of time to steer away from moving substantive legislation and steering attention away from this grave misconduct of the former president. I urge my colleagues to take this threat to democracy seriously and help hold Donald Trump accountable by supporting this investigation into how these documents were handled and to oppose this resolution, which is nothing but a poor attempt at distraction. And I yield back.
Gentleman yields back. For what purposes the gentleman from Arizona seek recognition?
Move to strike last word.
Gentleman is recognized.
Thank you, Mr. Chairman. I do find it intriguing that We heard the chairman refer to Secretary of State Hillary Clinton, that somehow her having 30,000 classified emails at a server at home is really no big deal, even after she bleach-bitted and cleaned up her hard drive, and then they had him physically destroy any copies of that. Interesting, because that person is an officer not protected and liable to prosecution under the PRA. And then someone actually just said, and made a comparison to the President of the United States with a Democrat staffer. I mean, how asinine is that? That's nuts. The PRA is pretty doggone clear. Who does it apply to? The government has to prove beyond a reasonable doubt that the accused is an officer, employee, contractor, or consultant of the U.S. But the case law is clear that the President of the United States is none of those, and when declassifying information, he does not have to go to any kind of specific procedure. That's the facts. That's the reality that you don't want to acknowledge. But then you move over, and let's start talking about this particular case here. Leaks after President Trump turned over 15 boxes. He turned over 15 boxes. Then there was the false leaks that we just heard talking about now about nuclear weapon and nuclear secrets being out. The FBI, more leaks, drip, drip, drip. On July 6th, a hard drive's given to the FBI. What happened then? More leaks from the FBI. Trump complied with a grand jury subpoena prior to the raid. New portions of this document, the affidavit, show that President Trump gave additional documents to the FBI, again before the raid, just like he gave on a July 6th hard drive given to the FBI, all before the raid, which is not a quiet operation. A raid's not a quiet operation. Show up with 30 agents, guns drawn, everybody's investigating everything. And guess what? The warrant itself violated the Fourth Amendment because the Fourth Amendment requires particularity of the location and what you are looking for. This basically said anything in this massive public accommodation, public housing, that President Trump lived in, which is I don't know how many rooms, dozens and dozens of rooms, subject to search for basically anything, for anything. That is a violation of the Fourth Amendment. But one of the great things that we've heard today is, hey, this is moot. This affidavit has already been released. Here's this page. Oh, that's all, wait a second, that's all redacted. How about this page? Oh, that's redacted. How about this page? Oh, my goodness, that's redacted as well. Let's keep going. Oh, goodness, how about this one? Redacted, 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 redacted. Oh, it's moot to ask for this. Redacted, redacted. The reality is you don't want the information because the information is going to reveal that the FBI does operate against political opponents, particularly under this administration. You have going back. This is new. This is breaking news. I don't know if you've seen it. Maybe you just missed it. This is recently breaking news that the FBI paid for Russian disinformation to frame Trump. That's all over the news. That just came out 2 or 3 days ago during his campaign. They weaponized the federal police bureaucracy in order to go after a political opponent. What does that sound like? Does that sound like the United States of America? No, that really doesn't. That's what's happening here. So when you look at it and you say, oh, come on now to say that the FBI or any other institution is weaponized, you just don't back the blue. Hey, we back the blue. That's why you're seeing in this coming forward more than 14 whistleblowers who say, you know what? Hey, the FBI has been weaponized for political purposes. You guys don't want to know it on the other side, but I sure would like to know it. I can't wait to hear them. And when we get the gavel back, they'll be in here and they'll be testifying and it'll all come out. You don't want it to come out today. That's why you oppose this resolution. Well, it's going to come out. I'll yield back.
Gentleman yields back. For what purpose does the gentlelady from Washington seek recognition?
Mr. Chairman, I move to strike the last word.
Gentlelady is recognized.
Thank you, Mr. Chairman. For the last 6 years, we've watched as the former president repeatedly violated democratic norms. As president, Donald Trump put his personal and private interests first over the interests of the American people. He lied to Americans an estimated 30,573 times during his presidency. Out of office, he's continued to lie about the results of the 2020 election, incited an insurrection, endangering our democracy simply so that he could stay in power. And now we've learned that Donald Trump, in another show of disdain for democratic norms, has been keeping classified and top secret documents that he was required to return at the end of his presidency. It is laughable that my colleagues across the aisle suggest that if a president wants to declassify documents, he can just, say so when that document is found in his home at Mar-a-Lago. It's ridiculous. In the aftermath, Trump spread misinformation on the FBI's investigation, claiming that the documents were his. Several House members boosted Trump's words, called the investigation a, quote, witch hunt, and created public pressure to, quote, defund the FBI. It's important that people who are watching this understand the connections between Donald Trump and his rhetoric, the big lie, the January 6th insurrection, and what's happening now following the FBI's search of Mar-a-Lago. Even also, in addition to that, the threats of political violence, racist and xenophobic rhetoric that continues to permeate our landscape. All of this is designed to undermine the faith in our institutions. And my colleagues are right. There is an undermining of the faith in our institutions, and it is perpetuated by many of our colleagues on the other side of the aisle. Things like a free and fair election or the peaceful transfer of power. All of that has been undermined. Now, following the search at Mar-a-Lago, the FBI and its agents have become targets. For example, an armed man named Ricky Schiffer, who was also at the Capitol on January 6th at the insurrection, attempted to break into the FBI building in Cincinnati, Ohio, and called for people to prepare themselves for, quote, combat after news broke of the search. In addition, federal magistrate judge who found that the FBI had probable cause and approved the search has received violent threats. Users posted anti-Semitic slurs on right-wing social media platforms and message boards and released the judge's name, address, and personal information to further his harassment. It is an uptick in violence that is fueled by the incendiary language spouted by Donald Trump and his loyal supporters. It is not normal. It should not be considered as normal. It is what led to January 6th and has the potential to continue to dismantle our democracy. Now, the fact that people are doubting our institutions is aided, perpetuated by a Republican Party that has decided that their best shot of winning is to actively undermine those very institutions, including the Department of Justice, the FBI, our elections. That is exactly, again, what led to January 6th. Institutions are not good when they agree with you and bad when they don't agree with you. An election is not fair if you win, but unfair if you lose. You don't get to say you support law enforcement when it goes after your opponents, but the minute that it goes after your own president, your former president, who took classified documents with nuclear secrets to his home in Mar-a-Lago, all of a sudden the FBI doesn't become a terrible agency for doing its job. You can't decide all of a sudden that these institutions are bad just because you don't agree with them. And let's be clear, the government is not immune from criticism, but there is a big difference between using your free speech rights or protesting peacefully or asking for oversight and taking this to a violent rhetoric that undermines the core of our democracy. That is the disturbing reality that has become mainstream in the last couple of years. It's extremely dangerous to peddle information to the public that makes government agents, federal agents, and judges a target of harassment and violence. We have to be honest about what's at stake and condemn those who continue to endorse the big lie, continue to talk about the FBI in the terms that we have seen, and continue to endorse this kind of rhetoric. With that, Mr. Chairman, I yield back and I oppose this resolution.
Gentlelady yields back for purposes. The gentleman from Texas seek recognition.
Strike the last word.
Gentleman is recognized.
Listen, I've been here long enough to remember when Democrats in judiciary and Congress were great advocates of civil rights and protecting the power of the legislative branch and the oversight that we should be doing over the executive branch, particularly in our case, the Department of Justice. And I don't have a nice typed up speech like we've been hearing from the other side, but what I got is facts. And what I got is recall. And I remember when William Jefferson's office was raided, we had the full affidavit for that warrant, and I read it. And it looked like they had a slam dunk case that he was guilty. But never in the history of Congress had the FBI come and raided an office without going through House counsel. And because of my background as a former prosecutor, felony judge, Chief Justice, I was asked to sit in on the conversations that became yelling matches between House counsel, the White House counsel, and the DOJ counsel and the FBI counsel, and everyone was livid that the FBI came and raided an office, whereas always before, they went through House counsel because our information is privileged. When we get information from whistleblowers, from constituents, they have a constitutional right and, I'd submit, obligation when they know of wrongdoing in the federal government to come tell us so we can do something about it. And now we're being condemned. Look, unlike the Democrats now who are not standing up to the DOJ and for civil rights, look, the head of the DOJ has issued an order basically indicating that nobody in the justice system is allowed to have their constitutional right of having a privileged conversation with their Congress member. That's outrageous. How else are we going to have proper oversight? And so, yes, you already heard mention we have 14 whistleblowers that have talked. In the last week, I got 6 more. This is systemic. It's not just Merrick Garland ordering that if you're in the DOJ, you can't have your constitutional rights. It is beyond that. We have somebody being demoted because he refused to make his field agents sign affidavits that contained lies that were prepared by the DOJ, people that weren't even at the incident. And then he got demoted, and his career's in jeopardy. And that was last week I heard about that. In the last week, we had a report from people that were making a protected disclosure under 28 CFR Part 27 that on the 7th floor of the Hoover building, they're not protecting the SCIFs, and that phones were being taken into the SCIF. Well, we know you can't do that, and yet here at the top level of the FBI, where our most important secrets are being discussed and reviewed, they're allowing phones to go in that can be hacked, and our enemies can find out everything. And so that was reported last week. First of this week, the director of the FBI, Christopher Wray, had his deputy report, that's a lie. There are no violations of the SCIF. So this week, I got 3 more whistleblowers saying, that's a lie. And one of them saying, I'm on the group that has to come in and make sure the SCIF is secure, and it wasn't. They were openly carrying phones. The director carried a phone into this gift. They don't care. So I would say, based on what we now know, that the FBI was paying Danchenko, a Russian lackey, for information, and they refused to provide that. It had to come from Durham. After 6 years, we get the truth. We wonder what else is being done
the gentleman
politically to go after
the gentleman
Republicans
yield?
and the civil rights of people and the rights of
gentleman
this
yield?
body. No, the civil rights of this body are being violated, and we need somebody on the Democratic side to step up the way I did when William Jefferson's office was wrongly searched. I yield back.
Gentleman yields back. For what purpose does the gentlelady from Pennsylvania seek recognition?
To strike the last word.
Gentlelady's recognized.
Thank you, Mr. Chairman. I rise in opposition to this completely unnecessary request for resolution because the affidavit is present. We have it. You've already introduced it for the record. And what I find alarming, despite all the alarm we hear over there, is that they're not talking about what you can read in the affidavit. The rules, the laws that are alleged to have been broken or possibly likely broken, the narrative in the affidavit, that which is not redacted, you notice the folks on the other side of the aisle don't want to talk about. The finding of confidential records at Mar-a-Lago, 15 boxes returned in January after a months-long inquiry by the National Archives. They finally get 15 boxes with many, many documents, Presidential Records Act documents, never should have been at Mar-a-Lago, classified documents, never should have been out of their protected spaces. I really find it sad that the American public would have to hear the false arguments being made here. After all, this is a unique committee of mostly lawyers. We studied and prized the rule of law, not the rule of power, the rule of petty. I lost, I don't want to leave the building, and 2 days before I do get forced to leave, I ship boxes and boxes of materials to my resort home in Florida. I almost feel sorry for the folks on the other side of the aisle, but I don't. They know better. They know that they are misleading the public when they talk about a raid. This was not a raid. This was sadly a required seizure. It was a search and seizure authorized by law after 20 months of negotiating with the president. And he said, there's nothing to see here. I don't have any classified documents. I don't have any presidential records. And then he says, okay, Obama took millions more than I took. How are those two things to be reckoned? Oh, I declassified all of them, magic wand. Oh, I returned them all. A lawyer even wrote to the National Archives and DOJ saying, no, nothing here, until they finally had to go in and get them and find highly, highly classified documents, among other documents. It was a legal search and seizure. The folks on the other side of the aisle know that. And what is at stake here is obviously the rule of law, obviously the protection of national security interests, the preservation of the Presidential Records Act, which any president should revere and abide by, but also what has become. You've heard some of the statements by members on the other side of the aisle, inciting people to be against the FBI, that something is wrong with the FBI. Again, how are these misleading and dangerous words coming from lawyers sworn to uphold the rule of law, not to go along with a president who long flouts the rule of law, and now we have evidence that he tried to subvert the rule of law? I hope we go back to speaking the truth. The American public and this democracy is owed nothing less. I yield back.
I hope we go back to speaking the truth, too.
Oh, could the little J.
For what, the
Gentlelady
gentlelady
yield?
yields back. For what purposes?
Gentlelady, could you yield? Just for a moment.
Gentlelady yields.
Just for a moment. let me thank the gentlelady for yielding. I wanted to raise this point about life and death. It is so easy for the Republicans to now bring in immigration, suggest that they're not talking about defund the police. They are talking about defunding the police, but more importantly, they're jeopardizing lives with this kind of rhetoric.
You get 5 new minutes?
First of all, they join, and I hope to explore this a little bit more, they join their own leader who has discussed President Trump attacks on the FBI, given the most horrid suggestion of their lack of patriotism. But I'm going to give this one point. In 2021, a top secret CIA memo warned about troubling numbers of informants being captured or killed. The state secrets Donald Trump took from the White House included information from human sources, the same individuals who are disappearing at a rapid pace for reasons we have yet to figure out. And so it is my point that we are jeopardizing lives, and we have to take this seriously. I yield back.
Gentlelady yields back for our purposes. A gentleman from California seek recognition.
To speak on the resolution?
Gentleman is recognized.
Thank you. Mr. Chairman, it's suggested that it's hypocritical to criticize Hillary Clinton for mishandling documents and yet defend Donald Trump. Let me point out the glaring differences. In the case of Hillary Clinton, she placed tens of thousands of government documents, including highly classified information, on a private server with less security than a Gmail account. She was not prosecuted for that. Indeed, President Trump said at the time he was glad she was not prosecuted because that would make us look like a banana republic. Unlike any other public official, the president is the only person in the government who can use classified information in any way he likes. You might criticize how he does it, but it's not illegal. What we find frightening is this glaring double standard between the two cases. Hillary Clinton did not have authority to declassify material at will and was not prosecuted. Donald Trump did have that authority and yet has been subjected to an unprecedented and unwarranted armed raid. Now, my colleagues are absolutely correct to criticize in the strongest terms anyone who suggests a recourse to violence. That is antithetical to the fundamental principles upon which our country was founded. There is, unfortunately, a lunatic fringe in politics on all sides, and it ought to be condemned and marginalized by all sides. And we certainly do. In America, we talk out our differences. That is specifically what this institution is designed to do. That's the essence of democracy. Talking out our differences without fear of the Department of Justice assigning threat tags to us or being singled out by the IRS for our political views. What is dangerous to a democracy is politicizing our law enforcement agencies, not based on the rule of law and equal justice under law, but based on the political views of their targets. We just learned, as has been pointed out, that one of the sources of the false information that underpinned the Russian collusion hoax was paid by the FBI. From the Durham investigation, we know the FBI lied to the FISA court to obtain search warrants against the Trump campaign. This hoax, aided and abetted by a federal agency to which we give terrifying powers, affected 2 presidential elections and undermined the elected president and his administration for 4 years. We now know that during the 2020 election, the FBI actively suppressed on social media entirely accurate stories in the New York Post that documented Biden family influence peddling, material which many Americans later told pollsters would have affected their vote if they'd known about it at the time. The most chilling words I've heard in this committee was what was just heard from a member who said, the FBI is law enforcement. Well, the FBI is not law unto itself. The FBI is an agency that we give terrifying powers, the power to destroy lives, in the trust that it will defend the Constitution and enforce the laws equally and justly. When those powers are applied to affect the outcome of elections and to apply laws differently depending on the political viewpoints of their targets, that is something that is lethal to democracy. It's a betrayal of the Constitution, it's a threat to the rule of law, and those responsible for the abuse of these powers must be held accountable, and if this committee won't, who will? Criticism of the FBI's conduct in these and other matters is not an attack on law enforcement. It is the FBI's conduct that is the attack on law enforcement. Holding it accountable is a defense of the rule of law and the foundational principle of equal justice under law upon which just law enforcement depends. And I say again, if the Judiciary Committee of the House of Representatives is not willing to stand for these principles, well, it needs to be replaced by one that will. I yield back.
Well done.
The gentleman yields back who seeks recognition. Can we get someone on our side?
Mr. Bishop next.
No, ask someone on our side. Yield to me for a second.
Mr. Chairman, I seek recognition.
For what purpose does the gentleman seek recognition?
Move to strike the last word.
Gentleman is recognized.
I'll yield to the gentleman, to the chair.
I thank the gentleman. I just want to point out a few things that have gone wrong with this debate. We're told that the president declassified this material. Aside from the fact that that's apparently not true, even if it were true, it would be irrelevant because there were several statutes that were violated which have nothing to do with whether the information was classified or not. Principal among these is the Espionage Act of 1917. If material vital to security of the United States, which this material admittedly was, is withheld or put into a position where it is not properly protected, it is a violation of the Espionage Act, which is a very serious act, whether or not the president declassified that. I thank the gentleman for yielding. I yield back. Who seeks recognition? For what purpose does the gentleman from North Carolina seek recognition?
To speak to the resolution.
Gentleman is recognized.
I thank the chairman. I'm not sure, I wish I had the Espionage Act in front of me because I'm not sure that's an accurate recitation of it. The Espionage Act would prohibit disclosing information to an enemy, but there's no hint of an allegation that that occurred here. The question is that the information was at Mar-a-Lago. You know, I will say that more generally, and Mr. Cicilline's still on the dais, I wish Ms. Dean and Ms. Jayapal were, because I think maybe, look, I'll start off by saying that Mr. McClintock often does a great job, I think, of centering the discussion in a way that is reasonable and avoids the excesses perhaps on either side. And I'd sort of like to pursue some of that because, you know, Mr. Cicilline said, gentleman from Rhode Island, that the president, he was going through a series of claims that he said President Trump has offered, one of which was that he declassified the information. And he said that's ridiculous. And I wonder whether Mr. Cicilline would engage in a colloquy on that point, because I've done a little research on it. I don't purport to be a national security law specialist, but I have looked into it. And first of all, first principle is that the executive, the president of the United States, all power reposed in the president and the unified executive theory of government, has the power over classified information. It's not governed, except for nuclear secrets, which is governed by statute, everything is governed by an executive order. President Obama replaced President Bush's executive order in 2009. But every president retains the power to dispose of, in the manner he sees fit during his term of office, classified information, to determine whether it should continue to remain confidential. So, for example, Politico has reported, now Politico not a terribly reliable source, but it has reported that, that the reason Scooter Libby wasn't prosecuted for disclosing Valerie Plame's identity, confidential information, is because he was directed to do so either by the vice president or the president at the time. And that would have made it unclassified information, even if there was no formal process. So I wonder how it is. Let's say that in President Trump's record, of course, another thing, members on the committee today have asserted that the president's done this with highly, I think was Ms. Dean's term, classified information, very valuable information. Well, how do you know it is? I mean, the fact that it's just marked or it's got markings of secret doesn't say that it's highly damaging or dangerous information. I mean, anything else you know about it.
The gentleman yield to that point?
I will, just if you'll give me one more second to finish that point. How do you know? I mean, if you know anything, it's based on leaks by the FBI to the Washington Post. And so I don't really, frankly, take that at face value. I will yield to the chairman to comment.
Thank you. Just to answer your question, how do you know? You saw on television the images of those folders, and some of them said classified or something like that, TCI, which is the highest classification. That's how you know it was so classified.
Okay, but
Mr. Biggs, you asked if I would engage in a colloquy. The answer is yes, if you were serious. Mr. Bishop, I'm sorry.
Yeah, I'll yield for a bit. I want to try to get another comment in, but go ahead.
Yeah, no, I just wanted to answer your question with respect to the declassification. I don't dispute that you are correct, that a president has the power to declassify documents. But what we now know is that process, there is an established process to declassify documents. That was not followed, and in fact, Trump's own lawyers don't make that claim in court that they were declassified.
For the purpose of advancing the colloquy, not for diminishing it, let me ask you this question. What regulation do you refer to? I've seen in a number of media reports, they say, but the president would have to go through a process. I've looked to see where that is. I cannot find any law that compels the president to follow a process in deciding to declassify. Merely deciding to put the records, copies of records among his personal, it appears to me, would do it. So what is the regulation, Mr. Cicilline?
I didn't say there's a law. I said there is a process that has been established that every single other president has followed in order to declassify documents. You don't just get to take them home and retroactively say, when you get caught, oh, I declassified them, you caught me.
I think
that's
this
not
is
a process.
possibly illuminating, because you've asserted that there's a process. So what you mean is that other presidents have followed a process, but I gave you the example of the Scooter Libby situation in which they didn't. And there's no reason, if this president decided not to, it's his constitutional authority not to, from what I understand. And I think it's useful to hear these things back and forth, because what comes out in this committee is, you said he did something that appears to be illegal. It's not illegal. It might be not what Barack Obama did, but it's not illegal.
But Mr. Bishop, the National Security Council has to be made aware when a president declassifies documents. It can result in the death of Americans who are keeping us safe. That's why there's a process in place to do it. So the National Security Team is aware of the action of the executive branch. That did not happen in this case. You can't declassify something in secret retroactively only when you get caught with top secret documents stolen from the White House.
I understand why someone could quibble over a judgment call, but that's
not quibbling over judgment call.
Oh,
no, this is not a quibbling over judgment call. This is a direct violation of practice and procedure that is designed to protect the national security secrets of the United States.
It's either a crime or it's not.
The gentleman's time has expired. The gentleman's time has expired. Who else seeks recognition? What purpose does the gentleman from Oregon seek recognition?
I'll strike the last word.
Gentleman is recognized.
Years ago, I represented a target of a subpoena, and upon receipt of it, I realized that the content that was requested would be, if disclosed, violative of any number of principles of confidentiality. I asked then, obviously, I challenged the subpoena in court, and there were then opportunities to talk about what should be protected and what shouldn't. When I look at the sequence of events that have transpired here, and I look at, by the way, I'll get to the point here in a minute, which of course is our resolution, but when I look at the sequence of events where the Attorney General's office was working with the former president and his team in obtaining various records over the course of over a year and a half, I wonder why the process that was used was not the one that we followed back in our little Oregon, because it's so obvious that the process that was used was not necessary. The process of raiding the former president's home. What should, and it's been raised over and over again that this is not what happened to Hillary Clinton, and this is not what happened in previous similar situations. And instead, the dialogue continued. Certainly not what happened here. The appropriate action here would have been for the grand jury to issue a subpoena for the boxes of material that they had just seen a few days earlier, and then Trump's lawyers would have had the opportunity to challenge the subpoena on various grounds. And then they could have sorted through which material was classified, which material reflected attorney-client privilege. That's what should have happened, but for some reason it didn't. Now, people can go back and say, well, a subpoena had been filed earlier, but that was months earlier. There had been ongoing dialogue right up to the point of the raid. I don't get it.
Mr. Benson, if you'll yield.
Let me finish. No, I'm not
Okay.
going to yield.
All right.
What I find interesting is because there were alternative tools available for the AG to use, and he chose not to. You have to ask, why would the Attorney General want to throw, as I've said earlier in other interviews on this topic, gasoline on a political fire? Why? What could possibly be the benefit? Well, I know, because this is a political matter, and the other focus on issues involving our former president was wearing thin, and this gave an opportunity for a new focus, which is exactly what we're about today. But what we're trying to do is perhaps bring this dialogue to an end by looking at the very affidavit that prompted the raid. Now, that affidavit better contain all kinds of things that say those records were about to be destroyed. Now, you know what? They weren't. The president was 1,000 miles away. So, that's why you go into one of these things with a search warrant, because you fear that there's going to be something that you're trying to lay your hands on that's going to disappear. But I actually, looking at a editorial here, it's important to note that Trump himself was 1,000 miles away when the FBI's search and seizure occurred. It would have been impossible, therefore, for him to destroy the subpoenaed evidence, especially if the subpoena demanded immediate production. If he or anyone else destroyed the evidence subject to a subpoena, there would have been a far more serious crime than what the search warrant seems to have alleged. What we're asking today is, let's see the affidavit. I mean, what is everybody scared of? We'd like to see it. Maybe it's good, maybe it's bad, but we'd sure like to see it. You know what, that I'm going to yield to Mr. Bishop from North Carolina.
I thank the gentleman for yielding. And I think that, again, and I compliment Mr. Bentz for sort of centering the analysis. If indeed the Attorney General caused an unprecedented in the history of the Republic execution of a criminal search warrant against a former president's residence, when there were other legal options available to solve the problem, it does, I mean, that's what implicates the oversight responsibility of this committee. And it is interesting that it breaks down to, and look,
Mr. Bishop, will you yield for a question?
In 1 second. I want to say this. We issued one Twitter statement that went farther than I wish we had said. We said, I think it was something to the effect of, we must smash the FBI into a million pieces. That was the wrong thing to say.
Have you spoken?
We should have said we should break the FBI into 94 pieces. Because they ought to be decentralized. Main justice appears to be the problem. The Washington field office appears to be the problem. We ought to put the FBI under the supervision of United States attorneys and judicial districts all over the country. And there are 94 of those. I wish we had said it that way. Because I do think there's excess rhetoric. But I think when you go back and forth and you stop talking past each other, there are very serious issues to be examined in the conduct of the FBI and the DOJ. And this committee is responsible for that. And if you think back to Senator Harry Byrd, for whatever else you might say about him, and there's much to be said, but he at least respected the prerogatives and the responsibilities of Congress vis-a-vis wrong. So with that, Mr. Bentz, I'll yield back. I don't know if I left enough time for the gentleman from Rhode Island.
The gentleman yields back. Who else seeks recognition?
Well, it's Mr. Bentz's time.
For what purpose does the gentlelady from Georgia seek recognition?
Thank you, Chairman. I move to strike the last word.
Gentlelady is recognized.
I think the very thing that you're espousing is what we're actually trying to do, is make sure that there's accountability, and that is our responsibility on this committee. And at this time, I'd like to yield the balance of my time to my esteemed colleague from Rhode Island to help justify exactly that point.
I thank the gentlelady for yielding. To answer your question, Mr. Bishop, this wasn't the situation that caused the Department of Justice and the FBI to go to a federal judge and seek a lawful order authorizing the search was because of all the other efforts had been unsuccessful. After almost more than a year of pleading and negotiating with the former president and his legal team that they returned documents that the former president stole that don't belong to him. They misrepresented that he had turned everything over. They had not. They misrepresented that they were not in possession of classified documents. That was not true. They sent a subpoena, which is a lawful order compelling you to do something. They did not comply with that law by producing the documents. Their only remaining mechanism to, in fact, collect these documents that, if revealed to our adversaries, could result in the death or serious danger not only to individuals but to the national security of the United States, was to execute a warrant and retrieve them.
Would the gentleman
let me finish. You had a chance and you didn't want to really engage in a colloquy, so just let me finish. And so the notion that they just did this sort of quickly and didn't exhaust all these other possibilities, look, the execution of a search warrant is a serious effort, no matter who it is. It's a particularly serious effort if the subject of the target of that is a former president of the United States. But so is the conduct of the former president deadly serious. And you don't get to hide behind having been the president to cover up or engage in conduct which is unlawful and to say you shouldn't be held accountable.
Well,
so you're right, it's serious, but the conduct of the former president was also unprecedented and serious. So first of all, let's not suggest that the FBI and the Department of Justice and the archives didn't try desperately to get back these documents that the former president had no right to take. And by the way, taking of them was a violation of federal law, failing to secure them is a violation of federal law, and failing to return them upon lawful demand for their return is another violation of federal law. So there's no question that they tried as hard as they could to retrieve these documents. The former president and his team misrepresented, lied, and refused to turn them over. So that's number one. Number two, someone made the suggestion, couldn't they just go in and see the documents are there and then go back and ask for them again? Why did they have to execute a warrant? The only reason they knew they were there was because they executed the warrant. They had lied and been told, we've given you everything. We don't have anything else. So the notion that the former president was in New York on the other side of the country didn't mean that those documents were safe or the danger to the American people or our national security was diminished in any way. The idea that we're talking about some of the most secret kinds of information that are essential to the safeguarding of the national security of the United States, that those were unsecured, stuffed away in a golf club where all you have to do is write a check to become a member, and that is not disturbing? And then the claim that, oh no, we're not really attacking the FBI. One of your colleagues was selling T-shirts that said, defund the FBI. Her name is Marjorie Taylor Greene. I don't know if anyone in the Judiciary Committee bought those T-shirts, but look, I spent my career battling with the FBI. I was a criminal defense lawyer. But I always recognized the value of law enforcement and the importance of respecting the institution of the court and of law enforcement. And when a judge reviews an affidavit and signs it saying there is probable cause to believe that there is evidence of crime at this location and that there is some danger that that evidence will not remain secure and safe and poses a danger, and is evidence of crime or a cover-up or a conspiracy, the judge signs that. That judge then authorizes the lawful execution of warrant. There's nothing illegal about it. It happens every day in America for people who commit crimes. And so I just wish all of this fussing about, geez, you have a lot of concern about the FBI. What about a little bit of concern about the conduct of the former president? I haven't yet heard a single Republican on this committee in this hearing condemn the taking away of classified documents and stuffing them in your golf club without legal authority, refusing to return them, and thereby really undermining not only the national security of the United States, but the ability to keep our country safe. So I thank the gentlelady for yielding, and I yield back.
Gentlelady's time has expired. Who else seeks recognition?
I'll go next, yeah.
For what purposes, the gentleman from Ohio seek recognition?
To respond to the last comments. Mr. Chairman, so which is it? Is it frustration or is it imminent threat to people who work in our intelligence community? Because if it's just, I mean, the gentleman just said, oh, this is dangerous to the folks who do our intelligence work. Well, if that's the case, why'd they wait 3 days? Once the judge, if we got this affidavit that was so alarming and this subpoena is so alarming, they had to go in. There was no way to continue to work with the president who brought him into his house, put the lock on the door, just like he said. If it was so threatening, why'd they wait 3 days? because the judge signed it on Friday. They didn't go and raid the president's home until Monday. So if the threat is so it can't be frustration and imminent threat. I don't see how it's both. But that's the argument the gentleman wants to make. I would yield my time to the gentleman from North Carolina, Mr. Bishop.
I thank the gentleman from Ohio. Gentleman from Rhode Island, I just want to say that one of those things I remember learning as a brand new, in fact, a law student going into court, is that you got to be careful what things you state as facts to the court. Because if you destroy your credibility before the court by stating things that you wish were true but aren't quite true, it hurts you going forward. You just said in your last comments that the FBI didn't know they were there until they executed the warrant. Well, it may be that every media account that I've heard over and over again is wrong, because I do think there's lots of wrong stuff in media, but they all say that the FBI, in fact, in dialogue with President Trump's lawyers, asks for for the room in which the boxes that they knew were stored should have a more secure lock, and it was put on the next day. So to assert as part of our conversation, that's exactly what I'm trying to get a little bit past, is we could have a dialogue that's useful here, but instead the assertion that they didn't know any boxes were still at Mar-a-Lago is not, I mean, you know that's not true. You say that there was no other thing that they could do to resolve this. I asked Mr. Cicilline, are you familiar with a motion for an order to show cause? So, you said there's a subpoena. Mr. Bentz pointed out without... Is
that a real question or
it is in a minute. Let me finish posing it. He said a moment ago that there was a process in a case he went through. Well, these processes exist. And you can go, if the subpoena had been issued, the grand jury subpoena months ago, and had not been properly complied with, you got a couple choices. You could go ask the court to order the president to show cause why he shouldn't be held in contempt for not abiding by the subpoena. And if, as Mr. Jordan just said, they allowed it to go on for months, and even, in fact, if you dig in deeply and you look at the communications between the president's lawyers and the Justice Department lawyers, they never come to a climax. They sort of just drop off, and then they go in with executing a search warrant. And you might say, well, at the end of the day, you can say this is a question of judgment on the part of the Attorney General. It certainly is. But Mr. Bentz's inescapable point is, it's one thing to say there's nothing else they could do. It is another thing to say the Attorney General decided in an unprecedented way to go execute a search warrant against the former President of the United States when other things were available. I think it's important that we clarify which it is, and I'll yield back to Mr. Jordan so that he can yield to you if he will.
Thank you. Sure. So with all due respect, sir, a motion to show cause may be something that you would do in a civil case. I tried thousands of criminal cases. Criminal investigations either lead to no indictment or indictment. People who are the target of a criminal investigation don't get an opportunity to show cause. They get a warrant issued, a warrant executed, and evidence collected. That's the way the criminal law works. And what you're missing is the point is the former president should never have had these documents. Taking them out of the White House in and of itself posed a danger. They weren't secure. He didn't return them. You're missing the point of the danger of the president's conduct. I yield back.
I would yield to the gentleman from North Carolina.
So was the FBI wrong to arrange interviews with Hillary Clinton over her emails? Or should it just have sent a warrant out and put her in chains and brought her in? Is there a reason for that to be different in one case than the other?
If there's no comparison between it, there's no comparison, despite your best efforts to make it the same. There's no comparison between the use of a server and someone who stole highly classified documents, refused to return them, didn't secure them safely, lied about the fact that they had been declassified, and then still refused to return them. That's a violation of federal law.
Gentleman's time has expired. Who else seeks recognition? For what purpose does Mr. Roy seek recognition?
Move to strike the last word.
Gentleman is recognized.
I'm moved by the assertion that there is no comparison to documents physically present in a space as compared to classified information being in electronic form on a server. and that somehow there's no comparison there. I would associate myself with the remarks from the gentleman from California and as well as the gentleman from North Carolina about why we're here. I remember we've had a whole lot of conversation about the facts, or at least the perceived facts or alleged facts about what has occurred or what exists in Mar-a-Lago, what doesn't. But remember, we're still dealing with a 50% or something redacted document, affidavit. The whole point here is the power of Congress to demand information from the executive branch for us to do our oversight responsibility. That's why we're here. The gentleman from Texas, my friend Mr. Gomer, articulated very well why we should be bound together as members of Article 1 to defend the powers of Article 1 in this context. I ran afoul of a few of my colleagues and the former president when I agreed to a subpoena on the Oversight Committee because I wanted information about where kids were being held after the issues at our southern border. I wanted that information. I'm fairly public about my belief in the need to secure a border for the betterment of Americans and migrants, but I wanted that information. Article 1, primacy. Not supremacy, but it is Article 1. There's a reason I introduced the Article 1 Act with my friend Mike Lee, saying that we should limit executive power and executive emergency power. We should be bound together here in wanting to demand information and be able to get it. And as my friend from California pointed out, the FBI, the power of the FBI can be used and is used often to destroy lives. We will talk in a minute about a different issue about Scott Smith from Loudoun County, who was kind of exhibit one, or certainly one of several exhibits, in the now fairly infamous letter from the National School Board Association in direct coordination with the White House, which led directly to the Attorney General of the United States issuing a memorandum that is still in effect, and under which we know from whistleblowers American citizens have been tagged as domestic terrorists. That is the power of your Federal Bureau of Investigation under the Democrat Attorney General of the United States.
And you're running cover.
And you're running cover for them. And we're sitting here right now simply wanting to see the entirety of an affidavit so that we can do our oversight duty, our job. If there's some concern about that not being able to be seen by the public, we can march down to the SCIF right now and go look at the fully unredacted version. What in the hell are my colleagues afraid of in seeing the full unredacted version?
SCIF will leak it.
The American people right now are tired of seeing the power of government being used against them. When we say we want to see changes at the FBI or rhetoric like defund or break up the FBI, as my colleague from North Carolina said about breaking it into 94 pieces, as a former federal prosecutor in a United States Attorney's Office, I absolutely respect the many men and women I worked with going after bad guys, something I wish my Democratic colleagues would more often like to do, by the way. But the power centralized in the FBI under the Attorney General of the United States being used to target American citizens is something that the People's House, the People's House Judiciary Committee, should be keenly concerned on a bipartisan basis to try to protect. And again, I want to bring this back to the simple point. This is a request of information of the executive branch from a member of Congress elected by 750,000 American citizens in Arizona to say, I'd like to see the entire affidavit. And my colleagues on the other side of the aisle are against transparency. Against transparency. They like to use slogans, people over politics. Well, why don't we put people over politics and actually use the power of Congress to seek the truth? I yield back.
Gentleman yields back. Who seeks recognition? What purpose does Mr. Fitzgerald seek recognition?
Strike the last word.
Gentleman is recognized.
Thank you, and I appreciate from Mr. Ben's yielding. We heard from the other side, when a judge says there's probable cause here and issues a warrant, you know that it's there. Well, I've been a judge, I've been a Chief Justice, and I know that's not the case. That's why we have appellate courts, and that's also particularly true when it comes to the persecution of candidate Donald Trump and President Donald Trump. We went for years before we found out the true basis of the 6 warrants. It was based on garbage, lies. There was no probable cause there, and we found out we had FBI agents lying, even though one's been found not guilty. The jury said, well, they didn't, since everybody lies to the FBI, it shouldn't be a crime. Well, that's here in D.C., and that's a Democrat. A Republican, of course, would be convicted of that. But that's why our job is so important, because judges are not perfect. And let me just read you, after the deputy director of the FBI, that all of a sudden my Democrat fans are such huge fans of. Oh, and by the way, this information about the FBI hiring a Putin lackey, Danchenko, that didn't come out in the Mueller report. So they either hid it or were incompetent in finding it. It didn't come out in the IG investigation. So he was either incompetent or just actually hid it. And it takes a special counsel 2 years after President Trump's out of office to finally reveal what happened 6 years ago in the Department of Justice dishonesty. And so let me just read from this letter dated September 11th, after the deputy director said, oh, no, there were no violations of security that compromised security. It says, by issuing an absolute denial of your misconduct, talking in the letters to Deputy Director Paul Abadi, you also implicitly claim that the 2 individuals who reported the misconduct made false statements. That assertion is false. Thinking back, you are certainly aware that many of your subordinates saw you wearing the phone in the skiff. Now your subordinates are coming forward and their reports are far more damning to you and Mr. Ray. You, Mr. Ray, and the employees on the 7th floor violated national security because you were all too lazy to secure your devices. You failed to set the example, and now you've become the example of what's wrong with the FBI. I was talking to an FBI, actually multiple FBI agents, but a former FBI agent said, you remember back in the 80s and 90s, if we needed somebody to report, we had an indictment, we would call their lawyer and say, you need to report at 9 or 10 or 1. Tomorrow we have an indictment, and they would show up to jail because they knew if they didn't, they'd come pick them up at home. What that's turned into now is it's actually the tactics the Gestapo used. Middle of the night, wee hours of the morning, you bust in, you drag them out of bed, and you don't let them even put on clothes. What happened to the FBI? You drag them out in front of CNN or some other liberal media that you leaked the information illegally to before you did the search, and so that they could film it in their underwear. What happened to our Justice Department? That was not the way they were. They had some decency about them, but they become so political. And I know if it ever turned around and it was Democrats, yes, I would be upset about that, like I was about criminal William Jefferson's activity, but the way he was treated and the violation here, and not one person on the Judiciary Committee has complained about a member of Congress's phone that has privileged information on it not going and being screened by House counsel before it's grabbed by the FBI. You are putting this body in jeopardy by not standing up for civil rights, and I appreciate my colleague. Thank you.
Gentleman yields back. For what purpose does Mr. Issa seek recognition?
I move to strike the last word, Mr. Chairman.
Gentleman is recognized.
Mr. Chairman, I can see the future, at least a little way in the future. Today, each of these resolutions will be voted down on a partisan basis. Even though the dais is empty, virtually empty of Democrats now, they will all be here and they will vote down each and every one of these. They will do that because you don't want to hear, you don't want to see, you don't want to know, or perhaps you don't want us to see, you don't want us to hear, and you don't want us to know. And I deeply regret that for many of the reasons that my colleague, Mr. Gomer, just said. You and I have served here for many years, for 22 years together, and we will serve in the next Congress together, undoubtedly. In the next Congress, you may occupy that seat, or someone else may occupy that seat. But the fact is that this committee's obligation, exactly as it is any time we suspect, not see, not are sure, but just suspect something that needs to be looked into, and we ask for the information, we need to get it. Now, I've made mistakes in my 2 decades here. You know, in what became the Bates decision, I didn't see the importance of demanding and holding in contempt a member of the Bush administration when she was not delivered upon our subpoena, the subpoena of Mr. Conyers. And I regret that because I learned from it. I hope that you will think again and that my vision of the future will be different than the reality. And you'll look and say, you know, notwithstanding what someone might be telling me to do, which is to block all of these, I should err on the side of openness and transparency. I hope we'll do that, but my vision is that we won't. That means that everything that we're trying to get today, we will have to wait until January 4th of next year, if at all, to get. And that will be justice delayed, which is justice denied. I want to use the little bit of remaining time I have to say something to this body that I think has to be said. We have almost always considered the work of people beneath the president. In the firing of the 9 U.S. attorneys, we were looking primarily at people around the president, even though it was the president's authority. In the case of Hillary Clinton's leaving government with classified information on a server that its very essence violated the Federal Records Act, we were dealing with someone beneath the president and no longer in government. The list of people we go after, Lois Lerner and so on, are most often beneath the president. Today, much of what we're considering has to do with that one unique individual, of which we have only had 46, and that is the President of the United States. All power of Article 2 and all rights and all decisions that are authorized, including declassifying documents, belongs to that individual. It may be passed on to subordinates to have some input, but the reality is the Constitution and this body bestows all of that power on one individual. And as a result, we hold that individual to high standards, and appropriately so. But we also respect the privacy and the work product of that individual at a level higher than any others. Often, this committee and others will see people come and say, well, this is privileged because it was prepared for a meeting with the president. We've dismissed that often and said it isn't. But we've never before dismissed the direct product of the president, the signatures, the notes, the work product of a president. The FBI and the Department of Justice has flagrantly done just that as we speak, and no decision by a judge to grant it or a decision to hold it in front of a special master changes the fact that we have crossed a line that we should not have crossed, or I should say the administration crossed a line they should not have, and we should right it by at least looking into it. And with that, Mr. Chairman, I thank you for your indulgence, and I yield back.
The gentleman yields back for purposes. Gentlelady from Pennsylvania, seek recognition.
I move to strike the last word.
Gentlelady is recognized.
I would yield to the gentleman from Georgia.
I thank the gentlelady for yielding, and you know, today what we are seeing on this committee is an attempt by my friends on the other side of the aisle to continue demonizing school boards, local school board members, school administrators, parents, and teachers. And these school board meetings have become a place where MAGA extremists go to disrupt based on false and deceptive information imparted to them by the former president and his MAGA extremist followers, deception about what's being taught to our children. And it's a travesty that we come today in Congress, just a couple of months before a very important election, that my MAGA supporters on the other side of the aisle are intent on winning so that they can take control of this body, and then they will have the ability to harass and try to intimidate the administration with their oversight powers. But while they are doing that, ladies and gentlemen, if they should regain control of the House of Representatives and the Senate, you know, what these MAGA extremist Republicans will do is to criminalize women's reproductive freedom. And you've seen that as late as yesterday when a Republican senator introduced legislation that would create a nationwide ban on abortion and would criminalize abortion. So they want to criminalize abortion. They want a nationwide ban on reproductive freedom for women. They would also, if you give them back the gavel, in addition to pursuing these kinds of red herrings like this school board issue that they're trying to get at the FBI for, they want to do away with Social Security. They want to make Social Security and Medicare a program that gets reauthorized every year. And if you don't believe that, go look at all of the position papers that Republican senators have put in the public domain. It's true. They want to, in addition to doing away with women's reproductive freedom, they want to do away with Social Security and Medicare as we know it. And last but not least, these MAGA Republicans are hell-bent on destroying our democracy. They want to defund the FBI. And this is a part of what they're doing today. They want to try to destabilize and defund the FBI so that it cannot perform its law enforcement function, so that people like the ex-president can do whatever they want to do, can take documents, steal documents, sell classified information if they want to. There would be no FBI there to get at the issue. So they want to destroy our democracy, and they're doing that. They're doing all of that while Democrats are putting people over politics. Do you realize that in the last 19, 20 months, what Democrats have done under the leadership of Joe Biden? We passed the American Rescue Plan, salvaged the American economy from the depths of depression, where millions of jobs had been lost. We passed an infrastructure bill that is creating hundreds of thousands, if not millions, of new good-paying jobs. We have passed the common sense gun reform, common sense gun safety reform, the first time in 30 years that's been done. We passed an industrial policy that protects our supply chain so that we manufacture semiconductors in this country. We passed the Inflation Reduction Act, which is saving money for people. So we're saving money, creating good jobs, while at the same time creating safer communities. And so that's the contrast between our two parties. That's what you're getting now, and conspiracy theories is what you're going to get if you let these folks take over. And with that, I yield back.
The gentlelady's time has expired. For what purposes? The gentleman from Ohio seek recognition.
Move to strike the last word.
Gentleman is recognized.
Thank you, Mr. Chairman. The unprecedented raid of President Trump's private residence at Mar-a-Lago should alarm every American citizen, irrespective of political affiliation. Never before in the history of this nation has the residence of a former president been raided by the Justice Department of his primary political opponent. Thus, Attorney General Merrick Garland and everyone involved with the raid had to know that their actions were setting a potentially dangerous precedent. They also had to know, Mr. Chairman, that they would face serious questions and that they would have to explain to the American people why there were no other avenues that they could pursue to resolve this situation. This was the only way to handle this, and we all know that that's not true. Make no mistake, the American people deserve answers, and they deserve them now. They demand them. Unprecedented circumstances require unprecedented transparency and accountability from government institutions. But that's not what the American people have been getting from the Biden administration. No, unfortunately, Mr. Chairman, there continue to be unanswered questions, and without answers, the raid appears to be politically motivated, and I think we all know that it was politically motivated. If millions of Americans determine that the raid was politically motivated, then the integrity of federal law enforcement and the justice system itself, unfortunately, comes into question. And that, Mr. Chairman, is not something that we can allow to happen. Instead, we must make every effort to protect the integrity of the justice system and restore the faith and confidence and trust of the American people. And that starts with demanding answers, as we're doing today, to questions that Americans have about this unprecedented raid. I know my constituents have been asking me. I think people on both sides have been asked about this raid because it was so extraordinary. Because he has to be taken, he absolutely has to take responsibility for approving the raid. The task for answering those critical questions falls squarely on the Attorney General's shoulders. And he has a lot to explain, a lot of explaining to do, as this raid isn't the only action that's been undermining the credibility of this Justice Department under this Attorney General and this President, President Biden. Look, no further than the DOJ and FBI being weaponized to treat American parents as domestic terrorists and subject them to a formal FBI investigation. We saw that. It happened in this country, in the United States of America. Parents who care about their kids, who want the best for their kids, being targeted by their own government. It's completely unacceptable. Add to that the manner in which the investigation into former Secretary of State Hillary Clinton having classified emails on her private server were handled. Unlike President Trump, Secretary Clinton wasn't subjected. She was not the subject of an unprecedented raid by the FBI, even though evidence showed that she egregiously mishandled classified information, and we all know about the sledgehammers and the bleaching of documents and just getting rid of this stuff. It happened. And how can we forget the debunked Steele dossier or the whistleblower allegations that the federal law enforcement officials purposefully suppressed an investigation into Hunter Biden? We know it happened. Mr. Chairman, abuse of the law is abuse of the law, and there should never be a double standard. To restore faith in a once respected government institution, and address the appearance of continued partisanship by the Justice Department, the Attorney General must respect this committee's legitimate exercise of its oversight authority and respond to our inquiries. That's what we're asking. Respond to the questions that we've already asked that are absolutely important and essential for the American people to know the answers to. Failure to respond in a complete and transparent manner with clear and convincing evidence will lead to millions of Americans continuing to view this raid as a blatant political tactic, further undermining faith in democracy and equal application of the law, and we cannot let that happen. A result which would only further divide an unfortunately already too divided country. With that, Mr. Chairman, thank you, and I yield back.
Gentleman yields back. Are there any further speakers? If not, the
Mr. Chairman, I seek recognition. I seek recognition.
For what purpose does the gentleman from Florida seek recognition?
I move to strike the last word.
Gentleman is recognized.
Oh, thank you, Mr. Chairman. I heard Mr. Johnson say that school board meetings were places where MAGA Republicans come to congregate. And, you know, it might be what you call them, but we actually just call them parents when they show up to congregate at school board meetings. And it's quite possible that what's happened at those school board meetings has created a new generation of MAGA Republicans, of which I certainly associate, but it doesn't demonstrate any harm to our country. I also heard Mr. Johnson say that when Republicans invariably take over this committee after the midterms, that we will engage in harassing oversight of President Biden and his administration. Well, on behalf of all my Republican colleagues, let me promise you, we will not do anything worse to President Biden than what all of you did to President Trump. So that's our promise. You have moved the Overton window, and we indeed intend to get answers. I guess I'll be voting for this resolution of inquiry because I'm wondering if in my time in federal politics, there will be an election that the FBI isn't trying to influence. I mean, in the 2016 election, to hold the position that the FBI wasn't trying to influence the election, you would have to believe that an FBI lawyer changing evidence before a secret court to secure a warrant to engage in surveillance that never would have been justified otherwise to get close to the President Trump's campaign was not interference. But of course it was. And then we have the 2018 election where the FBI again creates all of this threat construction and fuels the Russia hoax and the Mueller investigation. And then we saw how fake all of that turned out to be when Robert Mueller's testimony before our committee looked more like a silver alert than a commission of a crime. And then you get to the 2022 election, right? Or I'm sorry, the 2020 election, where Mark Zuckerberg has recently said, the operator of the most powerful digital platform in American politics, the FBI literally came to him and said that he had to suppress information that 1 in 6 voters who voted for Joe Biden said would have changed who they would have voted for. So they interfered in 2016 with Trump. They interfered in 2018 with Mueller and the Russia hoax. They interfere in 2020 by suppressing the information. And now in 2022, yet again, the FBI shows up to create this cloud of criminality over a records dispute, over the great crimes of unfoldering and intermixing. It is ludicrous. And I just hope that if we authorize these resolutions of inquiry, I will get to see an election that the FBI isn't trying to influence or control in some way. The American people deserve an FBI-free election. And it's no waste of time to ask these questions. Indeed, they're the answers that the American people deserve. They're the questions that we get all over the country. And though these inquiries will be voted down today, the American people get to vote in November, and we're going to get the answers that they demand. I appreciate the committee's indulgence, and I yield.
Would the gentleman yield, Mr. Gates?
Yeah, I'll yield to Mr. Roy.
I appreciate it, gentlemen. I just want to remind the American people watching this that in addition to what Mr. Gates just said, that why we're here with these resolutions of inquiry, I filed a resolution of inquiry last year regarding border statistics. For the American people's just understanding, what happens in the majority, you file it, it has to sit for 14 days, 14 legislative days before it then ripens. And then, you know, Congress should act on it in order to protect Article 1
powers and duties to request information of the executive branch. And what the majority does is change rules, and they change rules to essentially kill these resolutions of inquiry. So then we have to go back and refile them. So that's what's happened here. So I just want to make sure that's clear. You've had resolutions that were filed, then you had subsequent resolutions that are filed because games are being played with the rules to kill the desire by members of Congress exercising the Article I authority to seek information from the executive branch. Oh, the horror of a government founded on separation of powers for Article I to seek information from the executive branch. Again, I just want to bring this back to that core principle that what we're talking about here is seeking an unredacted copy of an affidavit. We're seeking information on border information. We're seeking information on what coordination occurred between the White House, the Department of Justice, and the National School Board Association to target American citizens. I yield back to the gentleman from Florida.
Yeah, and I thank the gentleman for his remarks. I mean, Democrats remember the FBI used to be a racist right-wing organization that went after people like Malcolm X and Marcus Garvey and Martin Luther King. Now they've become like a totalitarian left-wing organization raiding the homes of Trump supporters. Both is bad, and that's why Mr. Bishop's argument about perhaps decentralizing the power that has been overwhelmingly politicized and weaponized against both parties is probably a good thing that the Republicans will look at when we take control of this committee. I yield back.
Gentleman yields back. Does anyone else seek recognition? If not, the question occurs on the amendment in nature of a substitute. This will be followed immediately by a vote on reporting the resolution. All those in favor respond by saying aye. Aye. Opposed, no. In the opinion of the chair, the ayes have it. The amendment in nature of a substitute is agreed to. Reporting quorum being present, the question is on the motion to report the resolution H.Res. 1325 is amended unfavorably to the House. Those in favor respond by saying aye.
Aye.
Opposed, no. The ayes have it. The resolution is ordered reported unfavorably. Roll call vote is requested. The clerk will call the roll.
Mr. Nadler?
Yes.
Mr. Nadler votes yes. Ms. Lofgren?
Yes.
Ms. Lofgren votes yes. Ms. Jackson-Lee? Mr. Cohen? Mr. Johnson of Georgia?
Yes.
Mr. Johnson of Georgia votes yes. Mr. Deutsch? Ms. Bass?
Yes. Aye.
Ms. Bass votes aye. Mr. Jeffries? Mr. Cicilline?
Aye.
Mr. Cicilline votes aye. Mr. Swalwell? Mr. Liu?
Aye.
Mr. Liu votes aye. Mr. Raskin? Ms. Jayapal?
Aye.
Ms. Jayapal votes aye. Ms. Dimmings?
None.
Mr. Correa?
Aye.
Mr. Correa votes aye. Ms. Scanlon?
Aye.
Ms. Scanlon votes aye. Ms. Garcia? Mr. Neguse?
Aye.
Mr. Neguse votes aye. Ms. McBath? Mr. Stanton?
Aye.
Mr. Stanton votes aye. Ms. Dean?
Aye.
Ms. Dean votes aye. Ms. Escobar?
Aye.
Ms. Escobar votes aye. Mr. Jones? Ms. Ross?
Ross votes aye.
Ms. Ross votes aye. Ms. Bush?
Bush votes aye.
Ms. Bush votes aye. Mr. Jordan? Mr. Jordan votes no. Mr. Shabbat? Mr. Shabbat? Mr. Shabbat votes no. Mr. Gomer?
I vote no.
Mr. Issa?
I vote no.
Mr. Issa votes no. Mr. Buck?
No.
Mr. Buck votes no. Mr. Gates?
No.
Mr. Gates votes no. Mr. Johnson of Louisiana? Mr. Johnson of Louisiana votes no. Mr. Biggs? Mr. Biggs votes no. Mr. McClintock? Mr. Stubbe?
No.
Mr. Stubbe votes no. Mr. Tiffany? Mr. Tiffany votes no. Mr. Massey? Mr. Roy? No. Mr. Roy votes no. Mr. Bishop? Mr. Bishop votes no. Ms. Fishbach?
No.
Ms. Fishbach votes no. Ms. Sparts? Mr. Fitzgerald? Mr. Benz? Mr. Benz votes no. Mr. Owens? Mr. Owens votes no.
How is Swalwell recorded?
Mr. Swalwell, you were not recorded.
Aye.
Mr. Swalwell votes aye.
How is Ms. Demings recorded?
Ms. Demings, you were not recorded.
Demings votes aye.
Ms. Demings votes aye. Ms. Garcia, you are not recorded. Ms. Garcia votes aye. Ms. Jackson Lee, you are not recorded. Ms. Jackson Lee votes aye. Ms. McBath, you are not recorded. Ms. McBath votes aye.
Are there any other members who wish to be recorded that have not been recorded? Clerk will report.
Mr. Chairman, there are 20 ayes and 14 noes.
The ayes have it, and the resolution as amended is ordered reported unfavorably to the House. Members will have 2 days to submit views. Without objection, the resolution will be reported as a single amendment in nature of a substitute incorporating all adopted amendments. The staff is authorized to make technical and conforming changes. Pursuant to notice, I now call up H.Res. 1238, a resolution of inquiry requesting the President to provide certain documents to the House of Representatives relating to the October 4th, 2021 memorandum issued by the Attorney General entitled Partnership Among Federal, State, Local, Tribal, and Territorial Law Enforcement to Address Threats Against School Administrators, Board Members, Teachers, and Staff for purposes of markup, and move that the committee report the resolution unfavorably to the House. The clerk will report the objection.
H.Res. 1238 of inquiry requesting the President to provide certain
Without objection, the
documents.
resolution is considered as read and open for amendment at any point. I'll begin by recognizing myself for an opening statement. H.Res. 1238 is a resolution of inquiry that seeks information related to a memorandum issued by the Attorney General directing Department of Justice resources to address threats against school administrators, board members, teachers, and staff. The memo notes the, quote, disturbing spike in harassment, intimidation, and threats of violence, unquote, against these dedicated public servants, and calls for a coordinated response to protect against criminal conduct directed towards school personnel. One might think that there would be bipartisan agreement that protecting school officials from threats of violence is fundamental to the mission of the Department of Justice, and that the Attorney General should be applauded for protecting those who are responsible for educating our children. But instead, our Republican colleagues have invented a vast conspiracy that turns a simple memo about documented threats of violence against school officials completely on its head and imagines it to be some sort of attack on parents. Are they talking about the parent who told one school official, quote, your life is being laid bare on the open and dark web. I don't condone what's going to be sent to those who are close to you or to the danger they may be in, but you personally deserve it, close quote. What about the one who said, quote, mass of people who know who you are. They will be effing see your head swinging from a pole, or, quote, you better grow eyes in the back of your head. These are just a few examples of the threats received by school boards across the country. I wish I could say they were isolated incidents. They are not. Teachers and school administrators across this country are bearing the burden of the toxic, racist, and violent discourse that has become commonplace in our society. The same COVID-19 misinformation, big lie talking points, and racist rhetoric we hear in our politics and on cable TV are backdrop to the stories of assault on teachers, administrative staff, and their children. Let me be clear. Having a child in the school does not give you a free pass to threaten other parents or to intimidate your children's teachers. Our social contract is predicated on thoughtful discourse and meaningful engagement, not stalking teachers, terrorizing their children, assaulting school board members, and destroying property. And certainly not by promoting such behavior or inventing controversy through dark money political organizations. My colleagues across the aisle can shout and point fingers at underpaid school teachers and school board administrators all they want. But teachers and administrators are being targeted for threats and violence at their homes, in their schools, and throughout their daily lives. Death threats, active shooter drills, and intimidation tactics should not be part of the daily work of being a school teacher. Yet it has become the norm for those we trust with our most prized possessions, our children. No one can claim that the terrifying incidents across the country are simply the result of a misunderstanding or simply overeager parents, guardians. Parents who merely want to be involved in their children's education do not phone in expletive-filled death threats like in Loudoun County, Virginia, North Penn School District in Pennsylvania, and so many other districts around the country. A thoughtful school board meeting does not involve masked white nationalist and neo-fascist groups like the Proud Boys telling school board members that they should, quote, tie rocks around their necks and throw themselves in a river, as in an Orange County school board meeting in North Carolina. And helping with a school trip does not involve three men storming into a principal's office with zip ties as in Mesquite Elementary School in Tucson, Arizona. Educators in America today wake up, care for their children of their communities, and go about their daily lives under a shadow of danger from far-right and anti-government extremists. But rather than come to their aid, my colleagues across the aisle would rather use them as scapegoats. We are a country that prizes democratic involvement at every level of government. The right to be heard, to have a voice, is guaranteed by our Constitution. But nobody has a right to threaten their fellow citizens with violence or to commit violence against those with whom they disagree. Yet our teachers, school administrators, staff, and even students regularly experience both. Although schools are often the first and all too frequent targets, the exponential increase in physical and verbal attacks in this country does not end with them. We do not have to look far to find other instances of intimidation and bullying escalating to attacks and violence. But instead of working together to address the grave and growing danger presented by a hateful-fueled extremist ideology that is increasingly turning to violence, the committee must instead take time to consider this resolution of inquiry. I urge all my colleagues to vote to report this resolution unfavorably so that we may continue with the important work of this committee. I now recognize the ranking member of the Judiciary Committee, the gentleman from Georgia. I now recognize Mr. Shabbat for his opening statement.
Thank you, Mr. Chairman. Move to strike the last word.
Without objection.
Thank you. Parents.
The gentleman is recognized, rather.
Thanks. Mr. Chairman, parents have an inalienable right to direct the upbringing and education of their children, especially as the radical left continues to push their agenda on Americans' children through some school boards, not all, but some, that attempt, among other things, to install controversial curricula without parental consent. Before I was elected to Congress, I practiced law. I was a county commissioner, I was a member of Cincinnati City Council, and before that, I was a school teacher in Cincinnati, where I taught the 7th and 8th grade. As a teacher, I found that the students who performed the best, who did the best in school, were the ones who had parents that were actively had to switch mics there. Something happened to the other one. So I found as a school teacher that The children oftentimes that did the best were those that had parents who were actively involved in their education, and oftentimes were the ones who actually took the time, cared enough to go to school board meetings so they could see firsthand what the people in charge were doing with respect to their kids. But it's not just my firsthand experience. Studies on parental involvement over the years have supported that conclusion. Now, because parents care so much about the education of their children, school board meetings can sometimes be highly emotional affairs. Parents want to know and have a right to know how their kids are being taught and what they're being taught, and oftentimes what materials are being used to teach their children. And of course, parents have every right to be heard. That's how it's supposed to work. That's how we want it to work. What we don't need, Mr. Chairman, is the vast power of the federal government throwing its weight around, treating parents as domestic terrorists. So it's deeply concerning that 11 months ago, the Biden administration went so far as to label parents as domestic terrorists simply because they wanted to make sure that their kids received the best possible education. Not in a million years did I or many of my colleagues dream that the Department of Justice or the FBI would be weaponized to treat American parents as domestic terrorists and subject them to a formal FBI investigation, including case files detailing their political views and something called threat tags, just for exercising their fundamental constitutional right to speak and advocate on behalf of their very own children, whom they care about probably more than anything else in this world. This is not just a localized effort. To the contrary, information received from whistleblowers showed that the FBI has opened investigations with this threat tag in almost every region of the country, relating to all types of educational settings. Not everyone on this committee was around when the Patriot Act was adopted, but you were, Mr. Chairman, and I was as well. And as I'm sure you'll recall, several of us demanded the inclusion of a sunset provision in the Patriot Act so that we could continuously conduct vigorous oversight and make sure that its provisions weren't abused by any administration, Republican or Democrat. And you and I, Mr. Chairman, specifically worked together on the Constitution Subcommittee to make sure that the new tools given to law enforcement back then under the laws that we were at that time passing weren't abused by the then Bush administration, which we were both concerned about when we passed the Patriot Act back then. What we've seen over the last year, in my belief, far exceeds even the worst abuses that we imagined when the Patriot Act was enacted. It's truly astonishing that the law would be used to treat concerned parents like domestic terrorists. And that's why it's so important that we demand that the American people receive answers to their legitimate questions about the extent and reasoning that this administration, the Biden administration, has used in using counterterrorism resources to target, in this case, American parents. The Biden administration needs to stop stonewalling and respond to this committee's legitimate requests, and they ought to do it immediately. And with that, Mr. Chairman, I yield back.
The gentleman yields back without objection. All other opening statements that will be included in the record. I now recognize myself for purposes of offering an amendment in the nature of a substitute. The clerk will report the amendment.
Amendment in the nature of a substitute to H.Res. 1238.
Without objection, the amendment in the nature of a substitute will be considered as read and shall be considered as base text for purposes of amendment. I recognize myself to explain the amendment. This amendment makes only technical changes to the underlying resolution, such as capitalizing the word memorandum and using President Biden's complete middle name. Otherwise, the amendment makes no substantive changes. I yield back the balance of my time. Are there any amendments to the amendment in the nature of a substitute? For purposes of the gentlelady from Pennsylvania, seek recognition.
Mr. Chairman, I have an amendment at the desk.
Clerk will report the amendment.
Amendment to the amendment in the nature of a substitute to H.Res. 1238 offered by Ms. Scanlon.
Without objection, the amendment will be considered as read. The gentlelady is recognized for 5 minutes to explain the amendment.
Thank you, Mr. Chairman. You know, I was a school board member for almost a decade, finishing my final term in 2015, the end of that year. During that time, I had countless conversations with involved parents and constituents in grocery stores, at school concerts, on soccer fields, and at formal board meetings about how our schools could best serve our children and our taxpayers. Sometimes these discussions were emotional or passionate, and people didn't always agree. But everyone always respected our democratic processes and the boundaries of civility and protected speech as we sought to reach the best possible solutions for our community. Not once in that decade did we ever experience threats to the personal safety of board members, educators, or their families, not even when the lacrosse team showed up to protest a coaching change. But something changed over the past few years as partisan divides grew and bad actors, both foreign and domestic, exploited those divisions for political gain. We've seen teachers, school officials, and school board members across America and their families, their children, endure threats and violence because partisan operatives, fueled with dark money, sought to create chaos in our communities in order to promote their own political ambitions. School board members in Bucks and Montgomery counties near my district in southeastern Pennsylvania have received threats evoking gas chambers and acts of physical violence. School boards in my district had to suspend meetings and call police when brawls erupted. At a school board meeting in Virginia, a parent announced that she would bring, quote, every single gun loaded and ready to her child's school. In Arizona, police arrested a father after he stormed his child's principal's office with zip ties. As a former school board member, these incidents are really disturbing, and they should disturb everybody, anybody who understands that political violence is a threat to democracy and to the rule of law. And it's not just school officials who've been targeted by those more interested in creating chaos than serving our communities. We've seen threats and violent behavior being levied against public servants at all levels, including election workers, nurses, librarians, elected officials, and in recent weeks, towards FBI agents and record keepers at the National Archives. How are public employees supposed to teach children, run elections, or serve the public under constant threats of violence? How can we encourage Americans to serve the community, to teach, to run for office, or work at government agencies if doing so places them or their families in danger? This is not normal. Political violence is un-American. Our Republican colleagues have tried to frame criminal acts to intimidate school board officials as examples of protected free speech by caring and involved parents. But any reasonable person can see the difference between threats of violence and legitimate political discourse. Things have clearly gotten out of hand. We teach our children in schools that words matter and that they have consequences. However, when Republicans deny the seriousness of vandalism and threats of violence against school officials and their families, and the extremist rhetoric that inspires them, when they encourage such conduct instead of condemning it, they endanger the lives of elected officials, teachers, school staff, and our children. And the inflammatory rhetoric we've heard today continues the pattern of stoking grievances and polarizing our communities rather than helping our communities work together. Our colleagues seek to reframe criminal harassment, threats, and assaults against school leaders and their families as normal parental behavior by stoking the same kind of right-wing conspiracy theories that encourage those threats in the first place. My amendment will ensure that members of the House receive fair and balanced information regarding the extremely real and concerning threats made towards schools, school boards, educators, and school staff, and not just cherry-picked information to support another MAGA conspiracy theory. I encourage all of my colleagues to support this amendment, and I yield back.
The gentlelady yields back. Who seeks recognition? What purpose does the gentleman from North Carolina seek recognition?
To speak on the amendment.
Gentleman is recognized.
I would first ask the gentlelady whether she would vote against an unfavorable report for the inquiry if it included her amendment.
I think that remains to be seen since we're going to see what happens with the amendment, but I suspect it will follow the same path as most amendments in this committee.
Well, you think the amendment will fail, is what you're saying? That's what it would follow the course of most amendments? Because that's what I've observed is they never really get serious consideration.
No, I think this amendment should pass because I think most Americans understand that it's not normal for school board members to be attacked, for educators to be threatened, for their families to be threatened, and that's why we would ask that my amendment be made in order. Thank you. I yield back.
I have no problem with the amendment being made in order. The question is, what you said you assume it will pass. I guess I'd love to give you another opportunity, but if you're saying that you don't know whether you'll vote for the resolution of inquiry or not, if it carries your amendment, I'm just trying to understand if your amendment's in good faith.
Oh, the amendment is absolutely in good faith. I wish the resolution were.
If it were so amended, though, you intend to oppose the resolution anyway. Is that correct?
I didn't say that. I said I wish the resolution
Will you
was in
disclose
good
what you
faith.
intend to do? I take it you will not, which makes it pretty clear. I think the other, and so, look, there's no doubt that on an isolated basis, there have been some threats against school board members. And there's been gross rhetoric. It's really important for this Committee on the Judiciary to know the difference between the two. I was at a ceremony last night, which I thought had the pretty admirable theme of being devoted to supporting and preserving life in America. There were protesters outside the whole time who apparently don't want to preserve life, and they chanted really things I can't repeat here at the dais at us as we entered and left. I guess I can summarize it. F you fascists, they said, they sang over and over again as they pounded a drum. Now that's not very polite, but they certainly have a First Amendment right to it. The chairman opened this debate, and in the course of giving some examples, he spoke about an incident that occurred it was alleged to have occurred, I haven't seen a transcript, at the school board meeting in Orange County, North Carolina. Now, those who know, I went to Chapel Hill at University of North Carolina. It's in Orange County. It's the most leftist county in North Carolina, and the chairman of that school board is a leftist. And she reported that someone, that people that she said they wore, I guess, a caps that indicated they were members of the Proud Boys, or shirts and hats. That says 2 men in Proud Boys shirts and hats. One wore a stocking over his face. Well, of course, you know, things were being worn over faces. They were required to be worn. I never thought that was a really good idea, but they were required to be worn, which completely obscured his entire face for the whole meeting. Now, that's a little unusual, but it sort of makes me think about Portland. There's been no FBI nationwide memorandum on that one. Black bloc, but that's been widely respected by the left for some reason. Said the other one told our board during public comment that someone should tie rocks around our necks and we should throw ourselves in a river. I think they maybe have been referring to the Bible verse about one who does this to the least of these would better have millstones put around their neck and thrown into the river. And I can't remember precisely how that goes, but it's a Bible verse they were making reference to. But there's no threat in that language. There's no statement that the person speaking said, I'm going to tie millstones around your neck and throw you in a river. And that distinction is quite important. But in fact, what the amendment on its face does acknowledge is that there was coordination and communication between the White House and the National Association of School Boards to develop this theme of threats, when much of what is talked about is core First Amendment activity, whether we like the tone of the activity or not. It's really important to distinguish between the two. My time's expired.
Time of the gentleman has expired. For what purpose does the gentleman from Rhode Island seek recognition?
I move to strike the last word.
Gentleman is recognized.
Thank you. I want to thank the gentlelady from Pennsylvania for her amendment and for helping to focus the committee's attention on the very real issue of violence against school board officials and school officials in connection with the era in which we're living, where political violence seems to be becoming more and more common, and how dangerous that is for our country and our democracy and for the brave men and women who work in public education all across this country. But I am here to report to the gentlelady from Pennsylvania that this resolution has nothing to do with that, because of course this is about a made-up story that causes the Republicans to do big posters, because this made-up story about calling parents terrorists is so politically powerful. They've poll tested it, and they know it's really powerful. Even if it's not true, you just keep using it, and it will help you win, political points and maybe win elections. And they know that. They know it's actually not true at all, but it's valuable politically, and so they do big posters. I will guarantee you every Republican member on this committee is going to clip their remarks today. Tune in later tonight on Fox. You'll see it again, how they're defending parents who are being called terrorists by Democrats. All made up, but it's theater to produce a hit or a clip for television. So let me just remind everyone, as I've done, I think, at 4 other hearings, of the facts. This is made up because the memo that Mr. Jordan always makes reference to, which is dated October 20th, 2021, which I'd ask be made part of the record, actually makes no reference to parents being tagged as terrorists. In fact, the word parent isn't even in the memo. Then you have the testimony of Justice Garland under oath before this committee, and he said, and I quote, "I want to be clear. The Justice Department supports and defends the First Amendment right of parents to complain as vociferously as they wish about the education of their children, about the curriculum taught in schools. That is not what the memorandum is about at all, nor does it use the words domestic terrorism or Patriot Act. Like you, I can't imagine any circumstance in which the Patriot Act would be used in the circumstances of parents complaining about their children, nor can I imagine a circumstance where they would be labeled as domestic terrorists." I ask that be part of the record. And then in the report, in the memorandum, it talks about threats of violence or the use of violence against school board members and school board officials. So this is made up. Now, you don't have to take my word for it. There were 3 separate analyses, just to be sure, about this false claim. The first one was done by Fact Check, and it says, Attorney General never called concerned parents domestic terrorists. So the claim is false. Okay, that's number 1. I'd ask that be made part of the record.
Without objection.
Second fact check done by USA Today. Fact checked, FBI is not using threat tags on parents who protest at school board meetings. I ask that be made part of the record.
Without objection.
There's a third fact check if you really need to be convinced. No, the FBI isn't adding threat tags for parents who protest school boards. This is PolitiFact from November 19th, 2021. I'd ask that be made part of the record.
Without objection.
So this is not true. It's made up. It's an effort to try to politicize or take advantage of this issue to win. And it's really disappointing because, as Ms. Scanlon's amendment makes clear, this is actually a real problem with school boards and a real problem with the safety of individuals who are serving in the public school system. And it is, in my view, not only reckless and irresponsible, but deeply sad that rather than being serious about the rising violence at school board meetings, being stoked by people who think that's the correct way to respond to political disagreements, we have colleagues on this very committee who are continuing to promote something that just didn't happen because they think it will help them, putting their desire to get back into power over even the best interests of the people we serve. And I say that sincerely. This is a sad, sad use of this committee's time to again promote something which is simply not true. No matter how many times they say it, it doesn't change the facts. And so I urge you to support the amendment and defeat the underlying resolution and not be part of this ongoing charade, this ongoing false narrative that is intended to make people angry about something that simply didn't happen. And I yield back.
Gentleman yields back. Who seeks recognition? For what purpose does the gentleman from Texas seek recognition?
Move to strike the last word.
Gentleman is recognized.
Well, now that we've been liberal-splained, the narrative about what is actually going on by this administration, On September, let's talk about the facts. Let's talk about what's not made up, as the gentleman was just alleging about being made up. On September 29th, 2021, the National School Boards Association sent a letter to President Biden equating concerned parents voicing their opinion at school board meetings as domestic terrorists and urging the administration to exercise its authorities under the Patriot Act. News reports indicate that the NSBA coordinated with the White House and engaged for weeks leading up to this. Weeks leading up to this, that the NSBA coordinated with the White House this very specific allegation. We have, on October 4th, 2021, 5 days after the NSBA letter. The NSBA letter, the National School Board Association letter, by the way, which references specific examples, one of which is Scott Smith from Loudoun County, Virginia. One of which is Scott Smith from Loudoun County, Virginia. That is in the NSBA letter, which again we know to be factually true, that there had been coordination between the NSBA and the White House as emails evidence. The timeline suggests that the NSBA sent the letter on September 29th, and on October 4th, Attorney General Merrick Garland issued a memorandum that directed the FBI and U.S. Attorney's offices to address a purported disturbing spike in harassment, intimidation, and threats of violence at school board meetings. Let's talk about Scott Smith for a minute. Talk about all these things that are supposedly made up. My colleagues on the other side of the aisle allege. The National School Board Association sent this letter to the president. One of them, and in Virginia, an individual was arrested, another man was ticketed for trespassing, and that being Scott Smith. Why was this man so angry? This being an AEI article depicting exactly what occurred that fall. Why was this man so angry? It was because his 9th grade daughter had allegedly been sexually assaulted in a school bathroom by a gender-fluid, skirt-wearing boy. Now, that has now been adjudicated. And in fact, she was assaulted. And this father was angry. Now let's go forward. There are so many layers to this. The father in question, Scott Smith, on May 28, 2021, received a call asking him to come to the school because his daughter had been in a, quote, physical altercation. The school insisted they would handle the situation in-house. Police officers took this incident seriously. The school board then held a meeting to adopt a policy permitting bathroom access based on gender identity. Smith and his wife attended to voice their concerns. At that school board meeting, a school board member painted concerns about sexual assault as bigoted paranoia. After this exchange, Smith was approached and allegedly berated by a woman named Jackie Schwarm, a frequent poster in a Facebook group, Anti-Racist Parents of Loudoun County, a group that compiled a watch list with names, addresses, and employment information of parents who opposed woke school policies. Smith told the Daily Wire he tried to explain what happened to his daughter, that she was raped. And she looked me dead in the eyes and says, "That's not what happened." Smith further said that she noticed the name of his plumbing company on his shirt and said, "Oh, I'm going to ruin your business on social media," she said. This is what my colleague from Rhode Island says is made up. That's what my colleagues on the other side of the aisle say are made up. Sensing the situation could turn ugly, the police officers intervened. Days after the story was published, it received significant coverage on media websites, Fox News, National Review, Washington Examiner, Daily Caller. Contrast to Google search shows no coverage from CNN, NPR, Politico, ABC, NBC, CBS, or Education Week. The Washington Post reported that Loudoun parents were upset by revelations that the same assailant went on to allegedly sexually assault another girl at the school he was transferred to, which in fact happened. My colleagues on the other side of the aisle simply do not care. And they're perfectly fine empowering the Federal Bureau of Investigation to do what is demonstrably true, which is create threat tags in direct response to the National School Board Association, which, by the way, some 30 state school board associations have distanced themselves from and removed themselves from. I yield back.
Gentleman yields back. I recognize myself in support of the amendment. This amendment improves the underlying resolution by examining the role of violent white extremism, misogynistic extremism, far-right extremism, and anti-government extremism and attacks on schools, school board members, and teachers. The rapid rise in violent rhetoric and far-right domestic terrorism in this country has affected schools by radicalizing school shooters, energizing conservative extremists to intimidate, harass, and assault school administrators, and emboldening COVID-19 conspiracy theorists to attack teachers and torment students. In 2020, 66% of domestic terrorist attacks were from white supremacists. In 2021, 28 out of 30 domestic terrorism murders were committed by far-right extremists. But my colleagues across the aisle want the world to think this problem does not actually exist. Rather than fighting domestic terrorists, they would rather paper over the stories of innocent Americans and their families who live in fear and would rather point fingers at the Department of Justice. The underlying resolution is predicated on the fantasy that the problem is not far-right extremists attacking school board members, threatening teachers, and frightening children, but rather the Department of Justice somehow targeting nonviolent parents. Its supporters want you to forget the news stories, forget the evidence, and just listen to them. But no resolution blaming the DOJ can make the problem go away. It cannot undo the death threats or broken trust within communities. And it cannot erase the role of conservative media and far-right leaders in the fervor to physically and verbally bully school boards and teachers when civic discourse would be more appropriate. This amendment exposes the extremist ideology fueling many of the attacks on school officials. I encourage my colleagues to support it. And I will answer Mr. Bishop's question. If this amendment is approved, I will still oppose the resolution of inquiry, because the resolution of inquiry is so irreparable that even this amendment cannot repair it sufficiently as to justify support of it. I yield back. Who seeks recognition? For what purpose does the gentleman from Arizona seek recognition?
Move to strike the last word.
Gentleman is recognized.
I oppose the amendment. First of all, I want to point out a striking dichotomy here. The underlying resolution is dealing with school boards, and the amendment itself is expanded to basically any kind of action with regard to schools. So, for instance, the Mesquite Elementary School kidnapping plot of Vail, Arizona, not Tucson, but of Vail, Arizona, had nothing to do with the school board. It had everything to do with three crazies who went into the principal's office and did not kidnap her, but threatened to kidnap her, and were promptly arrested by local law enforcement officials. That's really kind of what you would expect to happen, is that the local law enforcement would be involved instead of federal officials. And we do know that, indeed, the National School Board Association did ask specifically for use of certain federal officials to get involved here. That's not make-believe, contrary to what the gentleman from Rhode Island suggests. On page 2 of the September 29th letter, and by the way, this letter being written after there's been collusion with the Biden administration and the NSBA, they specifically asked and said, quote, NSBA specifically solicits the expertise and resources of the U.S. Department of Justice, Federal Bureau of Investigation, U.S. Department of Homeland Security, U.S. Secret Service, and its National Threat Assessment Center. That's what they asked for. They didn't ask, they went beyond that. And why did they go beyond it? Because they also wanted the use of the Patriot Act, the next paragraph down. So when the gentleman from Rhode Island says they didn't do that, it's right in the letter. It's right in the letter. They want the federal government to impose and use the Patriot Act against parents who go to school board meetings. And what do we find out later from whistleblowers? Indeed, and this is, by the way, has been widely reported, except for by CNN and MSNBC, but it's been widely reported otherwise, that they used threat tags on parents who showed up at school board meetings. And why were the parents showing up at school board meetings? Protesting CRT and COVID-19 restrictions. That's why they were there. Now, what else do we know? We know that on September 29th, That's when the NSBA sent their letter, but that they had been in negotiations with the Biden administration before that ever happened. And I know that we heard AG Merrick Garland saying that, oh yeah, you should be allowed to protest, et cetera. We would never hinder it. Why do we know he said that? Because I was asking them questions to that effect. And he said, no, we don't view that as a terrorist threat. But we also had another attorney general from one of the districts in Washington State testify in one of my committees that they had been briefed. Yeah, they had been briefed on this, and they needed to be alert and aware of this. So the point is, we should be transparent here. This amendment doesn't get at the underlying amendment, and basically, we've already been told that the people who are supporting, that introduced the amendment, are not going to vote for the resolution even if the amendment gets on. So this is just a red herring, trying to change the very nature of the underlying resolution, which actually would provide us with the information that I think Americans would love to see and hear about, and that is the federal government's police apparatus spying on parents who do protest and have a right to First Amendment activity. Because if there's one thing that I agree with Merrick Garland on, it's that parents have the right to show up at school board meetings and protest and express themselves when they either agree or disagree with school board decisions, policies, and rhetoric. And I just want to close out by saying this. When I heard the chair and then the sponsor of this amendment talk about inflammatory language or inflammatory rhetoric, that's quoting each of them. One said inflammatory language, the other one said inflammatory rhetoric, and that it is extremist or radical to foster and go forward with this resolution. I just find it interesting because I find that there's radical rhetoric coming from the other side, including in those statements in and of themselves. When you start accusing people of radical rhetoric, you ought to look in the mirror. I yield.
The gentleman yields back. For what purposes the gentleman from Georgia seek recognition?
Move to strike the last word.
Gentleman is recognized.
Thank you. I rise in support of this amendment, and I seek to set the record straight. January 6, 2021 will never be forgotten, an infamous day in American history. MAGA Republicans descended upon the Capitol, engaged in an insurrection. They occupied the Capitol. 5 people were killed, hundreds injured, including hundreds of Capitol Hill police officers attacked and bludgeoned. It was a day that we'll never forget. And people on the local level at affected school board meetings, they won't forget the MAGA Republicans descending on their school board meetings after January 6th, like January 6th, disrupting meetings. It was a coordinated attack happening across the country. Americans won't forget about it. School board members, teachers, administrators subjected to violence, threats of violence, harassment, intimidation. And in response to that, the National School Boards Association sent a letter to the Biden administration seeking federal help. Things had gotten so far out of hand. And by the way, there's not one scintilla of evidence, either direct or indirect, that there was any coordination between the Biden administration and the National School Boards Association that caused that letter to be sent seeking federal assistance. And so in response to that request, Attorney General Merrick Garland sent a memo that is the subject of proceedings today in the Judiciary Committee, sent the memo indicating that there was going to be some coordination between the federal government and local governments to maintain order at school board meetings. And this was a coordinated attack on local school boards, the same way as the attack on January 6th. The same dark moneyed interests behind January 6th were behind this attack on school board proceedings across the country. It got to the point where even in my state, in my home state of Georgia, Cecilia Lewis was hired to a school district to serve as a diversity administrator. Nowhere in the description of her role or in her plan for the district was critical race theory ever mentioned. But Ms. Lewis, being a qualified contender for the job, accepted the position in the hope of making the district better for all of the students. Rather than welcoming her, parents in the district stalked and threatened her. They posted her location to Facebook. Once they had driven her out of her job, they followed her to her next job. They spread lies and rumors, making blatantly false claims about her plans for the district. These were MAGA Republicans. They made it their mission in life to make sure that this hardworking and qualified woman never found a job in education again. Ms. Lewis is only one of the many educators across the country who have been put in danger, intimidated and threatened and harassed due to MAGA Republican lies and hysteria. My colleagues on the other side of the aisle are more concerned with the parents who harass educators than they are about educators getting harassed. While our schools face a rising number of school shootings, failing infrastructure, lack of resources, and low salaries, among other things, my colleagues have decided that the educators who teach our children in the public schools, teach them about their multiplication tables, how to read and write, those are the enemy. 8% of the teachers are deciding to leave the profession every year, and we should be focused not on causing them to leave, but on supporting them, not villainizing them. They need our help. Discourse and dissent are important aspects of democracy, but harassment and threats are not. And this resolution will not help anybody. I'll again say that even the NSBA, which sought help, was forced after being intimidated and harassed and threatened to rescind their letter and apologize for even sending it. That's the level of violence and harassment and intimidation that this dark money directed at local school boards and their representatives.
Gentleman's time has expired.
With that, I yield back.
The gentleman's time has expired. For what purpose does Ms. Fishbach seek recognition?
Mr. Chair, to strike the last word.
Gentlelady is recognized.
Mr. Chair, I yield my time to Mr. Bishop.
I thank the gentlelady. Not only was the memorandum that Attorney General Merrick Garland ultimately issued coordinated with the White House, not only was the White House in coordination with the National Association of School Boards to do that, which Mr. Johnson just did, or a gentleman from Georgia just did exactly what is being done over and over and over. He characterized the National Associations of School Boards' subsequent analysis, independent investigation, and report on its own coordination with the White House. He says that report, or that admission and the retraction of their letter, was because of threats. He's doing exactly what's being done over and over and over, and what this resolution of inquiry seeks to fully uncover from the White House. Mr. Roy cited the example from Loudoun County. The chairman a moment ago cited Loudoun County as an example of a threat. Mr. Roy illustrated and provided great detail on how there was no threat. There was a parent who became unruly after a board member did unspeakable things to him in terms of a tragedy that his family had suffered. You characterize that as a threat so that you may justify putting criminal law enforcement forces on it. Same thing with the example that the chairman recited out of Orange County, North Carolina. I've pointed out already that there was no threat, but the article there goes further, describing what The chair of the board there talked about Proud Boys protesting at one of their meetings and a subsequent protest outside. She sought to criminalize that. The Democratic sheriff of Orange County, North Carolina, Orange County Sheriff Charles Blackwood, said no laws were broken. As the Proud Boys were on DOT right-of-way and not on school property, he said, while disrespectful, side note, exactly like the chanting I heard last night at the pro-life event. Back to the language here. Even though, he said, while disrespectful, their language did not go outside the bounds of free speech protected by the First Amendment. And yet, the Biden White House reaches out to the School Boards Association, says, among other things, be sure to put this stuff about the Patriot Act in your letter asking us for action, which they're going to get from the Attorney General of the United States, and indeed they did. And then months later, in the subject of a resolution of inquiry, the Democratic chairman of the Judiciary Committee characterizes all this again as being threats that justify the Attorney General's actions. How extraordinary. You know what you need? The gentleman from Georgia and the others who have spoken about white supremacists and MAGA threats, you need some red lights sort of on the walls behind you. You need to get sort of like the red speech, you know, the one the president gave, where he declared half of the country to be domestic enemies. You really need the red lights. Those add something. They add a real image that you would definitely want to look at.
Would the gentleman yield for a moment?
It's not my time to yield. It's the gentlelady from Michigan. Is that right? Minnesota. Sorry.
Would the
But I
gentlelady
think the
from
gentleman from
Minnesota
Texas
yield?
might have some more to add about the National Association of School Boards coordination with the White House.
And Mr. Chair, I would yield time to Mr. Roy.
I think the gentlelady, I think the gentleman from North Carolina. I would just add, very specific in response to the gentleman from Georgia's assertion that there, I think was, quote, not a scintilla of evidence of coordination. That was the gentleman's quote, not a scintilla of evidence. That in an article that I'd asked to made part of the record from Fox News, quote, in the September 14th, 2021 meeting of the NSBA Organization of State Association Executive Directors Liaison Group, they were informed there had been a meeting with White House staff that morning and that NSBA was preparing to send a letter to the president. Subsequently, on September 17th, the interim ED emailed notice to the State Association Executive Directors that indicated a letter requesting federal assistance would be sent. Another email exclusively sent to Fox News revealed that the NSBA had discussed the issues with the White House for weeks and that they altered the text of the letter to satisfy the curiosity of White House staff. Finally, in talks over the last several weeks with White House staff, they requested additional information on some of the specific threats, so the letter also details many of the incidents that have been occurring.
Those are Fox
There was
News
coordination.
reports?
I yield.
I yield to Mr.
Fox
Bishop.
News?
That is the epitome of politicizing criminal justice.
And with that, Mr. Chair, I yield back.
The time of the gentlelady's expired. For what purpose does the gentleman from California seek recognition?
I move to strike the last word.
Gentleman is recognized.
I'm going to start my remarks by showing a video of a little over a minute, and then I'm going to discuss what you're about to see on this video. If staff could play the video, that'd be great.
The heated debate over masks is escalating into physical altercations in various states across the nation. In Texas, a parent ripping a teacher's face mask during a Meet the Teacher event Monday, according to Eanes School District Superintendent Tom Leonard.
Let's just leave the mask wars out of the schools.
In a letter to parents and staff, Leonard calling it a physical assault on a teacher by a parent.
So you want to fight those wars, fight them somewhere else, but don't mess with the teachers. They have a hard enough job right now.
In Northern California, an elementary school teacher was hospitalized last week after a parent attacked him during a verbal argument over face masks, a district official says.
It was originally between the parent and the principal, and the teacher intervened at that point. The female principal intervened to say, hey, it's time to go. Like, you stop.
The teacher was stitched up for cuts and lacerations to his face. Police responded to the scene and are investigating. The parent was not arrested. The superintendent there sending a letter to parents saying assaulting a staff member will never be tolerated on any school campus.
Multiple teachers have been assaulted and exposed to threats of violence. A teacher was sent to the hospital by a parent who physically assaulted him. I don't care if you're a MAGA Republican or a member of the Red Cross. You do not have the right to engage in violence or threats of violence. I'd like to thank Congresswoman Mary Gay Scallon for her service as a school board member and all school board members across America. My wife is also a school board member, and last year, during the height of the pandemic, she received death threats so severe that the police department opened an investigation. Shame on any MAGA Republican who defends violence or threats of violence. Shame on any MAGA Republican who believes that it's okay to physically assault a teacher or school board official or school board member or have violent threats directed at them. Shame on any MAGA Republican who wants to intimidate law enforcement from investigating violence or threats of violence. Shame on any MAGA Republican who wants to intimidate the Department of Justice from investigating violence or threats of violence. Shame on any MAGA Republican who wants to promote chaos over community. Haven't we already had enough political violence in our country? I yield back.
Gentleman yields back. Who seeks, for what purpose does Mr. Gomer, the gentleman from Texas, seek recognition?
Just strike the last word.
Gentleman is recognized.
Thank you. It's very difficult to hear colleagues across the aisle saying things that we know are not true. And it's to say this is made up. We've heard it, and you know, this is from the report of the National School Board Association, the one that did coordinate with the White House. Their own report, these are Democrats, that's why they worked with the Biden White House. But on May 20th, 2022, the National School Board Association released a report that it had commissioned to examine these events. And the report offered new evidence on how the Justice Department coordinated with the White House to target parents. The report found that the first communications between the NSBA and the White House occurred on September 9th, and that the Biden White House closely coordinated with the NSBA on its letter to President Biden. On September 21st, 8 days before the NSBA letter, Mary Wall, a senior policy advisor to a man known as President Biden, emailed NSBA's interim CEO and executive director, Chip Slavin, asking, is there any way we can take a look at the letter in advance of release? In specific, I'm meeting with colleagues from other White House offices and the DOJ tomorrow morning. I mean, I don't know. Maybe somebody here knows Mary Wall and considers her an absolute liar constantly, but this was what the report found from the NSBA was asking for coordination. And anyway, she says she'd like it tomorrow morning to see if there might be any options we can pursue here. So if you have concrete recommendations in your letter, e.g. the threat assessment you mentioned, it would be good to know so I can include it in discussions. In response, Slavin emailed Wall a detailed summary of the contents of the letter, which included specific language about the Patriot Act and the use of, and wait for it, quote, domestic terrorism tools. The NSBA Commission report concluded, quote, the White House officials discussed the existence of the NSBA letter, its requests, and the contents of the letter with the Department of Justice officials more than a week before the letter was finalized and sent to President Biden. In other words, Justice Department officials knew that the NSBA would encourage President Biden to invoke the Patriot Act and domestic terrorism resources against parents. And I want to echo my colleague across the aisles. comments about violence. And I have so many people say, you know, they call us liars. Scott Smith was called a liar for truthfully saying his daughter was sexually assaulted. And he was called a liar, and it provoked him to violence, it appeared. And I just want to say that we cannot allow provoking words to cause people to resort to violence. We cannot be baited into that. Nobody should do that. And at times, it occurs to me, are these people calling us liars when we have the truth right in front of us to try to provoke violence again so that they can shut us down for good, arrest more people? Why do they keep saying things are not true that we have proof they are true? It's quite disconcerting, but I come back to this. We are to use the tools peacefully, as Dr. King found. The Weather Underground with violence didn't accomplish anything. Then they went to our universities, got tenured, started teaching teachers about how to teach Marxism in the school. And we cannot allow, no matter how bad things get, cause conservatives, parents concerned about their kids to resort to violence. Don't take the bait, no matter how many times Democrats call you liars. We know the truth, and we would encourage our colleagues to admit the truth, and we can work things out much more peaceably. I yield back.
Gentleman yields back. For what purposes, gentlelady from Texas seek recognition?
Strike the last word.
Gentlelady is recognized.
Let me rise in very strong support of the gentlelady from Pennsylvania's amendment to the Resolution 1238 that shocks me by its premise. Shocks me by its premise. I think Mr. Lieu has provided us with a visual, but those of us who've been in our various communities know that parents are loving and put their children first. Nothing in the administration, Department of Justice, characterized parents as terrorists. What was done is that as every child should be safe in their schools, and we had an incident in my district yesterday, thank God all are safe and that it was a hoax, but you should see the video of our children scurrying because they felt that there was, not felt, that heard that there was an active shooter. We want nothing but safety for our children, nothing but safety for our teachers and teachers' assistants, principals and otherwise. Know that by what is going on in Uvalde. But to have a resolution to even cast aspersions to suggest what this administration is trying to do to characterize parents in a certain way, look to the data of what is happening and what happened to school boards, universities, public educational institutions, employees dealing with violent extremism. That is the gentlelady's thought. If you want to get some information, as is evidenced in H.Res 1238, let us find out the kind of evidence of threats towards school boards, school boards, universities, public educational institutions, and their employees, inspired by violent extremism, misogynistic extremism, far-right extremism, or anti-government extremism, including Mesquite Elementary School kidnapping plot and the Oxford High School shooting. Or even to think of the moment when President Trump publicized, exaggerated, a legitimate, lawful entrance to his compound that had refused to abide by the law. Listen to these words. The FBI and the Justice Department have become vicious monsters controlled by radical left scoundrels, lawyers, and the media who tell them what to do. You people right there, and when to do it. They're trying to silence me, and more importantly, they're trying to silence you, but we will not be silenced. Vicious monsters. And what happened? A disturbed soul showed up, infused by the poison of this past president at an FBI office, and tragically, he is dead. How many more are going to jump out of the woodwork, moved by this kind of attitude? I ask unanimous consent to place this in the record, Mr. Chairman.
Without objection.
I ask unanimous consent to place the timeline the Justice Department criminal inquiry into Trump taking classified documents to Mar-a-Lago.
Without objection.
And the relevance of it? The relevance is that we in the federal government are not perfect. But there's a whole litany of dates: fall 2021, January 2022, February 9, 2022, February 18, 2022, April and May 2022, when the appropriate process was utilized to work with the former president. April 29, 2022, May 1, 2022, May 10, 2022, May 11, 2022, May 12, June 2nd. And the issue is that as long as we keep promoting that the government is an enemy of the people, as long as we call law enforcement vicious monsters, then you are creating the atmosphere that permeates over into the innocent place of where we teach children, the innocent place of teachers who want to do nothing but come to school and have beautiful crafts and artwork. I know, because I have 7-year-old grandchildren. Their greatest joy is to come home and show their spelling bee or spelling paper with an A on it, or their drawings. Calmness, harmony, and the administration's calmness, harmony, and the school board's investment in our children. And so to suggest that the Department of Justice wanted to do anything but just ensure that harmony and peace could go on, and that school boards would not have to get armed guards to protect them in the board meetings, because some had bought into the very language of the former president that FBI are vicious monsters and we are an enemy of the state, your government is an enemy of the people. Stop it. This amendment to this underlying resolution, which I absolutely oppose, is a vital evidence that there was reason to begin to ask the hard questions. I ask my colleagues to support the gentlelady's amendment and to oppose the underlying resolution. I yield back.
Gentlelady yields back. For what purposes, Mr. Tiffany seek recognition?
Move to strike the last word.
Gentleman is recognized.
Thank you, Mr. Chairman. So once again, we have a drive-by shaming that's happened in the room here. Someone comes in, the gentleman from California in this instance, comes in and says shame on MAGA Republicans. And you can see it. You can see the shiny ball at this point. It's repeat MAGA Republicans enough, and then the American people won't pay attention to the lawlessness on the southern border, which has virtually been erased. They won't focus on the crime that's happening across America. In my state, in Milwaukee, Wisconsin, I mean, it's just completely out of control. Does not want people focusing on that and doing this shaming. Let's be real clear. I know I've been consistent, and I believe my colleagues over here have been real consistent about this. We have denounced violence of all types. And yet, I don't hear the gentleman from California. I have not heard once where he has denounced the violence that happened in the summer of love of 2020. I mean, the country was on fire. I think about Madison, Wisconsin, Milwaukee, Wisconsin, Kenosha, Wisconsin. We saw it on our TV screens happening day after day right next door in Minneapolis. And yet, there's no denouncement of that violence that was committed. And let's be real clear. We should all denounce all violence of that sort rather than trying to do these drive-by shamings in a committee like this. I yield to the gentleman from Texas.
I think the gentleman from Wisconsin. I would just respond to the gentleman from Georgia who was scoffing at the citation of Fox News, which was quoting actual emails. So I'm going to insert those into the record. And I would ask that we be able to insert into the record the email from Mary Wall in the Executive Office of the President, referencing and saying, attached, please find an internal, saying, thanks for the heads up. Is there any way we can take a look at the letter in advance of release? And the response from the National School Board Association Executive Director saying, find the internal NSBA document attached. We use this document as a reference point. A follow-up memorandum from Viola Garcia to the State Association officers and executive directors in which she references the September 14th meeting that the Fox article referenced, meeting at the liaison group, that they were informed there had been a meeting with White House staff that morning and that NSBA was preparing to send a letter to the president. And then later that in response to the letter sent by NSBA on October 4th, the Attorney General announced in a memorandum widely shared throughout the U.S. Department of Justice that he was ordering all U.S. attorneys' offices, et cetera, et cetera. I'd ask that these be inserted into the record because these are the actual facts. That's what actually matters. and you have a news account on Fox News being scoffed at, but these are the facts of what happened in the direct and clear coordination between the NSBA, the White House, that then resulted in action by the Department of Justice issuing a memorandum that is still in place as we speak. And I would yield to the gentleman from Wisconsin to yield to the gentleman from Ohio.
Yeah, I just want, if I may continue.
Sure.
You know, I think about, it was cited that the USA Today gave this definitive article saying that, geez, this stuff just did not happen. Well, let me tell you about PolitiFact. Just recently, we showed that PolitiFact was completely wrong from a year ago when we exposed what happened with the evacuation from Afghanistan, where it was said, yes, these people were vetted. Well, it's clearly being shown by Inspector General's reports that that did not happen. We went back to PolitiFact and said, hey, you want to correct your story because it's proven that how you rated my statements as mostly false, they are true at this point. And we've been showing that, nah, we're not going to deal with that at this point. So you can cite that if you want to, but we've seen time after time how they don't get the facts correct, including with what happened in Afghanistan with the disastrous withdrawal, and now we've got a huge national security concern as a result of it. I yield to the gentleman from Ohio.
Thank the gentleman for yielding. I want you to go back to the memorandum that the Attorney General issued on October 4th of last year. Very first sentence. In recent months, there's been a disturbing spike in harassment, intimidation, threats of violence against school administrators, board members, teachers, staff who participate in the vital work of running our nation's public schools. When he testified, when the Attorney General testified, we asked him a simple question. What was the basis for you putting that first sentence in your memorandum? And what did he say? What did he say? He said it was the letter from the National School Boards Association that they have now said we regret and apologize for sending. The letter, as the gentleman from Texas just pointed out, they coordinated with the White House to use the words domestic terrorism in the letter and cite the Patriot Act. That's why we want the correspondence back and forth, in addition to the few emails we've been able to uncover, because it was all coordinated, and it was based on that coordinated letter that the Attorney General of the United States writes that first sentence. There was no other evidence. I'm going to take the word of a left-wing political organization that's been in cahoots with the White House to put this together because we think it's going to be to our political advantage. They found out it wasn't, and Glenn Youngkin's now the governor of Virginia because of it. But that's what they did. We want all the communications between the White House, the NSBA, and the Justice Department that put this whole scheme together.
I yield.
Would the gentleman's time has expired.
Would the gentleman yield?
For what purposes, the gentleman from from California seek recognition?
I move to strike the last word.
The gentleman is recognized.
And I'd offer to yield time to the gentleman from Texas.
I thank the gentleman from California. I would add, in addition to what the gentleman from Ohio was just discussing, that what we have in the form of the underlying resolution of inquiry is specific language that is, I would say, general in its nature of suggesting we want to know the truth of what was going on with the correspondence among the highest levels of the Executive Office of the President, the Department of Justice, that relates to the correspondence with the National School Board Association. There are no quotes in this resolution of inquiry. There are no specific allegations. There is simply a request for the information of the correspondence back and forth, because that's what we do when we want to conduct oversight. That's what we do rather than having to rely on outside organizations using the Freedom of Information Act to get the actual email correspondence, which we're just inserting into the record. We'd like to see the rest of it. The gentlelady from Pennsylvania offers this amendment, an amendment which goes through and offers alleged quotes. I'll take at the gentlelady's words and from some record that these quotes are accurate. I don't know, but you're inserting into the record alleged quotes. It doesn't say alleged, by the way. They just assert the quotes. And the gentlelady acknowledged the gentleman from North Carolina that she has no intention of supporting the underlying amendment or the underlying
The gentleman
bill.
yield for a moment.
Briefly,
Okay.
if she'll answer that question, will you support the underlying bill?
No, I don't support the underlying resolution
So
because
this
I
is a
think
red
it's
herring.
misguided. No, if by some reason it should pass, then I think it should be amended to reflect the fact that there were legitimate concerns,
And reclaiming my time, the underlying resolution of inquiry is asking for specific correspondence among the highest level decision makers. The gentlelady knows specifically why she's putting these quotes in there, so that she can make a political stunt rather than seeking truth. I'd be fine including that amendment, even though I think it's clearly designed to be biased, if the gentlelady would support the underlying measure, which she does not, and clearly does not. At the end of the day, the American people know what's going on here. Parents being targeted by federal officials. parents being targeted by the evidence in front of us of a direct coordination between and among, frankly, the White House, the Department of Justice, and the National School Board Association, which the gentleman from Georgia glosses over and decries as political. The National School Board Association memorandum from October 22nd, 2021, which should be inserted in the record if it has not been, in which they say, we regret and apologize for the letter. To be clear, the safety of school board members and other public officials, educators, and students are our top priority. However, there was no justification for some of the language included in the letter. We should have had a better process in place. And it retracts the letter. You have 30 states, 30 state school board associations which have distanced themselves from the National School Board Association, 26 of which they've withdrawn, flat out withdrawn from affiliating with the National School Board Association. That's a majority of the states of the United States of America in which their state school board associations have withdrawn from affiliating for the clear political engagement of this organization with this White House to target parents that yield to the gentleman from California, to yield to the gentleman from Ohio.
Thank you. Reclaiming my time. You know, I know there's been a lot of the word shame used here, but shame on everyone in this room if they are not sincerely looking for the truth. And it appears as though there are a number of people who are not looking for the truth, and that's the reason that I predicted earlier, and I predict again, that we will not see any of these resolutions allowed to seek the truth. And with that, I would yield to the gentleman from Texas briefly.
I come from a family of teachers. In fact, my mother was my 8th grade English teacher in a public school. But we've heard repeatedly from people across the aisle about the paragons of virtue that are all teachers. Most are. But I've also heard a woman who was saying, a young woman, that her life basically devastated because middle school teachers were telling her, if you ever look in the mirror and you're not pleased with what you see, then it means you're transgender. And she bought that, and it upended her life. And eventually she came back to being straight and realizing she was manipulated by teachers. And again, I would encourage people not to be provoked to violence, because the law has been and still is, provoking words are never a defense to a physical assault. Do not get provoked to violence, no matter how bad the words are.
Thank you, and I yield back.
Gentleman yields back. Does anyone else seek recognition? For what purpose does Mr. Jones seek recognition? Mr. Owens seek recognition?
I'd like to strike the last word.
Gentleman is recognized.
I'd like to give my time over to Ms. Tiffany.
I want to thank the gentleman from Utah. I want to go back and put a finer point on what the gentleman from Texas, just to my left, made in his comments. Of inquiry requesting the president to provide certain documents to the House of Representatives relating to the October 4, 2021 memorandum issued by the Attorney General entitled Partnership Among Federal, State, Local, Tribal, and Territorial Law Enforcement to Address Threats. It is so straightforward. This is just purely sunshine. This is what it's part of the purpose of this committee, from what I understand, is to provide sunshine to the American people. I did not get a chance to comment on the previous bill that was before us. That was even more simple, the request there. It's simply to ask for the copy of the affidavit. That was it. That's it. I mean, people are trying to muddle here what is being requested here. It is very straightforward, and it's documents the American people should see, because the American people are very fair at their foundations. Most American people, they just want, put the truth before us, and we'll make our conclusions from there. And yet we have this denial that's happening today and this obfuscation about what is being requested here today. It is very simple. Produce the documents that you have written in the administration and let the American people see them. Obviously, they have something to hide. I yield back to the gentleman from Utah.
I yield my time to Ms. Jordan. Yes.
I thank the gentleman for yielding. Again, the basic facts here is, I think, so plain. We know there was coordination prior to the letter ever being sent to the President of the United States between the White House, the School Board Association, and some element at the Justice Department. So they send the letter. 5 days later, the Attorney General of the United States issues a memorandum. The first sentence of the memorandum cites we're concerned about the intimidation and threats that are going on there. When he testified in front of this committee, we asked him what was the basis for the very first sentence in the memo that set up this apparatus that has now resulted, based on what whistleblowers have told us, over 24 parents being investigated by the FBI. We asked him what was the basis for that first sentence, and he said, the letter. The letter that has now been rescinded, apologized for, regretful, all kinds of, they can't backpedal enough. The letter that prompted this all, that caused more than half the states to leave this organization, that's all happened. And oh, by the way, here's another fact that I think is important. The two people who signed the letter from the National School Boards Association, the CEO is gone. The other individual got a plum assignment on, what's this? The National Assessment Governing Board. Joe Biden appointed her to that board, a board with only 5 people on it. She got appointed to that board on October 13th. So what's that? 9 days after the memorandum, based on the letter that she had sent. Well, Shazam, that sounds kind of scary, kind of unnerving to me that all happened. And so what do we have here? We have a resolution saying we'd kind of like to know all the other facts, all the communication going on between these folks that started this whole scheme to harass, and we know what they were trying to do. They were trying to, this is about First Amendment, chill the speech of moms and dads. And they thought, we all know this, they thought, because the gubernatorial candidate in Virginia said this, they thought it was going to help them win the Virginia governor's election. That's what they thought. Now, they thought wrong. Turns out, when Democrats say we think government is actually smarter than parents, lots of moms and dads say we disagree. And in Virginia, they said it in a big way on Election Day. But all this resolution, as the gentleman from Texas has pointed out, as so many of the members on this side have pointed out, is simply asking for, show us that communication, that we've sent countless letters. I mean, I don't know how many letters we've all signed to the AG, to the school boards, to the Justice Department, to everyone, to the we've sent them to we sent them to the Secretary of Education, and we've gotten zero information back. You would think this committee would want to get, as the gentleman from Wisconsin just pointed out, a little sunshine, a little transparency. That's, after all, our job. I would yield back. Thank you, the gentleman, for yielding.
I yield back.
For what purposes, Mr. Johnson seek recognition?
Move to, for the purpose of being able to introduce into evidence or into submission before this committee a final report on the events surrounding the National School Boards Association's September 29th, 2021 letter, wherein it is established that the letter there was no evidence of any coordination by the administration and the National Association of School Boards or any of its...
Mr. Chairman, and what time is
that objection? Who seeks recognition?
Well, Mr. Can I say a point of clarification? I didn't understand the gentleman from Georgia. Who made that assertion? Who was the report?
In the final report of the events surrounding the School Boards Association by the firm hired by the association to conduct an investigation and get to the bottom of what happened. And they found that there was...
Clearly disinterested.
That there was no... Yeah.
The gentleman...
So the report is now in the record for the public perusal.
Who seeks recognition? If there are no further speakers, for what purpose does Mr. McClintock seek recognition?
Thank you.
To speak on the amendment?
Gentleman is recognized.
Thank you. I mean, Mr. Chairman, what the Democrats seem to be saying here is that speech is violence. This fiction is then used to justify suppressing speech that they don't like. That's the crux of this discussion. Speech is not violence. Speech can be hateful, it can be disgusting, it can be bigoted, it can be false, but unless it is specifically and overtly inciting violence, our society has always tolerated it, confident that such speech can best be countered and corrected as long as everyone else is free to speak their minds. Kinder sentiments will always triumph over hateful ones. Truth will always triumph over lies. Sound opinion will always triumph over folly. You know, there used to be a common expression, sticks and stones may break my bones, but names can never hurt me. There was another, I might despise what you say, but I will defend to the death your right to say it. These sentiments are the principles of a free society. And I've made this point before. There are only two possible ways to resolve conflicts among us human beings. There's reason and there's force. We've built an empire of reason where people, all people, can express their opinions freely without fear of retribution by their government. Those who spew hate or folly or lies will naturally be contained by those who offer better sentiments, not by force, but by reason. People can hear all sides and draw their own conclusions, and we've based our entire form of government on the assumption that they will usually and ultimately will always arrive at just and sound conclusions. Our government was formed to protect this fundamental right of individuals to express their own views and the fundamental mechanism of democracy, which is to test all opinions, hold them up to every possible light, and then arrive at a common conclusion for our society. The worst thing that we can do is to suppress speech or punish people from expressing their opinions. Churchill spoke of such societies. He said they're afraid of words and thoughts. Words spoken abroad, thoughts stirring at home, all the more powerful because forbidden, terrify them. They make frantic efforts to bar out thoughts and words. They are afraid of the workings of the human mind. A state of society where men may not speak their minds, where children denounce their parents to the police, where a businessman or small shopkeeper ruins his competitor by telling tales about his private opinions. Such a state of society cannot long endure if brought into contact with the healthy outside world. He was speaking of the oppressions of the European dictatorships of the age, and the healthy outside world he was speaking of was ours, that beacon of freedom and liberty that is founded on the most fundamental right of every citizen to express himself. So I say again, speech is not violence. Only dictatorships treat it as violence, and they do so as an excuse to silence dissent and impose their opinions not by reason, but by force. That is antithetical to the principles of the American founding. I yield to Mr. Roy.
Would Mr. Roy yield for a minute?
I'm going to take this time for a second from the gentleman from California just to say that, first of all, I wish I could speak like the gentleman from California and express the views that he just expressed the way he just expressed them. And I'm always in awe of your ability to do so, and thank you for it, because it's really important. And I would just offer, and it bears repeating, in the context of speech and engagement in the public square, that the gentleman, Mr. Smith, whose daughter was assaulted in a restroom in the school he sent her to be protected in, was at the school board meeting in question and was then approached and was told that, quote, we've heard it several times tonight from our public speakers, but the predator student simply does not exist. And that after that exchange, Smith was approached by a woman who's a frequent poster in an anti-racist parents group in Loudoun County, and said they were compiling a watch list with names, addresses, and employment information of parents who opposed woke school policies. And Smith told the organization that he tried to explain what happened to his daughter, and she looked me dead in the eyes and said, that's not what happened. This to a man whose daughter had been assaulted, and he's at the school board meeting, and he's trying to have his grievance heard, and then he had the force of law enforcement, local law enforcement, step over his ability to speak there in the parents in the school board meeting, and now my colleagues on the other side of the aisle want to federalize that as domestic terrorism. That is the problem. I yield back.
Gentleman yields back. If there are no further speakers, the question occurs on the amendment. All in favor say aye. Aye. Opposed, no? No. In the opinion of the chair, the ayes have it. The amendment is agreed to. Are there any further amendments to the amendment in nature of a substitute? If not, the question occurs. The gentleman is recognized.
Move to strike the last word on the underlying, yeah.
Gentleman is recognized.
So I did want to add also into the record, and I'll submit these all later, all of these that I've been adding to the record, I'll bring to the chairman, that it bears noting that a Loudoun County judge just in the last week removed the fairly notably leftist Commonwealth's attorney from the case regarding his daughter's sexual assault, and the case regarding the dad with respect to the sexual assault of his daughter. The judge removed the liberal Loudoun County Commonwealth's attorney, Buddha Bibaraj, from an appeal case citing concerns over impartiality. So without objection, I'd like to insert that into the record.
Without objection.
And I think that this is just an important another piece of all of this, if you're following the facts on this and why this does in fact matter. And I'm not gonna repeat much of what we've already now, I think, gone over in the context of the amendment to the underlying measure. But I do want to just reiterate that we're talking about a request of information by the Congress of the United States, Article 1 from the executive branch, and that we are forced, in the absence of an agreement by our colleagues on the other side of the aisle, of the importance of Article 1, checking Article 2 to understand what occurred. We are forced to rely only on the Freedom of Information Act information that we're able to get through outside organizations, rather than carrying out our responsibility and duty in the House Judiciary Committee to oversee the Department of Justice in what should raise clear alarm bells, regardless of one's views about the motives of the Attorney General. We should at least be concerned on a bipartisan basis of a coordination of outside group at the Department of Justice and the White House that results in the highlighting of a particular parent, as was done in this particular memorandum, and then the threat tag being issued subsequent to that. And very clear coordination by the dates and all the evidence before us. We'd all agree, objectively, in a court of law, if you had this evidence, that we should all be concerned on a bipartisan basis about this. This is simply a request of information. I want all the American people who are seeing what's happening today, whether it was with respect to the affidavit, whether it's respect to this issue, whether it's respect to the state of the border, whether it's with respect to the consequences of the border and the various matters before us, these are simply requests of information from the executive branch by the Article 1 legislative branch. And with that, I will yield back.
Gentleman yields back. For what purpose does the gentlelady from Pennsylvania seek recognition?
I move to strike the last word.
Gentlelady is recognized.
Thank you. I'm grateful for the voice vote to affirm my amendment, and I just wanted to bring back the purpose of the amendment with respect to this resolution, because it's been suggested that the origin of the Department of Justice's concern about threats and violence against school board members somehow just came from the School Board Association, but in fact, it came from speech, and not the type of glowing speech, you know, the exchange of opinions in the public square, but speech like this. Brenda, I'm going to gut you like a fat effing pig when I find you. Your mother is an ugly communist whore. If she doesn't quit or resign before the end of the year, we will kill her, but first we will kill you. Or people who know who you are, they will effing see your head swinging from a pole. Now, this is not the exchange of ideas in the public marketplace of ideas. This is criminal conduct. This is threats to do bodily injury, threats to kidnap or injure or kill a person. That is criminal conduct. That is not protected free speech. And in the run-up to the Attorney General's interest in the subject, we saw those kinds of threats against school board members and educators proliferating across the country. And those threats were ugly, and they were not protected speech. They were criminal activity. I yield back.
The gentlelady yields back. For what purposes does Mr. Owens seek recognition? Oh, does anyone else seek recognition? In that case, the question is on the resolution. All those The question occurs on the amendment of state. The question occurs on the amendment and the nature of its substance.
I move to strike the last word.
The gentleman does move to strike
Yes.
the last word.
Yes.
Gentleman's recognized.
Thank you. Thank you, Mr. Chairman and Ranking Member Jordan, for including H.R. 1238 in today's markup. Although it is tragic that the Biden administration has treated parents as terrorists, I am grateful for the opportunity for my Republican colleagues and I to stand up and defend every parent's right to be involved in their children's education, to be informed of the curriculum taught in local schools, and to advocate for free speech and transparency in local school board meetings. I have a passion for education. My life's journey and opportunity to live my American dream has been defined by a quality education I received. It was not by happenstance, but by design of my parents and a proud segregated community in which I was raised. I see education as the great equalizer in today's new civil rights. As a youth, I was a beneficiary of the success of many HBCUs during the 1990s. It was an era, the 1900s, I'm sorry. It was an era when the Black community led the country in the percentage of men matriculating from college. I was taught of the success of the great academic pioneer, Booker T. Washington, who founded Tuskegee University in 1881. By the early 1900s, this university was producing more self-made millionaires than Harvard, Yale, and Princeton combined. My father received his PhD in agronomy from Ohio State in 1951. He went on to teach at an HBCU, Florida A&M, for 40 years. My mom taught middle high school. They represented an entire generation that was totally committed to their children's education. At the age of 16, my parents, with 5 children, drove a Chevy station wagon, pulling a pop-up tent 7,000 miles from Tallahassee, Florida to California, north to Canada, back to North and South Dakota, and then back home. For 2 months, they planned and shared with their children every national park, monument, cave, mountain, desert, and ocean along the way. As teachers who loved their profession and children, my parents' lives were all about education. I'm convinced my love for this country and my fellow Americans are rooted in that family trip. When I was elected to Congress, my top priority committee was a no-brainer, education and labor. I'm committed to give every parent, regardless of race, creed, color, or zip code, the opportunity to give their children the gift my parents gave me, confidence through critical thinking skills and opportunity to earn their American dream. This means improving access, granting choice, and elevating the level of learning in pre-K through 12 education. It means combining rigorous academics, parent transparency, prioritizing students instead of academic bureaucrats, and granting good teachers the innovative freedom boasted by financial incentives. When education is transformative, our students are transformed. The last few years has been difficult as parents have watched their children suffer intellectually and mentally as their education was put on hold for an entire year. They have discovered the death of stealth and insidious indoctrination that was being imposed on them. They have discovered that if they showed up to their own school board meeting objecting, they would be literally targeted by our own federal government in collusion with school administrative bureaucrats as domestic terrorists. The power of education is rooted in trust, respect, and having the same end game, the success of every child. It's based on transparency and collaboration between students, teachers, administrators, and school board members. In my position as ranking member of the Pre-K through 12 Subcommittee on the Education and Labor Committee, I have been proud to advocate for the Parents' Bill of Rights. This legislation makes it clear what should be obvious, that parents, not academic bureaucrats, have the God-given right to make decisions for their children. Parents to have the right to know what their children are being taught. Parents to have the right to be heard. Parents to have the right to see their school's budget. Parents to have the right to protect their child's privacy. Parents to have the right to keep their children safe. Parents to have the right to choose the best learning environment for their children. And parents and children to have the right for educational freedom. Unfortunately, many school districts have been ignoring the wishes of parents while special interest groups try to criminalize free speech. I urge a yes vote on H.R. 1238 to make a critical step in holding the Biden administration accountable. Show us the documents in which you've labeled parents' participation in school boards a threat. Recognize that parents have a right to sit at a seat at the table in every aspect of their children's education. I want to say real quickly to my friends on the other side of the aisle, parents and moms and dads are not stupid. They will not go with the idea of not believing their own lying eyes. They do not believe that Democrats did not want to defund the police, or that the Reduced Inflation Act is truly reducing inflation. And we'll see this in November as an accountant, a day to be reckoned with. Thank you, and I yield back.
The gentleman yields back. Now, if no one else wants to speak, the question occurs on the amendment nature of a substitute. This will be filed as amended. This will be followed immediately by a vote on reporting the resolution. All those in favor respond by saying aye. Aye. Opposed, no. No. In the opinion of the chair, the ayes have it. The amendment nature of a substitute is agreed to. Reporting quorum being present, the question is on the motion to report the resolution H.Res. 1238 as amended unfavorably to the House. Those in favor respond by saying aye. Aye.
Aye.
Those opposed, no. No. The ayes have it. The resolution is ordered reported unfavorably. Recorded vote has been requested, and the clerk will call the roll.
Mr. Nadler.
Aye.
Mr. Nadler votes aye. Ms. Lofgren. Ms. Lofgren votes aye. Ms. Jackson-Lee. Ms. Jackson-Lee votes aye. Mr. Cohen. Mr. Johnson of Georgia.
Aye.
Mr. Johnson of Georgia votes aye. Mr. Deutsch. Ms. Bass. Mr. Jeffries. Mr. Cicilline.
Aye.
Mr. Cicilline votes aye. Mr. Swalwell. Mr. Liu. Mr. Raskin.
This is Judiciary.
Ms. Dryapal.
Aye.
Ms. Dryapal votes aye. Ms. Dimmings.
As the chair recorded.
You are not recorded.
Chair votes aye.
Mr. Correa.
Mr. Thompson votes aye.
Clerk will report the vote.
Mr.
Madam
Correa.
Clerk, how am I recorded? There were 19 yeas.
Mr. Correa. Ms. Scanlon.
Yes, aye.
Ms. Scanlon votes aye. Ms. Garcia.
Aye.
Ms. Garcia votes aye. Mr. Neguse.
Aye.
Mr. Neguse votes aye. Ms. McBath.
Aye.
Ms. McBath votes aye. Mr. Stanton.
Aye.
Mr. Stanton votes aye. Ms. Dean.
Aye.
Ms. Dean votes aye. Ms. Escobar.
Aye.
Ms. Escobar votes aye. Mr. Jones. Ms. Ross.
Ross votes aye.
Ms. Ross votes aye. Ms. Bush.
Bush votes aye.
Ms. Bush votes aye. Mr. Jordan.
No.
Mr. Jordan votes no. Mr. Shabbat.
No.
Mr. Shabbat votes no. Mr. Gomert.
No.
Mr. Gomert votes no. Mr. Issa.
No.
Mr. Issa votes no. Mr. Buck.
No.
Mr. Buck votes no. Mr. Gates.
No.
Mr. Gates votes no. Mr. Johnson of Louisiana. Mr. Johnson of Louisiana votes no. Mr. Biggs. Mr. Biggs votes no. Mr. McClintock. Mr. McClintock votes no. Mr. Stubbe.
No.
Mr. Stubbe votes no. Mr. Tiffany.
No.
Mr. Tiffany votes no. Mr. Massey?
No.
Mr. Massey votes no. Mr. Roy? Mr. Roy votes no. Mr. Bishop? Mr. Bishop votes no. Ms. Fischbach? Ms. Fischbach votes no. Ms. Sparts?
Round 7.
Mr. Fitzgerald? Mr. Fitzgerald votes no. Mr. Bentz?
Mr. Benz votes no.
We're out there around
Mr. Bentz votes no. Mr. Owens? Mr. Owens votes no.
How is Swallow recorded?
Mr. Swalwell, you are not recorded.
Aye.
Mr. Swalwell votes aye.
Mr. Chairman, how is Ms. Demmings recorded?
Ms. Demmings, you are not recorded.
Demmings votes aye.
Ms. Demmings votes aye.
House Correa recorded?
Mr. Correa, you are not recorded.
Correa votes aye.
Mr. Correa votes aye.
How is Lou recorded?
Mr. Liu, you are not recorded.
Lou votes aye.
Mr. Liu votes aye.
How am I recorded?
Mr. Deutsch, you are not recorded.
Aye.
Mr. Deutsch votes aye.
Has Mr. Stanton been recorded? Clerk will report.
Mr. Chairman, there are 20 ayes and 18 noes.
The ayes have it. The resolution as amended is ordered reported unfavorably to the House. Members will have 2 days to submit views. Without objection, the resolution will be reported as a single amendment in nature of a substitute incorporating all adopted amendments, and staff is authorized to make technical and conforming changes. Pursuant to notice, I now call up H.Res. 1257, a resolution of inquiry directing the Secretary of Health and Human Services to provide certain documents in the Secretary's possession to the House of Representatives relating to the establishment of an emergency intake site in Erie, Pennsylvania, at the Pennsylvania International Academy to house the influx of unaccompanied migrant children for purposes of markup, and move that the committee report the resolution unfavorably to the House. The clerk will report the resolution.
H.Res. 1257 of inquiry directing the Secretary
Without
of
objection,
Health.
the resolution is considered as read and open for amendment at any point. I'll begin by recognizing myself for an opening statement. H.Res. 1257, introduced by Representative Mike Kelly, directs the Secretary of Health and Human Services to provide to the House of Representatives the contract relating to the establishment of an emergency intake site in Erie, Pennsylvania, at the Pennsylvania International Academy to house the influx of unaccompanied migrant children, as well as any documents related to the termination of that contract. Once again, this resolution is completely unnecessary. Had Representative Kelly reached out to the committee, we would have been happy to work together to obtain this contract. Instead, he has chosen to file this resolution. Upon seeing this resolution, my staff reached out to the Department of Health and Human Services and was able to obtain the contract in a matter of days. Without objection, I would like to submit the contract relating to the establishment of an emergency intake site in Erie, Pennsylvania, at the Pennsylvania International Academy for unaccompanied children for the record. Representative Kelly also asked for the termination notice. In communications with the committee, HHS has stated that the contract was not terminated, so there is no notice to provide. HHS merely allowed the contract to expire once the facility was determined to be unsafe for children due to certain code violations and a gas leak. Without objection, I would like to submit the natural gas system evaluation form, as well as the email from HHS staff with this information. Having already obtained all the necessary documents related to the resolution, it is my hope that we can quickly dispense with this resolution and not take up any more of the committee's time. I now recognize the ranking member of the Judiciary Committee, the gentleman from Ohio, Mr. Jordan, for his opening statement.
Thank you, Mr. Chairman. It is my understanding as well that Mr. Kelly has received some of the information. I think most of the information, if not all the information he's asked for. I know he still has a few additional questions that I think he looks forward to working with the majority staff to get those final questions answered. But I think we can move ahead with this one. And and get to the next resolution.
Without objection, all other opening statements will be included in the record. I will now recognize myself for purposes of offering an amendment in the nature of a substitute. The clerk will report the amendment.
Amendment in the nature of a substitute to H.Res. 1237.
Without objection, the amendment in the nature of a substitute will be considered as read and shall be considered as base text for purposes of amendment. I recognize myself to explain the amendment. This amendment in the nature of a substitute makes a single technical change to the resolution of inquiry by spelling the number 14 instead of using the actual number. No other changes were made to the resolution of inquiry. I urge all members to support the amendment, and I yield back the balance of my time. Are there any amendments to the amendment in the nature of a substitute? If not, the question occurs on the amendment in the nature of a substitute. This will be followed immediately. This will be followed immediately by a vote on reporting the question. All those in favor respond by saying aye. 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 Opposed, no. In the opinion of the chair, the ayes have it. The amendment in the nature of a substitute is agreed to. Reporting quorum being present, the question is on the motion to report the resolution H.Res. 1257 as amended unfavorably to the House. Those in favor respond by saying aye. Aye. Opposed, no. The ayes have it. The resolution is ordered reported unfavorably. Members will have 2 days to submit views. Without objection, the resolution will be reported as a single amendment in the nature of a substitute, incorporating all adopted amendments, and staff is authorized to make technical and conforming changes.
Have they called votes?
Okay. Then we'll break the votes.
I don't care. If you want to do it. Yeah, yeah. I can shorten mine too.
Pursuant to notice, I now call up H.Res. 1239, a resolution of inquiry directing the Attorney General to provide certain documents in his possession to the House of Representatives relating to the October 4th, 2021 memorandum issued by the Attorney General entitled Partnership Among Federal, State, Local, Tribal, and Territorial Law Enforcement to Address Threats Against School Administrators, Board Members, Teachers, and Staff for purposes of markup, and move that the committee report the resolution unfavorably to the House. The clerk will report the resolution.
H.Res. 1239.
Without objection, the resolution is considered as read and open for amendment at any point. I will begin by recognizing myself for an opening statement. Like the previous resolution of inquiry, H.Res. 1239 seeks information related to the Attorney General's memorandum directing the Department of Justice resources to address threats against school administrators, board members, and teachers and staff. Because it suffers from all the same flaws, focusing on an invented scandal rather than the real threat facing school officials across the country, I will oppose it for the same reasons and will not take up more of the committee's time on an opening statement. I urge all members to report the resolution unfavorably. I now recognize the ranking member of the Judiciary Committee, the gentleman from Ohio, Mr. Jordan, for his opening statement.
Thank you, Mr. Chairman. We've sent over 100 letters trying to get answers from this administration on this issue. We've sent them to the FBI, to the DOJ, to the U.S. attorneys, to the Department of Education. It's amazing how many agencies were involved in this targeting of moms and dads. You had the DOJ, you had the White House, you had the Department of Education, you had the Department of Homeland Security, and of course you had the FBI. We're simply asking for the stuff from the Justice Department. You all know the history here. We've debated this in the committee, but letter after letter goes unanswered. That's why we're actually pushing this resolution of inquiry. We hope that the majority will see the light and support us in getting information and answers to the questions where now, as I said before, we know of over 24 parents who were investigated by the FBI, none of them charged, but investigated by the FBI for simply showing up, speaking up on behalf of their son or daughter. And with that, Mr. Chairman, I would yield back.
Without objection, all other opening statements will be included in the record. I now recognize myself for purposes of offering an amendment in the nature of a substitute. The clerk will report the amendment.
Amendment in the nature of a substitute to H.Res. 1239.
Without objection, the amendment in the nature of a substitute will be considered as read and shall be considered as base text for purposes of amendment. I will recognize myself to explain the amendment. This amendment makes only technical changes to the underlying resolution, such as capitalizing the words memorandum and task force and using President Biden's complete middle name. Otherwise, the amendment makes no substantive changes. I yield back the balance of my time. Are there any amendments to the amendment nature of a substitute? For what purpose does Mr. Johnson seek recognition? Johnson of Louisiana.
Speak on the matter.
Gentleman is recognized.
Thank you, Mr. Chairman. Let's review the well-documented facts. Last September, the National School Boards Association and the Biden administration coordinated to send a letter requesting to treat parents at school board meetings as domestic terrorists. Yes, that is right. It's documented and it's a fact. The Biden administration thinks concerned parents who express frustration with radical policies governing their children's education somehow warrant counterterrorism resources. The NSBA and Biden administration letter infamously urged the government to use federal law enforcement to target concerned parents at local school board meetings and chill their protected First Amendment activity. One of the parents the NSBA cited in its letter is Scott Smith, who we've heard about today already. His only crime, so-called, was demanding that Virginia school board officials accept responsibility for the fact that his daughter was sexually assaulted in a school bathroom. New information from the NSBA shows that Justice Department employees coordinated with the White House directly, well in advance of sending that letter. And they likely knew and raised no concerns that the letter would urge the use of the Patriot Act to target parents. As a reminder, the Patriot Act, of course, we all know, was enacted after 9/11 to investigate and punish terrorists. Just 5 days after the NSBA's letter, Attorney General Garland issued a memorandum, and he directed the FBI and other Justice Department components to address a supposed, quote, disturbing spike in harassment, intimidation, and threats of violence, unquote, at school board meetings. Of course, that disturbing spike was never backed up with any evidence at all. Thanks to whistleblowers, we now know that the FBI quickly operationalized counterterrorism tools against moms and dads. On October 20th, 2021, the FBI's counterterrorism and criminal divisions created an EDU officials threat tag. That was the threat tag that would be applied to all school board-related investigations. 2 days later, the NSBA issued a formal apology for its letter, disavowing its characterization of concerned parents as villains and withdrawing the request for counterterrorism resources. They were exposed, so they hung Merrick Garland out to dry. And to this day, Attorney General Garland has yet to rescind the memorandum. Given that the underlying basis for his order has been rescinded, we all have been wondering here, why hasn't the order itself? Parents voicing their concerns at school board meetings are not domestic terrorists. That's why we have the placards here. We have to remind our Democrat colleagues of the obvious. Given the Biden-Garland DOJ's track record of inviting news cameras along to kick in the doors of their political opponents, you can bet that if there was a single parent in this country who posed any real threat to any single school board member, we would all know about it. It would be constantly broadcast on CNN and MSNBC and the rest. So let's be clear. The request for counterterrorism resources has now been withdrawn, and there is no evidence that parents pose any particular threat to any public officials. And yet, Judiciary Committee Republicans have repeatedly called on Attorney General Garland to rescind his memo, and we've sent over 100 letters now requesting information and documents regarding the investigation and the use of that threat tag. To date, all we have received from the Justice Department and the FBI are half-page response letters and exactly 0 requested documents or substantive information. It is simply unacceptable for the Biden administration to continue using federal domestic terrorism resources to target American parents. The use of these resources chills protected First Amendment activity, as these parents now rightfully fear that their advocacy for their children could result in a visit from federal law enforcement. I urge my colleagues to join me in asking for these documents so we can finally get to the bottom of this administration's utter disregard for the rule of law. I remind my colleagues again, this is clearly within the jurisdiction and the very important responsibility of the Judiciary Committee of the U.S. Congress. This is our role. I yield to the ranking member.
Thank the gentleman. Well said. And he raises a critical point. There's a fundamental question here. In all these meetings going on between the White House, the FBI, the Justice Department, and the School Boards Association before they sent the initial letter that prompted this, in all those meetings, did the White House suggest or encourage that the Patriot Act domestic terrorism language be included in the initial letter? Did the Justice Department suggest or encourage that? Or if they got an advance copy Did they object to it? Did they raise concerns? Those are pretty fundamental questions. I think a lot of people would, I think the American public would like the answers to. What was really going, who made the decision to put that in? Was it suggested by the White House and Justice Department, Homeland Security to put that language in the letter that's now been rescinded? Those are important questions that we'd like the answers to. Thank the gentleman. Yield back.
The time of the gentleman has expired. We have votes on the floor, but there are quite a few people who have not yet voted. Is anyone else seeking recognition? We could sneak one more in before going to votes. For what reason does the gentleman seek recognition?
Move to strike last word.
You are recognized for 5 minutes.
Thank you. I couldn't help but have to revisit the Vail, Arizona so-called kidnapping incident that was part of the amendment of one of my colleagues across the aisle. I find it interesting because I actually talked to people who live in the Vail district and have been very closely associated to that issue. And so I also went back and I said, I'm going to read all the local reports. And what I thought was interesting was the principal actually invited those 3 individuals into her office. They had a discussion. They terminated the discussion. The 3 refused to leave at first. So she said, I'm going to call the police. They then left, and guess what? They weren't charged with kidnapping. They were charged with trespass, misdemeanor trespass. And the way so many of these things end up, it was local law enforcement that took the appropriate action there. It wasn't the federal government. It was the local law enforcement. So, on September 29th, the NSBA sent a formal letter to the White House after there had been apparently some negotiation going on between the administration and the NSBA. And the letter supposedly, and we've seen it, was emphatic, begging the Biden administration to come in and intervene, bring federal law enforcement. It encouraged them to use the Patriot Act against parents. But most of the incidents that were even cited by the NSBA in their own letter to justify the federal intervention didn't even escalate to bringing charges or arrests having been made on the local level. And yet, without any evidence, Merrick Garland, relying solely apparently on their negotiations pre-letter and post-letter, decided that they were going to say that there's a disturbing spike in harassment and go forward and try to intervene and try to federalize these issues and make parents the targets of federal law enforcement, even with a threat tag. And the ultimate crux of what we're doing here is we're simply saying, will you please answer our questions? That's all. If you guys on the other side, I mean, if you think that everything was on the up and it's appropriate, what problem do you have with transparency? We're simply asking for transparency. Answer our questions, provide us the information, show us that we're wrong. And you can't. You refuse to do it, as do the various federal officers and agencies that we've requested this information from. It's that simple. Just support transparency, support the legislative branch and our oversight duty. That's all we're asking. That I'll yield back.
The gentleman yields back. There are a series of 7 votes on the floor now. The committee will stand in recess until immediately after the last vote. Immediately after the last vote, all members will please return to the committee meeting. The committee stands in recess. The committee will come back to order when who seeks recognition? Does anyone else seek recognition? If no one else seeks recognition, we can go to a vote.
Mr. Bishop?
Yes, Mr. Chairman, I seek recognition.
Gentleman is recognized.
You know, we've talked a good bit today about the apparent politicization of the FBI, and I think it worth spending a couple of minutes to talk about one other thing that has emerged in the last day by virtue of the filing of a motion in limine by Special Counsel Durham in the prosecution of Igor Danchenko. Those who paid close attention will know that Igor Danchenko was identified, albeit 3 years after the fact, as the primary subsource in the Christopher Steele dossier, the fiction, the pile of garbage on which was erected about 3 years of harassment of President Trump's administration by the FBI. Here's what's emerged. FBI, I first interviewed Mr. Danchenko about the dossier in January, I believe it was January 25, 26 of 2017. They learned that, you know, by that time they knew the substance of the dossier was garbage, knew it conclusively. And of course we know that the FISA applications continued after that point based substantially on the dossier. Well, what we learned in the motion in limine just filed by Durham is that following that interview in January 2017, in March of 2017, the FBI designated Mr. Danchenko a confidential human source, an informant to the FBI. And he remained under that status from March of 2017 until October 2020, the same month in which Durham's investigation became designated a special counsel, and of course 1 month before the 2020 election. The best theory for, now some people have pointed out that that means that after they knew he was a liar, the FBI paid Igor Danchenko as an informant for 3 years. But it's much worse than that, because it begs the question, and only one analyst I've seen has answered this in a plausible way, and his name is Hans Monkey. I guess that's how you pronounce it. But he has a piece out, I think, today that makes clear that once Igor Danchenko was designated a confidential human source, an informant by the FBI, his identity could be withheld from the Nunes investigation and from Congress and from any discovery of anyone associated with Congress, because under the sources and methods exception to what is disclosed to Congress. So, you know, I know I'm off topic in a way from the subject matter of the school board issue, except it goes to the Attorney General, and it's about the conduct of the FBI in that case. And again, all of these things, it's sort of like the Whitmer kidnapping plot, or the Fednapping plot as some call it, that I tried to ask questions about and of course got no answers for how the FBI had put that together and what the FBI's actions were in that, of course, in which ultimately a jury acquitted some defendants on the basis of entrapment. But this is part of the pattern. Crossfire Hurricane, the way that was covered up by the FBI, this is part of the cover-up that allowed Crossfire Hurricane to continue over a period of years and to avoid all accountability for everyone involved. But this is the tale of Igor Danchenko. We're going to see him prosecuted, I understand, next month. But the American people are waiting for accountability. It ought to be, under these circumstances, it ought to be clear to everybody on this committee that reasonable inquiries, that obtaining documents about another manipulation by the FBI, another, and by Attorney General Garland, another inexplicable, unjustifiable attack on the American people using the special status and powers of the Justice Department and FBI needs to be fully uncovered. It's time for the cover-ups to end. It's time for the cover-ups to end. And they're going to end in the next Congress. I'm quite confident. And with that, I'd offer to yield to anyone else seeking time. And seeing none, I yield back.
The gentleman yields back. Who seeks recognition? For what purpose does the gentleman from Ohio seek recognition?
Speak on the resolution.
The gentleman is recognized.
Yeah, I'm just going to underscore what the gentleman from North Carolina pointed out. This news broke yesterday so the FBI knows that Danchenko is a liar. He's lied to them. And yet they go ahead and make him a confidential human source. And the information I hadn't picked up on that my friend and colleague just pointed out is, and when they made him a confidential human source, they thereby hide him from the discovery process or information that then Chairman Nunes would be able to get, or anyone could get who's investigating. I mean, think about that. So they made a decision to use American tax dollars to hire a guy that they know is a liar, who then further lied to us, I think. And when they did all that, they were hiding it from the Intelligence Committee, from even, I would assume, figuring out the scheme and the process they were implementing. Is that accurate, Mr. Bishop?
The gentleman yield, it is accurate. And there's another element, of course, as I said, from the Nunes Committee, from the investigations going on in Congress, but actually also another thing. Remember the multiple FISA applications that were made on the predicate of the substantial amendment. They denied forever that the dossier featured prominently. Turned out it certainly did when the Inspector General's report came out. But this features into that too. So if they knew that means, in other words, it's not just some sort of passive oversight that they somehow continue to apply in signatures, but they're taking steps to conceal those things that would have undone the scheme while that was being done.
And then, if I could follow up, and then when the Justice Department, the previous Justice Department, makes Mr. Durham a special counsel, designates him in that category or status, they say the timing just happens to be, that's when they drop Mr. Danchenko as a confidential human source. Is that right?
Exactly.
And what's the significance of that, in your opinion, as a guy who's practicing all kinds of law? What's the significance of doing it and the timing associated with that?
I think the answer was that by that point in time, they got it undone before an election happened, and they would get another Trump administration to discover it. They could let it go, but they knew the damage was done. It had persisted. Yeah. The concealment had persisted for the entire Trump administration. And of course, if gentlemen will, so they're lying to Congress, or they're concealing information from Congress. They're concealing information affirmatively from the FISA court. Yep. Remember the FISA court saying that the FBI had manifested an institutional
17 errors and omissions, and they had someone who actually altered evidence and lied directly to the court.
An institutional lack of credibility,
yep.
A lack of I forgot what the term, but truthfulness, forthcomingness.
Mm-hmm.
And so that the question becomes, what has this committee done to uncover the bottom of that, to make sure that's discovered? That is fundamental oversight. And this committee runs from it under the majority rather than dealing with its responsibility to see to it that institutions needing reform get the reform they need.
And I guess the whole point, and I appreciate the gentleman bringing it up, the whole point is this provides context, provides a framework for evaluating this whole issue of why we want information regarding the school board's fiasco and the process and scheme that was put together to target parents, why we're asking for those over 100 letters we've sent, why we're asking for that information. I hope we can pass this one. I don't think we're going to. I think the majority is going to be against it, but I would yield back, Mr. Chairman.
The gentleman yields back. Who seeks recognition? No one else seeks recognition. Question occurs on the amendment in the nature of a substitute. This will be followed immediately by a vote on reporting the resolution. All those in favor respond by saying aye. Aye. Opposed, no. In the opinion of the chair, the ayes have it. The amendment in the nature of a substitute is agreed to. Reporting quorum being present, the question is on the motion to report the resolution, H.Res. 1239, as amended unfavorably to the House. Those in favor respond by saying aye. 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 Opposed, no. No. The ayes have it. The resolution is ordered reported unfavorably. Recorded vote is requested. The clerk will call the roll.
Mr. Nadler.
Aye.
Mr. Nadler votes aye. Ms. Lofgren? Ms. Lofgren votes aye. Ms. Jackson Lee? Mr. Cohen? Mr. Johnson of Georgia? Mr. Johnson of Georgia?
Aye.
Mr. Johnson of Georgia votes aye. Mr. Deutsch? Ms. Bass? Mr. Jeffries? Mr. Cicilline?
Aye.
Mr. Cicilline votes aye. Mr. Swalwell?
Aye.
Mr. Swalwell votes aye. Mr. Liu? Mr. Raskin?
Aye.
Mr. Raskin votes aye. Ms. Jayapal? Ms. Demmings?
Aye.
Ms. Demmings votes aye. Mr. Correa?
Aye.
Mr. Correa votes aye. Ms. Scanlon?
Aye.
Ms. Scanlon votes aye. Ms. Garcia?
Aye.
Ms. Garcia votes aye. Mr. Neguse?
Aye.
Mr. Neguse votes aye. Ms. McBath? Ms. McBath votes aye. Mr. Stanton?
Aye.
Mr. Stanton votes aye. Ms. Dean?
Aye.
Ms. Dean votes aye. Ms. Escobar? Mr. Jones? Ms. Ross?
Ross votes aye.
Ms. Ross votes aye. Ms. Bush?
Bush votes aye.
Ms. Bush votes aye. Mr. Jordan?
No.
Mr. Jordan votes no. Mr. Shabbat? Mr. Gomert?
No.
Mr. Gomert votes no. Mr. Issa?
No.
Mr. Issa votes no. Mr. Buck?
No.
Mr. Buck votes no. Mr. Gates? Mr. Johnson of Louisiana? Mr. Johnson of Louisiana votes no. Mr. Biggs?
Hello?
Mr. McClintock? Mr. McClintock votes no. Mr. Stubbe?
No.
Mr. Stubbe votes no. Mr. Tiffany?
Tiffany? No.
Mr. Tiffany votes no. Mr. Massey?
No.
Mr. Massey votes no. Mr. Roy? Mr. Bishop? Mr. Bishop votes no. Ms. Fishbach?
No.
Ms. Fishbach votes no. Ms. Sparts? Mr. Fitzgerald?
No.
Mr. Fitzgerald votes no. Mr. Benz? Mr. Benz votes no. Mr. Owens? Mr. Owens?
No. No. Always no.
Mr. Owens votes no.
How is Lou recorded?
Mr. Liu, you are not recorded.
Lou votes aye.
Mr. Liu votes aye. Mr. Shabbat, you are not recorded. Mr. Shabbat votes no.
Clerk will report.
Mr.
Has every member voted who wishes to vote? Clerk will report.
Mr. Chairman, there are 17 ayes and 15 noes.
The ayes have it. The resolution is amended as ordered reported unfavorably to the House. Members will have 2 days to submit views. Without objection, the resolution will be reported as a single amendment in nature of a substitute incorporating all adopted amendments. The staff is authorized to make technical and conforming changes. Pursuant to notice, I now call up H.Res. 1241, a resolution of inquiry directing the Secretary of Homeland Security to provide certain documents in his possession to the House of Representatives relating to immigration enforcement and border security for purposes of markup, and move that the committee report the resolution unfavorably to the House. The clerk will report the resolution.
H.Res. 1241 of inquiry directing.
Without objection, the resolution is considered as read and open for amendment at any point. I will begin by recognizing myself for an opening statement. H.Res. 1241, introduced by Representative McClintock, directs the Secretary of Homeland Security to provide to the House of Representatives certain documents in his possession relating to immigration enforcement and border security. More specifically, it asks the Secretary to produce all documents relating to the number of individuals on the no-fly list or the Federal Bureau of Investigation's terrorist screening database who have been encountered by United States government personnel at the southwest border or between ports of entry since January 20th, 2021, and the number of those individuals who have been released from the Department's custody. I oppose this resolution for a number of reasons. To begin with, this resolution is completely unnecessary. The minorities had no problem obtaining briefings or information on this issue. Just last year, Minority Leader Kevin McCarthy asked for and received a classified briefing relating to allegedly concerning individuals apprehended along the U.S.-Mexico border. Further, in July, the Biden administration began posting some of this data publicly on the Customs and Border Protection website. If my colleagues simply look at CBP's website, they would see the number of individuals accounted by Border Patrol who are on the FBI's terrorist screening database for the last five and a half fiscal years. This fiscal year, 16 people in the screening database have been encountered by Border Patrol on the northern and southern border. This accounts for 1/1000% of the people encountered by Border Patrol. This is a lower percentage than those encountered in fiscal year 2018 under the Trump administration. This resolution attempts to paint all migrants as terrorists and should be soundly defeated. If members are concerned about specific security risks, they can ask for a classified briefing on this issue instead of taking up the committee's time with this resolution. I oppose this resolution, and I urge all members to report it unfavorably. I now recognize the ranking member of the Judiciary Committee, the gentleman from Ohio, Mr. Jordan, for his opening statement.
Thank you, Mr. Chairman. Maybe I'll just start before I get into the statement that's prepared here. Just remind the committee what happened when the Secretary of Homeland Security testified in this room to us when the minority party asked the Secretary what we thought was a pretty basic question. We asked, it's been reported that there are 42 individuals who've come across the border who are on the terrorist watch list. What is the status of those individuals? And I would just remind the committee of the Secretary's answer. He said, I don't know. And I'm like, what do you mean you don't know? You're the Secretary of Homeland Security. Your job is to protect and secure and make safe the country here. And he didn't know. And he had to get back with us and get an answer. So that is our concern. We want all the information related to these folks who've been apprehended. Democrats have embraced an open borders policy and maligned our hardworking men and women at Customs and Border Patrol. But one thing we should be able to agree on is that people who mean to do harm to our country and our way of life should not be able to bypass screening and simply walk into the United States. We should all want to make sure that terrorists are not sneaking across the southern border, but so far we've not been able to get any meaningful information to assure us that the Department of Homeland Security is taking this problem seriously. Here's what we know. In April, news reports emerged that 2 men from Yemen had been arrested at the southwest border who were identified on the terrorist watch list. Then in August of 2021, Rodney Scott, then the head of the Border Patrol agents, told us that, quote, their national security mission is paramount right now despite, this is one of our agents telling us, despite the Biden administration focus on migrant families and children. Scott went on to tell the agents, if a national security crisis, immigration is just a subcomponent of it right now. It's just a cover for the massive amounts of smuggling going on across the southwest border to include aliens on the terrorist screening database at a level we have never seen before. That's a real threat, close quote. January 2022, Scott told the Texas Public Policy Foundation during a panel discussion that U.S. Border Patrol agents stopped 14 non-citizens who were named on the terror watch list and tried to sneak into the United States. On January 27th, this year, an investigative journalist for Deadline Detroit told Fox News that a, quote, Lebanese-born national listed on the FBI's terrorist watch list was released in the United States after crossing the border illegally. April 18th, Fox News reported that a FOIA request confirmed that 23 people who came across the border between January 2021 and December 31st, 2021 appeared on the terrorist screening database. And we know that so far this fiscal year, U.S. Border Patrol has encountered 66 illegal aliens between ports of entry on the southwest border who were listed on that terrorist screening database. This is 51 more than all of the last fiscal year and is exponentially more than in any other recent fiscal year. Think about it. 66 individuals on the terrorist watch list that attempted to get into our country by crossing the border illegally just this year. And those are just the ones we know about. When asked by committee Republicans during the April hearing, as I referred to earlier, the status of these aliens and whether they were detained or released in the U.S. Interior, Secretary Mayorkas couldn't even provide an answer. Given that there have been nearly 1 million known gotaways along the southwest border since President Biden took office, there's good reason to believe that individuals listed in the terrorist screening database have crossed illegally into the United States. It's our job to make sure the DHS has taken this matter seriously. We hope that they are fulfilling their responsibility to protect the homeland, but given this administration's attitude about border security, we're not so sure. That's why it's imperative that the department provide us with our requested information. I hope you support it. I yield back.
Without objection, all other opening statements will be included in the record. I now recognize myself for purposes of offering an amendment in the nature of a substitute. The clerk will report the amendment.
Amendment in the nature of a substitute to H.Res. 1241.
Without objection, the amendment in the nature of a substitute will be considered as read and shall be considered as base text for purposes of amendment. I recognize myself to explain the amendment. This amendment in the nature of a substitute makes a single technical change to the resolution of inquiry by spelling out the number 14 instead of using the numeral. No other changes are made to the resolution. I urge all members to support the amendment and yield back the balance of my time. Are there any amendments to the amendment in the nature of a substitute? For what purpose does Mr. McClintock seek recognition?
I'll just speak on the resolution, Mr. Chairman.
Gentleman is recognized.
Thank you. The chairman is correct that the Department of Homeland Security posts the number of suspected terrorists encountered on the border. That's all they report. They do not report what's happened to those suspected terrorists, where they are, what they're doing, or even who they are. So far this fiscal year, they have reported encountering 66 illegal aliens between ports of entry on the southwest border who are listed on the terrorist screening database. By the way, that is more than double the total of 26 encountered in the previous 5 years combined. Let me repeat that. They've encountered more terrorists on our southern border in the last year, in fact, twice as many more in the last year as they've encountered in the previous 5 years combined. You know, we asked Secretary Mayorkas if he had released any of the terrorists who were encountered crossing the border illegally this fiscal year into the United States. He sat right at the witness table before us in this committee room and couldn't give us an answer. I want you to think about that. The Secretary of Homeland Security won't tell us whether the agency that he leads has deliberately released terrorists into our country. Aside from those that we've encountered, there is no doubt that aliens listed in the terrorist screening database have crossed illegally into the United States as part of the nearly 1 million known gotaways along the southwest border since President Biden took office. Now, the unconditional surrender of Afghanistan to the Taliban by this administration resulted in the release of more than 5,000 of the most dangerous terrorists on the planet that we were holding at Bagram Air Force Base. We know what happened to one of those 5,000 plus terrorists. One of those terrorists detonated the bomb 10 days later that killed 13 U.S. Marines at Kabul airport. We don't know where the other 5,000 are. But I think it's a pretty good bet that more than a few of them have made their way into our country through our open southern border, and we need to know. If these terrorists, unleashed because of the president's policy in Afghanistan, are able to make their way into this country because of the president's immigration policy. I'm afraid that the price paid by innocent Americans will be horrendous. The mass bombings we read about in other countries may soon arrive on our shores, and if they do, responsibility will rest squarely with the president, his administration, and his apologists in both public office and the press. H.Res. 1241 directs the Secretary of Homeland Security to provide Congress with documents, communications, and other information in his possession regarding illegal aliens who've been encountered by the U.S. government personnel between ports of entry along the southwest border since January 20th, 2021, who are listed on the no-fly list or the terrorist screening database. And if you won't listen to us, I wish you'd listen to others. Nolan Rappaport authored an op-ed piece in The Hill today in which he raises some of these very concerns. I'd remind you, he was the Democratic consultant on the Immigration Subcommittee of the House Judiciary Committee. I'm afraid the terror is coming. For all we know, it's already on its way. For all we know, it's already here. For God's sake, secure our border, rigorously enforce our immigration laws, fully vet any asylum claims of refugees before they're admitted into our country, or else be prepared. Be prepared to bear the full condemnation of history for the terrors you will have set in motion against your country and your countrymen, betraying the highest trust in the land. I yield back.
Gentleman yields back. Who seeks recognition? For what purpose does Mr. Shabbat seek recognition?
Move to strike the last word, Mr. Chairman.
Gentleman is recognized.
Thank you, Mr. Chairman. Well, I'm sure it comes as no surprise to anyone that when you allow your borders to be open and the administration in power shows no interest in securing that border, that individuals from around the world, from across the globe, are going to try to take advantage of that lack of security. The staggering numbers of illegal crossings, they speak for themselves, but what should keep everyone on this committee, at least, up at night, because it's our responsibility to protect the American people, is the number of internationally recognized terrorists that have been cited at the border. We know that an increasing number of aliens listed on the terrorist screening database are being encountered along the southwest border and released by DHS into the U.S. No doubt even more such aliens are part of the hundreds of thousands of gotaways known by Border Patrol to have entered the U.S. without even being encountered. The data from U.S. Customs and Border Protection, it's shocking. And make no mistake, these record-setting numbers will continue well into the future if stronger action isn't taken by the Biden administration to secure our border once and for all. Perhaps the root of the problem is that the administration doesn't want to know the full extent of the threat. Not knowing means not having to face the truth of what's really at stake here. Those of us on this committee who were here during 9/11 remember what it was like to grapple with grief and loss after terrorists came to American soil to do us harm. One of our top priorities must be to utilize the tools provided to us under the Constitution to ensure the safety and security of the American people. And that starts with securing our southern border. That ought to be the priority, at least one of the priorities of the people on both sides of the committee. It's clearly not at this point, at least on one of the sides. Mr. Chairman, I'm not opposed to immigration. None of us, to my knowledge, on this side of the aisle is opposed to immigration. In fact, I'm sure most of us on this committee agree that our nation has benefited greatly from the hard work of the men and women who've come to America by following our legal immigration system, Anyone who has been to a naturalization ceremony, and I've been to many of them, has seen firsthand the dedication and the patriotism in the eyes of our newest citizens. But illegal immigration, that's a different story entirely. First and foremost, we must realize that no good comes from allowing such an egregious humanitarian crisis to continue at our southern border and turning a blind eye to those who come here with malicious intentions. Currently at our southern border, it's utter chaos. And if you talk to some of the folks on this committee, they see it virtually every week when they're back in their district, because some of them are literally right on the border. We're all border states now because these folks go all over the country. In fact, we put them on a bus or on a plane, and we ship them across the country at this point in time. This resolution of inquiry introduced by my friend Mr. McClintock simply asks for information to assist the committee in its oversight of federal immigration enforcement in order to assess how DHS is enforcing existing immigration law. That's the least we ought to do. Congress and the American people have a right to know the number and mechanism of removal or expulsion for aliens listed in the terrorist screening database who were encountered entering illegally along the southwest border. Unless, of course, you're gullible enough to buy the patently absurd position of Alejandro Mayorkas or Kamala Harris that the southern border is secure. I mean, it's hard to believe. I mean, he said it when he was before this committee. I really couldn't believe that Mayorkas would have the nerve to say the border's secure. I mean, that's an absurdity. Anybody believes that there's either something wrong with them or they're so gullible that they believe anything. And then for the Vice President of the United States to repeat that again, that this administration has secured the border, that's just ludicrous, absolutely ludicrous. The safety and security of American families deserves nothing less than a secure border, and this committee ought to be instrumental in doing that. With that, Mr. Chairman, I yield back to balance my time.
Gentleman yields back. Does anyone else seek recognition? If not,
Yeah, I want to say something.
Mr. Chairman, I do. Biggs, this is Biggs, I'm up here.
for what purpose does Mr. Biggs seek recognition?
Move to strike the last word.
Gentleman is recognized.
I appreciate that, Mr. Chairman. And you know, this resolution offered by my friend, Mr. McClintock, is so common sense, so rational. It's hard for me to believe that there's any opposition in this committee. It really is. Look, we have an example of this. In January, our federal law enforcement, ICE, released a suspected terrorist that Border Patrol had stopped. The FBI had flagged this guy. His name is Isnaro Garcia Armado. He was turned loose near Yuma, Arizona on April 18th. All he was given was a GPS monitoring device, and away he went. They actually had to go out and try to find him again, and they were fortunately able to find him. But the problem is this. Since October of last year, just through July, you have 2 million illegal aliens have come into this country. In Yuma, they are able to turn back maybe 10%. It's right around 10 or 11%. The balance, 89 to 90%, are released into the interior of the United States of America. The vetting process is incomplete because the only way we find out about them if they've got a criminal record or should not be in here on the face of it is if they have a U.S. criminal history or if they are in some kind of database that we have access to. Like occasionally there'll be an Interpol hit. That doesn't happen very often. In the meantime, Yuma, Arizona, small city, not even quite 100,000 people, 1,000 people are encountered every day. That does not include those who get away, the known gotaways and unknown gotaways. Mr. McClintock is exactly right. You're flirting with danger, and he's correct. By so doing, you will face the disapprobation of history should anything happen. And quite frankly, when you start looking at the numbers of people that are on the watch list that we have actually stopped and arrested, and there are dozens and dozens of them, and you realize that there's 1 million people that have been able to enter our country that we have no idea where they come from, where they're going, and whether their intentions are malevolent or benign, then you have to understand that you are just playing with a matter of time. It's nothing I wish for this country, but what I do hope for this country is that we have an administration that no longer will lie to the American people and say the border is secure. I hope that we have an administration that will quit encouraging people to come into this country illegally between ports of entry. I hope that our administration will start standing up and standing behind the men and women of CBP and ICE. I hope that we have an administration that says we have 1.2 million people who have had due process and have been ordered removed from this country, and we are going to start removing them. In other words, I hope we have an administration that will change its ways and start enforcing the law, because all of these things that I've mentioned have led to almost 5 million people illegally entering the country since Joe Biden took office. It is unbelievable to me that there would be anybody opposed to requiring the DHS secretary who has committed malfeasance of office and has sat in our committee and under oath said that there was operational security of our border when he knows that statutorily he is exactly wrong. I support this resolution of Mr. McClintock. It is the right thing to do. And with that, Mr. Chairman, I yield back.
The gentleman yields back. For what purpose does Mr. Jordan
Just speak on the resolution.
Gentleman is recognized.
Thank you, Mr. Chairman. I just want to commend the previous two gentlemen and the good work they've done on this issue, Mr. McClintock and Mr. Biggs. Mr. Biggs mentioned, used the phrase flirting with danger, and I think that's appropriate. And I guess I want to go back to something that Mr. McClintock mentioned. I guess I mentioned it as well, but when you have the Secretary of Homeland Security ask the question, when the question was posed to him, what is the status of the people that you've encountered on the border, not to mention the ones they didn't encounter, but the ones you've encountered on the terrorist watch list, what is their status? As Mr. McClintock pointed out, yeah, we know who the numbers, but he couldn't answer, and they don't report what happens to him. When we asked him that question, and he said he didn't know. Again, I think, what does it say about the guy in that job that he didn't? Remember, we asked the majority for over a year to bring in Secretary Mayorkas for a hearing on the chaos on our southern border. You would think when he comes, he would be prepared to answer that question, knowing that it's going to get asked. What's the status of the people you've encountered, illegals entering our country who are on the terrorist watch list? You would think he would be more prepared than to have the answer he gave us, which was, I don't know. So that's why we want to get this information. I mean, I think he was genuinely, I don't think he was trying to hide anything. I think he just didn't know, which is concern in and of itself to me. There are some things he said that I think he's just not giving us the straight scoop. As the gentleman from Arizona pointed out, when the secretary said the border is secure, but we obviously know it's not. When the borders are, the vice president said the border is secure, we obviously know it's not. But when Mr. Mayorkas also said we are executing our plan, I think he was being square with us then. I think their plan is to not have a secure, but not to have a border. But I think the real question is, how can the Secretary of Homeland Security give us that kind of answer when you pose such a fundamental, basic question, and he's not prepared to answer, doesn't know the status of the people he's encountered who are on the terrorist watch list? I find that frightening and just underscores why this information is so important and why we're asking for it. With that, I'd yield to the gentleman from North Carolina.
I thank the gentleman from Ohio, and I think to put a finer point on, or another point on it, the Secretary has appeared here and has said that the border is secure repeatedly. President Biden insists that the border is secure. Vice President Harris appeared on Meet the Press on September 11, I believe. And here's Chuck Todd's question. Chuck Todd, no not always eager to hold the Biden administration to account for sure, says, we're going to have 2 million people cross this border for the first time ever. You're confident this border's secure? Vice President Harris says this. We ought to listen to this very carefully. She says, we have a secure border in that that is a priority for any nation, including ours and our administration. Hear that again. We have a secure border in that that is a priority for any nation, including ours and our administration. One thing about Vice President Harris, God bless her, is that she sometimes sort of thinks out loud. And when she gave that answer, what she's saying is, I know the right answer that I have to give is that we have a secure border. Because any nation needs a secure border. So she says, in that is a priority. So in other words, that's got to be the right answer. And yet she also knows that when the gentleman's asking her about the 2 million people who've come into the country without any process, it can't possibly be secure. And given that level of detachment, that kind of devoted insistence on something being opposite what everybody knows it to be, there is no such thing as a secure border for the United States. And we are at grave risk from people who are terror watch listees and from the thousands and thousands and thousands of gotaways who no one knows. And we're reminded with September 11 passing that it only took 20 onboard jetliners to do the damage to this country that was done. And this administration is not just derelict, it is intentional in its allowance of this to continue. And what did the chairman say? The chairman said he didn't want to stigmatize migrants as terrorists. Happy to echo and inculcate the notion that half of American citizens are domestic terrorists, but we wouldn't want to make that suggestion about migrants, even when the terror watch list guys are coming across at will. Time's up.
Who seeks recognition? Gentleman yields back. Who seeks recognition? Does anyone else seek recognition? In that case, the question occurs on the amendment nature of a substitute. This will be followed immediately by a vote on reporting the resolution. All those in favor respond by saying aye. Aye. Opposed, no. In the opinion of the chair, the ayes have it. The amendment nature of a substitute is agreed to. Reporting quorum being present, the question is on the motion to report the resolution. H.Res. 1241 is amended unfavorably to the House. Those in favor respond by saying aye. Aye. Opposed, no. The ayes have it. A recorded vote is requested. The clerk will call the roll.
Mr. Nadler.
Aye.
Mr. Nadler votes aye. Ms. Lofgren. Ms. Lofgren votes aye. Ms. Jackson-Lee. Mr. Cohen. Mr. Johnson of Georgia. Mr. Deutsch. Mr. Deutsch.
Yes. Aye. Yes.
Mr. Deutsch votes aye. Ms. Bass.
Aye.
Ms. Bass votes aye. Mr. Jeffries. Mr. Cicilline.
Hello. Oh, sorry.
Mr. Cicilline.
How is the chairman recorded?
Chairman is recorded aye.
I vote aye.
Mr. Cicilline votes aye. Mr. Swalwell.
Pursuant to the notice.
Someone,
Mr. Swalwell. Mr. Liu.
Swalwell said aye.
Mr. Swalwell votes aye. Mr.
Aye.
Liu. Mr. Raskin. Ms. Jayapal.
Do you see where the unmute and the,
Ms. Demmings?
yeah, there.
Aye.
Ms. Demmings votes aye. Mr. Correa? Ms. Scanlon?
Aye.
Ms. Scanlon votes aye. Ms. Garcia?
Aye.
Ms. Garcia votes aye. Mr. Neguse? Ms. McBath? Ms. McBath votes aye. Mr. Stanton?
Aye.
Mr. Stanton votes aye. Ms. Dean?
Aye.
Ms. Dean votes aye. Ms. Escobar?
Aye.
Ms. Escobar votes aye. Mr. Jones? Ms. Ross?
Ross votes aye.
Ms. Ross votes aye. Ms. Bush?
Bush votes aye.
Ms. Bush votes aye. Mr. Jordan? Mr. Jordan votes no. Mr. Shabbat? Mr. Shabbat votes no. Mr. Gomert?
No.
Mr. Gomert votes no. Mr. Issa? Mr. Buck? Mr. Gates? Mr. Johnson of Louisiana? Mr. Johnson of Louisiana votes no. Mr. Biggs?
No.
Mr. Biggs votes no. Mr. McClintock? Mr. McClintock votes no. Mr. Stubbe?
No.
Mr. Stubbe votes no. Mr. Tiffany?
No.
Mr. Tiffany votes no. Mr. Massey? No. Mr. Massey votes no. Mr. Roy? Mr. Bishop?
No.
Mr. Bishop votes no. Ms. Fishbach?
No.
Ms. Fishbach votes no. Ms. Sparts? Mr. Fitzgerald?
No.
Mr. Fitzgerald votes no. Mr. Benz?
No.
Mr. Benz votes no. Mr. Owens?
No.
Mr. Owens votes no.
Mr. Jeffries? Mr. Raskin?
Votes aye.
Mr. Raskin votes aye.
Mr. Chairman, how am I recorded? Hank Johnson?
Mr. Johnson, you are not recorded.
I vote aye.
Mr. Johnson of Georgia
Oscar
votes
Ray
aye.
recorded.
Mr. Chairman, Congressman Issa, how am I recorded?
Mr. Correa, you are not recorded.
Correa votes aye.
Mr. Correa votes aye. Mr. Issa, you are not recorded.
Issa votes no.
Mr. Issa votes
Chair,
no.
how is Lou recorded?
Mr. Liu, you are not recorded.
Lou votes aye.
Mr. Liu votes aye.
Mr. Chairman, how is Ken Buck recorded?
Mr. Buck, you are not recorded.
I vote no.
Mr. Buck votes no.
Are there any members who wish to vote who have not voted? The clerk will report.
Mr. Chairman, there are 19 ayes and 16 noes.
The ayes have it, and the resolution as amended is ordered reported unfavorably to the House. Members will have 2 days to submit views. Without objection, the resolution will be reported as a single amendment in nature of a substitute incorporating all adopted amendments, and staff is authorized to make technical and conforming changes. Pursuant to notice, I now call up H.Res. 1249, a resolution of inquiry directing the Secretary of the Interior to transmit certain documents to the House of Representatives relating to the impact of illegal immigration on federal or tribal lands for purposes of markup, and move that the committee report the resolution unfavorably to the House. The clerk will report the resolution.
H.Res. 1249 of inquiry
Without
directing...
objection, the resolution is considered as read and open for amendment at any point. I will begin by recognizing myself for an opening statement. H.Res. 1249, introduced by Representative Blake Moore, directs the Secretary of the Interior to transmit to the House of Representatives certain documents relating to the impact of unauthorized immigration on federal or tribal lands. For example, the resolution asks the Secretary to produce all documents related to the current level of environmental damage to federal protected and tribal lands along the southern border. I oppose this resolution for a number of reasons. First, I find it interesting that my colleagues are now concerned about the environment. But where was their alarm when construction of the border wall by the prior administration was wreaking havoc on the environment and causing serious environmental damage to federal protected and tribal lands along the southern border? Did they ever express concern or demand an environmental impact study? Of course not. Instead, they pushed the administration to waive every environmental regulation it could to build an unnecessary border wall. Environmental consequences be damned. This resolution is also unnecessary. The minorities had no problem obtaining briefings or information when they have asked. When the Secretary of Homeland Security testified before this committee just a few months ago, the issues discussed in this resolution were never raised once. Rather than take up the committee's time, my colleagues can easily request this information from the Department of Interior's Congressional Liaison Office, which is the normal and appropriate route for these types of requests. I urge my colleagues to oppose this resolution, and I urge all members to report it unfavorably. I now recognize Mr. Gomet for an opening statement.
Thank you, Mr. Chairman. This resolution of inquiry would direct the Secretary of Interior to provide Congress with important information about what's happening at the southern border. As everyone here knows, whether they will admit it or not, illegal immigration has a devastating effect on communities throughout our country, and especially those on the southern border, as many of us have seen firsthand for years. Illegal immigration is wreaking havoc on our economy, and it's a leading cause of illegal drugs, including fentanyl, coming into our country, which is estimated to have killed over 100,000 Americans that some of us care about in this country. Something that is less understood is the effect that aliens illegally crossing our borders are having on the environment. On their journeys into our interior, aliens routinely trample on and otherwise harm the habitats of wildlife and vegetations. They also leave large quantities of trash and other refuse. Reports indicate this has taken a devastating toll on the environment near the border. To answer the chairman's question, some of us have been raising Cain about the issue of the effect on the environment. We've seen what it's been doing in Arizona. We've seen the devastation by no one going into wilderness areas with motorized vehicles except all of the people bringing in illegal aliens, bringing in drugs, bringing in munitions. According to the Center for Immigration Studies, the Arizona Department of Environmental Quality estimates that over 2,000 tons of trash are discarded at the Arizona border every year. These we've seen, we've brought pictures, we've raised the issue, especially in natural resources. This ROI would help us better understand the nature of this problem. The ROI would direct the Secretary of Interior to produce information related to the current level of environmental damage to federal protected and tribal lands along the southern border. It would also direct the Department of Interior to provide Congress with information about the costs associated with the cleaning up of the refuse left behind. In addition to information about the environment, the ROI would also require the Secretary to provide information related to the illegal drugs and how cartels are taking advantage of the Biden administration's lax approach to border security. We saw that cleaned up during the Trump administration as the wall was being constructed, the environment was being protected, but all that's gone. To that end, it would provide Congress with information in the possession of the Interior Department related to drug smuggling and cartel activity. The Biden administration's failure to secure the border is an issue that affects every one of our communities and is something we should all want to better understand. Mr. Chairman, this is an important resolution that would provide us with much needed information about these discrete aspects of the toll being taken by illegal immigration on our southern border and the environment. I urge colleagues to support the resolution.
Without objection, all other opening statements will be included in the record. I now recognize myself for purposes of offering an amendment in the nature of a substitute. The clerk will report the amendment.
Amendment in the nature of a substitute to H.Res.
Without objection, the amendment in the nature of a substitute will be considered as read and shall be considered as base text for purposes of amendment. I will recognize myself to explain the amendment. This amendment in the nature of a substitute makes a single technical change to the resolution of inquiry by spelling the number 14 instead of using the actual number. No other changes were made to the resolution of inquiry. I urge all members to support the amendment, and I yield back the balance of my time. Are there any amendments to the amendment in the nature of a substitute? Who seeks recognition? Nobody seeks recognition. The question occurs on the amendment in the nature of a substitute.
Mr. Chairman, I would like to be recognized. I'm sorry, I was trying to.
Mr. Biggs seeks the gentleman is recognized.
Thank you, Mr. Chairman. I move to strike the last word and.
Gentleman is recognized.
Thank you so much. When the chairman said that Republicans obviously do not care about the environment because we didn't express anything when President Trump was trying to build a fence across 2,000 miles of border, he must not have been paying attention to some of the language that I was using and I know many others were using. We do care about the environment. We care about the concerns with the tribes as well. I'm sure the chairman's unaware that across Arizona's border, there's one tribe that has 62 linear miles that border the international, that sits on the international boundary with Mexico. The federal government for decades has respected and provided deference to tribal leaders who don't want a border wall like we have elsewhere in Arizona that President Trump has put up. Instead, long periods of time to negotiate, to get some kind of technical aspects to allow cameras to go in and sensors. There's an additional tribe down in Yuma that has about 10 miles, linear miles right on the border as well. They also don't want a fence, but they allowed Normandy barriers there. The problem in both places, though, is that those are the vast areas that through which literally tens of thousands of illegal aliens cross every year. And in so doing, they also end up crossing natural preserves along our border area. They've cut roads. They've left tens of millions of pounds of garbage and human refuse and litter in those areas. I am astonished when I hear someone say that we have not tried to deal with environmental problems, that we should not worry about a report. The reports regarding environmental garbage and trash coming from Interior and Homeland Security are few and far between. It speaks to people who haven't actually been down to the remote areas of the border to see otherwise pristine areas, beautiful areas of desert, destroyed by the refuse there. I have been speaking extensively about the need for our environmental activists who disagree with me on everything else to come forward and stand up and speak about the environmental damage and wreckage that is happening in the Arizona desert and in some of the mountain areas along the border Mexico. I'm astonished that the chair would oppose this. This is a transparency measure. If there is the data, then let's get it from Interior and DHS and let's get it to the entire American public. They need to understand that not only is it a humanitarian crisis along the border, it is an environmental crisis as well. There is violence that happens on the border. Our border is controlled by cartels. We need to regain control of our borders. We need to also work with environmentalists to make sure that this stops. You should see it. I invite you to come down with me, Mr. Chairman. I can take you to place after place, literally hundreds of places that have untold amounts of refuse, human refuse and debris, destroying our habitat. I invite you to come with me. And then maybe you will also share my concern and my passion for trying to get this information. I support this resolution. It is necessary. And with that, Mr. Chairman, I yield back.
Gentleman yields back. Who else seeks recognition? For what purpose does Mr. Benz seek recognition?
Strike the last word.
Gentleman is recognized.
Mr. Chair, I've joined my colleagues, Mr. Biggs' remarks. And just for purpose of the record, I would like to share some numbers. I think we can assume, without concern of folks thinking otherwise, that the million people that got away in some fashion or another crossed the land I'm about to describe. So the acres of federal land within 100 miles of the Mexican border, the Bureau of Land Management, 12 million acres. The Department of Defense, 5.7 million acres. The United States Forest Service, 3.7 million acres. The Bureau of Indian Affairs, 3.5 million acres. The other 2.2 million acres, and these are all, the Bureau of Reclamation, 21,000 acres. Total federal acres, 30 million within 100 miles of the Mexican-American border. I think it's clear that the people of the United States have reason to be concerned about the impact on these millions of acres, 30 million to be exact, that the unstopped flow of immigrants is causing. Also, I want to go back to some remarks that were made about the wall. I have here, Mr. Chair, 5 pages, single-space list of the different types of creatures, endangered, threatened, candidate species like to be affected by construction of Trump's border wall. This list was created in 2017. I'm guessing things haven't changed much, but we have 5 pages of the types of creatures and plants that would be affected by the construction of Trump's border wall. Could we assume safely that the million people that have come across unapprehended this year may have had some impact on these 5 pages of endangered and threatened candidate species? Could we assume that? And I'd like to offer this for the record, Mr. Chair.
Without objection.
I would normally take the time, but it's late in the day, to read down through some of these creatures, but don't you think the American people should know the type of impact that this so-called secure border, the folks crossing into the United States are having on their property? That's what this resolution asks for. It's pretty simple. What better thing to ask these agencies for than the conditions that are being created by another agency, that is Homeland Security, failing to stop the traipsing of these people across these sensitive and public lands. Mr. Chair, it's sad, isn't it? 5 pages of endangered and threatened candidate species, all of whom were called out in extreme detail when it came to the wall, but are being ignored now. For what reason? Are they being less hurt? Unlikely. With that, Mr. Chair, I yield back.
Gentleman yields back. For what purpose does Mr. Owens seek recognition?
Thank you, Mr. Chairman. I move to strike the last word.
Gentleman is recognized.
I'd like to thank my colleagues and fellow member of the Utah delegation, Blake Moore, for introducing both H.R. 1249 and H.R. 1250. I encourage members to support these resolutions of inquiry. Illegal immigration is harming the public lands along our southern border. Reports show that immigrants who cross the southern border leave trash and other refuse behind on their trek. Although Utah is not a border state, 64% of Utah's federal lands owned by the federal government. We know what it's like to have federal government control our lands, and it comes with problems. In the case of the southern border, we must hold the Biden administration accountable for the decision to leave an open border. These resolutions of inquiry will bring transparency and help us better manage our lands. Thank you, and I'll yield back.
Gentleman yields back. Does anyone else seek recognition? In that case, the question occurs on the amendment nature of a substitute. This will be followed immediately by a vote on reporting the resolution. All those in favor respond by saying aye. Aye. Opposed, no. In the opinion of the chair, the ayes have it. The amendment nature of a substitute is agreed to. Reporting quorum being present, the question is on the motion to report the resolution H.Res. 1249 as amended unfavorably to the House. Those in favor respond by saying aye. Aye. Opposed, no.
No.
Recorded vote has been requested. The clerk will call the roll.
Mr. Nadler.
Aye.
Mr. Nadler votes aye. Ms. Lofgren. Ms. Lofgren votes aye. Ms. Jackson Lee.
Aye.
Ms. Jackson Lee votes aye. Mr. Cohen. Mr. Johnson of Georgia.
Johnson of Georgia votes aye.
Mr. Johnson of Georgia votes aye. Mr. Deutsch. Ms. Bass.
Aye.
Ms. Bass votes aye. Mr. Jeffries. Mr. Cicilline.
Aye.
Mr. Cicilline votes aye. Mr. Swalwell. Mr. Liu.
Aye.
Mr. Liu votes aye. Mr. Raskin.
Aye.
Mr. Raskin votes aye. Ms. Jayapal. Ms. Demmings. Mr. Correa.
Aye.
Mr. Correa votes aye. Ms. Scanlon.
Aye.
Ms. Scanlon votes aye. Ms. Garcia.
Aye.
Ms. Garcia votes aye. Mr. Neguse.
Aye.
Mr. Neguse votes aye. Ms. McBath. Ms. McBath votes aye. Mr. Stanton.
Aye.
Mr. Stanton votes aye. Ms. Dean.
Aye.
Ms. Dean votes aye. Ms. Escobar. Mr. Jones. Ms. Ross.
Ross votes aye.
Ms. Ross votes aye. Ms. Bush.
Bush votes aye.
Ms. Bush votes aye. Mr. Jordan. Mr. Jordan votes no. Mr. Shabbat. Mr. Shabbat votes no. Mr. Gomert.
No.
Mr. Gomert votes no. Mr. Issa.
No.
Mr. Issa votes no. Mr. Buck.
No.
Mr. Buck votes no. Mr. Gates. Mr. Johnson of Louisiana. Mr. Johnson of Louisiana votes no. Mr. Biggs.
No.
Mr. Biggs votes no. Mr. McClintock. Mr. McClintock votes no. Mr. Stubbe.
No.
Mr. Stubbe votes no. Mr. Tiffany. Mr. Massey. Mr. Massey votes no. Mr. Roy. Mr. Bishop.
No.
Mr. Bishop votes no. Ms. Fishbach.
No.
Ms. Fishbach votes no. Ms. Sparts.
No.
Ms. Sparts votes no. Mr. Fitzgerald.
No.
Mr. Fitzgerald votes no. Mr. Benz. Mr. Benz votes no. Mr. Owens.
No.
Mr. Owens votes no.
How is Swalwell recorded?
Mr. Swalwell, you are not recorded.
Aye.
Mr. Swalwell votes aye.
How is Escobar recorded?
Ms. Escobar, you are not recorded.
Aye.
Ms. Escobar votes aye.
Has every member voted who wishes to vote? Clerk will report.
Mr. Chairman, there are 19 ayes and 16 noes.
The ayes have it. The resolution is amended as ordered, reported unfavorably to the House. Members will have 2 days to submit views. Without objection, the resolution will be reported as a single amendment in nature of a substitute incorporating all adopted amendments, and staff is authorized to make technical and conforming changes. Pursuant to notice, I now call up H.Res. 1250, a resolution of inquiry directing the Secretary of Homeland Security to transmit certain documents to the House of Representatives relating to the impact of illegal immigration on federal or tribal lands for purposes of markup, and move that the committee report the resolution unfavorably to the House. The clerk will report the resolution.
H.Res. 1250 of inquiry directing the
Without objection, the resolution is considered as read and open for amendment at any point. I will begin by recognizing myself for an opening statement. H.Res. 1250, introduced by Representative Blakemore, is a carbon copy of H.Res. 1249, except that it directs the Secretary of Homeland Security rather than the Secretary of the Interior to transmit to the House of Representatives certain documents relating to the impact of unauthorized immigration on federal or tribal lands. Instead of taking up any more of the committee's time on this, I would simply note that I oppose the resolution for the same reasons discussed in my previous opening statement, and I urge all members to report it unfavorably. I now recognize the gentleman from Texas, Mr. Gomer, for an opening statement.
Thank you, Mr. Chairman. This resolution of inquiry directs the Secretary of Homeland Security to provide Congress with information related to the effect of illegal immigration on our environment, how drug cartels are trafficking narcotics on federal and tribal lands. Drug Enforcement Administration has assessed that Mexican drug traffickers remain the most serious drug trafficking threat in America as they continue to control smuggling pathways primarily across the southwest border. These Mexican drug cartel traffickers are also the main supplier of most illicit drugs available on reservations throughout tribal lands. This is made possible by the fact that Mexican drug traffickers take advantage of the Biden administration's weak border policies to not only illegally cross the border, but also traffic poisonous, illicit drugs like fentanyl. The Biden administration's border insecurity threatens every American community. Border Patrol agents are taken away from their jobs of protecting the border and preventing drug trafficking and are forced to process aliens who cross the border illegally. Meanwhile, our country's drug crisis continues to spiral out of control. So far in fiscal year 2020, U.S. Customs and Border Protection has seized over 500,000 pounds of illicit drugs. These drug seizures include fentanyl, heroin, cocaine, methamphetamine, and marijuana. On August 30th, 2022, the DEA warned the public of a new trend of rainbow fentanyl targeting children and young people. The DEA and its law enforcement partners, quote, seized brightly colored fentanyl and fentanyl pills in 18 states, unquote, and stated, quote, this trend appears to be a new method used by drug cartels to sell highly addictive, potentially deadly fentanyl made to look like candy to children and young people. Meanwhile, our country's drug crisis continues to spiral out of control also. According to data from the Center for Disease Control and Prevention, 93,655 fatal drug overdoses occurred in 2020, a nearly 30% increase over the prior year. In 2021, fatal drug overdoses increased to over 107,622 deaths, which represents a life lost every 5 minutes on average. Of those deaths, 71,238 were attributed to synthetic opioids, primarily illicit fentanyl. The requests for information in this ROI to the Department of Homeland Security are identical to those in the ROI to the Department of Interior. Importantly, the documents at both of these agencies are necessary to fully understand the devastating effects of the Biden administration's open border agenda. I urge support for this resolution and yield back.
Gentleman yields back. Without objection, all other opening statements will be included in the record. Are there any other? Oh, I now recognize myself for purposes of offering an amendment in the nature of a substitute. The clerk will report the amendment.
Amendment in the nature of a substitute to H.Res. 1250.
Without objection, the amendment in the nature of a substitute will be considered as read and shall be considered as base text for purposes of amendment. I recognize myself to explain the amendment. This amendment in the nature of a substitute makes a single technical change to the resolution of inquiry by spelling the number 14 instead of using the actual number. No other changes are made to the resolution of inquiry. I urge all members to support the amendment, and I yield back the balance of my time. Are there any amendments to the amendment in nature of a substitute? For what purpose does Mr. Benz seek recognition?
Strike the last word, Mr. Chair.
Gentleman is recognized.
Thank you, Mr. Chair. And this will sound familiar since I just made this point concerning the last bill, but it's equally applicable here. And that is that the number of endangered and threatened Canada species like to be affected by the folks coming across the border, the million plus this year unapprehended, that type of impact absolutely should be taken into account and reported upon by the Department of Homeland Security. I should point out, and I didn't in my last set of remarks, that I've been to the border 3 times, and I've looked with the members of the Natural Resource Committee at the damage done by people entering and then tromping across grasses and through groves of trees, leaving garbage strewn here and there, and then goodness knows what sort of damage to the flora and fauna of the space. Why it's being ignored now by the environmental organizations that were so anxious to bring the possible danger to the environment that might come from the so-called Trump border wall. Why were they so anxious there? And yet here, the same 5 pages of endangered species are at risk, and we hear nothing, a deafening silence. It's another example, I think, of the double standard that's applied when it comes to folks that enjoy the positive view of our press and those that do not. I just want to mention that and again, I failed to mention the fact that the species with critical habitat along the border, not just where the wall might be, include such things as the San Bernardino spring snail, the Quino checker spot butterfly, the northern Mexican garter snake, the Mexican spotted owl, which brings me to a point. The spotted owl obviously is hugely important in Oregon, and in fact is responsible for shutting down the entire timber industry in Oregon, costing us hundreds of thousands of jobs and goodness knows how many lives ruined, driven to the very fentanyl that we're now hearing about coming across the border. It seems to me that we should be taking into account each and every one of these types of impacts. We're not, and why is beyond me. The approach that I used earlier, asking this be added to the record, I renew for this purpose, Mr. Chair. Please add this to the record, this 5 pages.
Without objection.
Thank you. And with that, I just want to mention, if the Bureau of Land Management was applying the same standards to people tromping across the desert that they apply in some of my district's uses of public land, this would have been stopped long ago, this kind of damage. And what I'm saying is, if you have the obligation to manage public land appropriately, you must submit to oversight by the Bureau of Land Management. Why wouldn't we be applying the same kind of standards to the type of impact these millions of people are having as they tromp across our federal lands? Doesn't make any sense, Mr. Chair. That I yield back.
Gentleman yields back. Who seeks recognition? In that case, the question occurs on the amendment nature of a substitute. All in favor say aye. Aye. Opposed, no. In the opinion of the chair, the ayes have it, and the amendment is, the opinion of the chair, the ayes have it, the amendment nature of a substitute is agreed to. Reporting quorum being present, the question is on the motion to report the resolution H.Res. 1250 as amended unfavorably to the House. Those in favor respond by saying aye. Aye. Opposed, no. No. The ayes have it. Recorded vote is requested. The clerk will call the roll.
Mr. Nadler.
Aye.
Mr. Nadler votes aye. Ms. Lofgren. Ms. Lofgren votes aye. Ms. Jackson-Lee. Ms. Jackson-Lee. Mr. Cohen. Mr. Johnson of Georgia.
How did the chairman vote?
Aye.
I vote aye.
Mr. Johnson of Georgia votes aye. Mr. Deutsch. Ms. Bass.
Bass votes aye.
Ms. Bass votes aye. Mr. Jeffries. Mr. Cicilline?
Aye.
Mr. Cicilline votes aye. Mr. Swalwell?
Aye.
Mr. Swalwell votes aye. Mr. Liu? Mr. Raskin? Ms. Jayapal? Ms. Dimmings?
Aye.
Ms. Dimmings votes aye. Mr. Correa?
Aye.
Mr. Correa votes aye. Ms. Scanlon?
Aye.
Ms. Scanlon votes aye. Ms. Garcia?
Aye.
Ms. Garcia votes aye. Mr. Neguse?
Aye.
Mr. Neguse votes aye. Ms. McBath?
Aye.
Ms. McBath votes aye. Mr. Stanton?
Aye.
Mr. Stanton votes aye. Ms. Dean?
Aye.
Ms. Dean votes aye. Ms. Escobar?
Aye.
Ms. Escobar votes aye. Mr. Jones? Ms. Ross?
Ross votes aye.
Ms. Ross votes aye. Ms. Bush?
Bush votes aye.
Ms. Bush votes
I'm
aye.
unrecorded.
Mr. Jordan?
I'm unrecorded.
Mr. Shabbat?
See, it's two different groups. Now they're not.
Mr. Shabbat votes no. Mr. Gomert?
No.
Mr. Gomert votes no. Mr. Issa?
No.
Mr. Issa votes no. Mr. Buck?
No.
Mr. Buck votes no. Mr. Gates? Mr. Johnson of Louisiana? Mr. Johnson of Louisiana votes no. Mr. Biggs?
No.
Mr. Biggs votes no. Mr. McClintock? Mr. McClintock votes no. Mr. Stubbe?
It ain't his words.
No.
Mr. Stubbe votes no. Mr. Tiffany?
No.
Mr. Tiffany votes no. Mr. Massey? Mr. Massey votes no. Mr. Roy? Mr. Bishop?
No.
Mr. Bishop votes no. Ms. Fishbach?
No.
Ms. Fishbach votes no. Ms. Sparts?
No.
Ms. Sparts votes no. Mr. Fitzgerald?
No.
Mr. Fitzgerald votes no. Mr. Benz? Mr. Benz votes no. Mr. Owens?
No.
Mr. Owens votes no.
How am I recorded?
Mr. Jordan? Mr. Jordan votes no.
Mr. Jeffries?
Mr. Jeffries votes yes.
Mr. Jeffries votes yes.
How am I recorded?
Ms. Jackson Lee, you are not recorded.
Yes.
Ms. Jackson Lee votes yes.
Mr. Deutsch?
Aye.
Mr. Deutsch votes aye.
Has every member voted who wishes to vote? Clerk will report. Hold on. Mr. Liu? Mr. Liu? Mr. Liu, you have to put your microphone on. Mr. Liu, we can't hear you. All right. The clerk will report.
Mr. Chairman, there are 20 ayes and 17 noes.
The ayes have it, and the resolution is amended as ordered reported unfavorably to the House. Members will have 2 days to submit views. Without objection, the resolution will be reported as a single amendment in nature of a substitute incorporating all adopted amendments, and staff is authorized to make technical and conforming changes. This concludes our business for today. Thanks to all our members for attending. Without objection, the markup is adjourned.